Sure.
Okay, you can let Dexter know. Okay,
Dexter.
What's the phone?
We are going to do the Creole interpreter first.
I'm
We have that
sorry,
availability.
407 973 1183. Okay, thank you. Okay, bye-bye.
Is that Jimmy?
Mano,
Oh.
no, right in front of
Okay. Yep, got it. Lano Jean?
Yes.
Yep, got it.
Good morning.
Speak Creole or English?
English.
Speak English?
No, sir.
Oh, okay.
I can comprehend.
Twenty CF 7669.
This must be in a park. Huh? Why not park? Okay, Judge.
Sit down. Hey.
Good morning. Are you there?
Yes, I am. Hi, good morning.
Hi, good morning, ma'am. I'm going to go ahead and call the case. This is case number 20 CF 7669. Sir, good morning. Tell me your name, please.
Monsieur, qui j'en relais?
You got to speak Creole now.
Speak Creole?
Yeah.
Lano Jesse
Allô,
Jean.
monsieur, qui j'en relais?
Lano Jesse Jean.
Lano Jesse Jean.
Oui.
Sir, you were arrested for burglary of a conveyance and petty theft.
Ou t'es arrêté, monsieur, parce que ou t'es volé un petit bagay ici?
This was pursuant to a warrant.
I'm sorry, the interpreter did not get that. It's kind of muffled.
Sorry about that. We were wearing masks, so sometimes it's a little difficult to hear.
Oh, sorry, yes, I figured.
No problem. He was arrested for burglary of a conveyance and petty theft pursuant to a warrant.
OK. OK, donc, monsieur, ou t'es arrêté et parce que ou t'es cassé un caille, ou t'es volé un bagay là-dedans, et ou t'es gagné un mandat d'arrêt contre vous-même?
He is not to have any contact with the victim
Ou pas capable de gagner un contact avec victime là?
or return to the scene.
Ou bien retourner côté bagay là t'es fait?
Bond will be set at $2,500.
Ou bien on bond $2,500
On count one, and count two will be $100.
pour premier chef accusation et pour deuxième chef accusation, bond là à $100.
I am revoking the bonds or the releases in the out on bond cases,
Il m'a retiré bond que vous avez gagné dans le cas que vous avez gagné en sorti sous bond,
except for 20 MM 378. I'm not going to take any action on that case, but on all the felony matters.
à part pour 20 mm 2070, pas pour aucune action sur ça.
Those bonds are going to be set at none.
Tous les deux bonds pour le mettre sous pas gain bond.
Mr. Jean, I will let the judges in those divisions know that you're here so that you can get in front of them to have a hearing regarding your conditional releases.
Il m'a quitté juge dans le cas ça yo connaît que ou là dans prison pour ou capable gagner une audience sous et quelle qualité de relation gagner.
Thank you, sir.
Your
Merci,
Honor,
monsieur.
about the bond, you said that the one that wasn't revoked was 378 or
The misdemeanor.
The misdemeanor. Okay,
Yes.
that's what I thought.
Thank you, Madam Interpreter. That's all we have.
Oh, thank you. Have a good day.
You too. Bye-bye.
You want me to call her back?
You guys, I made a mistake on Mr. Jean's case on the warrant. I thought I had checked it, the date on the warrant, but I missed it. So the offense date is January 2nd of 2020. So I'm not revoking in 20 CF 3006 or 19 CF 14408, but I will be revoking in 19 CF 9294. And then they can address all the cases in the felony division if they need to make any modifications to the conditional releases. All right, let me call this man.
Good morning, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has not been sworn yet, Your Honor.
All right, good morning. Arlene, could you swear him in, please?
Yes. Do you swear to translate from Spanish to English, English to Spanish, the testimonies you will receive today?
Yes, I do. Your Honor, the interpreter would like to inquire which jail courtroom, which location of the jail is the defendant in.
Yes, sir, courtroom 2.
One moment, please. Connected, Your Honor. However, the interpreter would like the staff from the jail to maybe get the microphones on the table a little closer because the microphones on the headphones normally don't work very well.
Sure, no problem.
Thank you.
¿Me escucha?
Muy-
Okay.
Okay, loud and clear, Your Honor.
Great, okay. This is 20MM5697. Sir, please tell me your name.
Señor, este es el caso 20M5697. Si me da su nombre, por favor.
Kevin. Laguel.
Kevin Laguel.
Sir, you were arrested for battery, domestic violence. There is probable cause. I will appoint the public defender to represent you. You are not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or any firearms, sir. Can Mr. Laguerre be placed on pretrial release?
Yes, Your Honor.
Sir, I'm going to place you on pretrial release at this time. Do you have any questions about the no contact order?
Disculpa. No tengo ninguna pregunta.
No, I do not have any questions.
All right, sir, thank you.
Para. ¿Te paso una pregunta?
May I ask a question?
Yes, sir.
¿Qué pasará después de todo esto? No.
And what's going to happen after all this?
I don't know, sir. You'll have to talk to your lawyer about that, okay? They can explain the process to you.
Ok.
Okay. Thank you. Sir, good morning. Tell me your name, please.
Jorge Luis Maldonado.
Jorge Luis Maldonado.
This is case number 20MM5691. Sir, you were arrested for battery domestic violence. There is probable cause. I will appoint the public defender to represent you. You are not to have any contact with the victims. You are to maintain a separate residence. You are not to possess any weapons or firearms. If you do need a one-time return with law enforcement to get your things, you may do so. Do you have any questions about the no contact order, sir?
Sí, porque ella va a ir para casa de la hija, que ella vive, ella tiene familia aquí, so ella va a ir por la hija. So, yo voy a mi casa.
Yes, she's got relatives here, so she's going to go to her daughter's house.
Okay, that's fine. If she's not staying at the house, then you're allowed to be there.
Ok, perfecto.
And I
Okay,
can,
perfect.
and then I can place Mr.
Yes, Your
Maldonado. Okay, Mr. Maldonado, I'm going to place you on pretrial release at this time, sir. Thank you.
Thank you so much.
Good morning. Your name, ma'am?
Ivonne Mari Pérez Acevedo.
Yvonne Mari Perez Acevedo.
Ma'am, this is 20 CF 9368. You were arrested for fraudulent use of personal identification information, 3 counts. Fraudulent use of credit cards greater than $100, 3 counts. Attempted fraudulent use of a credit card and theft of a credit card. There's probable cause, ma'am, for the offenses. I'm going to appoint the public defender to represent you. You're not to return to the Walmart. And you're not to have any contact with the victim. Bond on count 1 is $1,000. Bond on 2, 3, 4, 5 is $150. Oh, and bond on count 6 is $150, 7, $100, 8, $100. What was there?
¿Cuánto sería el total de la?
Oh, and then the 2
What would the
additional.
total be?
Just a minute, ma'am. There's 2 additional counts for the 3 credit cards on the second page, and bonds on those will be $100 as well. Approximately 3,000, ma'am. You can add up the amounts on your affidavit, the amounts that remain the same.
No entiendo. La cantidad.
I do not understand.
La
Your
cantidad
bond amounts are the same as they are on the police report, ma'am. Thank you.
de los 2,150, los 2,250.
Or 2,150?
Ma'am, I don't know the total amount. I didn't add it up. You'll have to add it up on the affidavit.
Okay,
Thank you.
Okay,
gracias.
thank you.
Sir, good morning. Your name?
Jesus Rodriguez Navarro.
You were arrested in 20 CF 9383 for possession of cocaine and resisting officer without violence. There is probable cause. I will appoint the public defender to represent you. You're not to possess or consume any controlled substances without a valid prescription, sir, and I'm going to place you on pretrial release at this time. Thank
For
you.
both cases, Your Honor?
What?
Both cases.
Oh, I didn't see that. Oh, the no valid? That can go on there too. Thank you.
And Your Honor, may the state have the case number for the no valid, please?
Sure. 20 CT 4764.
Any conditions for that?
For the driving case? Not to drive without a valid driver's license. Thank you.
Your Honor, Christoria Smith is medical.
Okay. Do you anticipate her coming out of medical anytime soon?
She's been medical since she came in on Saturday, Your Honor.
Right. So I was trying to wonder why she got reset for today.
Judge Shoemaker just reset her for Wednesday.
I see, okay. So that date was preset. Well, I'll appoint the Public Defender's Office to represent Ms. Smith. Mr. Matos, did you want to waive her appearance?
Yes, Your Honor.
All right. She was arrested in 20 CF 9169 for attempted second-degree murder with a weapon. There is probable cause. I've appointed the public defender. Ms. Bush, did you want to be heard with respect to bond?
Yes, Your Honor. The state would ask the court to take into consideration the facts that are contained within the sworn arrest affidavit. And in those facts, the state would ask the court to find that because the witness victim is familiar with Ms. Smith, that the court find that proof is evident or presumption is great that Christoria Smith is the person so identified in the affidavit. The state would also ask the court to take into consideration that while there are no convictions, there are several violent crime arrests, aggravated battery ×2, battery domestic violence as well. And the state does not know the outcome of those cases or if they're currently pending. But the state would ask the court to hold her at no bond for the safety of the community and the safety of the victim.
Okay, thank you. Mr. Matos?
Your Honor, at this point, we just like to reserve it for a downtown hearing, and we do not have any arguments against we just like to reserve.
So at this time, the state has met their burden to establish that there is proof evident or presumption great based upon the information contained within the sworn affidavit for arrest, including the admissions of Ms. Smith. So bond will remain at none. I will not exercise discretion in setting a bond. She's not to have any contact with the victim or any witnesses. She's not to return to the scene, and she's not to possess any weapons or firearms.
Your Honor, this is the interpreter, just making sure that the interpreter can disconnect.
Oh my gosh, I'm so sorry. Yes, sir, you are. I apologize.
No problem, Your Honor.
Thank you.
You're very welcome.
He was so patient.
That was the last one.
Good morning, your name?
Jason Watkins.
Mr. Watkins, you are here on a writ of attachment. It's DR 1514886, sir. You are going to be released on your own recognizance as to this case only. You're
Okay.
going to be given a court date of August 31st at 11 a.m. You'll get the paperwork, so you'll be able to see the instructions for the call-in. You have to call in for the hearing. You won't appear in person at the courthouse. You have to call in.
Okay.
Make sure you do that. Otherwise, there'll be a warrant issued for your arrest, but you'll get a copy of the order upon your release.
Yes, ma'am.
All right. Thank you, sir.
Thank you.
Good morning, sir. Your name?
Robert Allen.
Oh, wow.
Mr. Allen, you were here in 20 CF 9389. You were arrested for tampering with a witness to hinder communication to law enforcement, battery, and assault. There is probable cause. I will appoint the public defender to represent you. You are not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or firearms. If you need to return one time to the residence to get your things, you may do so. Sir, do you have any questions about the no contact order?
No, ma'am.
All right, sir. Bond on count 1 is going to be $1,000. Bond on count 2 will be 100. Bond on count 3 will be 100. Thank you, Mr. Allen.
Thank you.
Good morning, your name?
Good morning.
Tell me your name.
Jose Ibarra.
Mr. Ibarra, this is 20 CF 9297. You were arrested for battery by strangulation, dating violence. This was pursuant to a warrant. I'll appoint the public defender to represent you. You are not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or firearms. You're also not to possess or consume any alcohol or controlled substances without a valid prescription.
Okay.
Bond is going to be $1,000. I'm revoking your Osceola County cases. Those bonds are going to be set at none, sir.
They're gonna be set at what?
None.
Oh, is there any way to get those reinstated?
Yes, you will need to have your lawyer file a bond motion with the judge that's handling those cases.
What's this number? Okay. And is there any possible way not to get those revoked? Like, cause I truly feel like because I want to get a lawyer and everything for everything that's
You
going on.
absolutely can get a lawyer. My problem, though,
Yeah, cause
sir, is that, no, listen to me. You asked me a question. My problem is that you were just arrested for DUI in June, right? And then you were just arrested last night for this crime, and it's alleged in the affidavit that you were drunk. I don't know if that's true or not true, but I have some concerns. I have some concerns about that, so your lawyer will have to file a motion and make argument for you. Okay?
then
Thank
there's-
you.
Okay.
Good morning, your name?
Marshall Knight.
Mr. Knight, this is 20 CF 9372. You were arrested for aggravated battery on a pregnant person.
Yes, ma'am.
There is probable cause. I am going to appoint the public defender to represent you. You are not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or firearms, sir. You may return to the residence if you need to with law enforcement one time to get your things. And I'm going to place you on pretrial release at this time, sir. Do you have a question, Mr. Knight?
What does that mean, ma'am? I'm sorry, I really don't know what that means.
That's okay. So you're going to be placed on pretrial release. They're going to monitor you in the case while it's, waiting to go through the court system. You won't have to post a monetary bond to be released today. You'll have to check in with pretrial release as you're waiting for your case to go to court.
So I'm released today, ma'am?
Yes, sir.
Yes, ma'am. Thank you.
You're welcome.
Okay, that's fine.
Good morning. Your name?
Paul Pritchett.
Mr. Pritchett, you have two cases this morning. I will appoint the public defender to represent you in both. You have 20 CF 5154. You were arrested pursuant to a warrant for tampering with a witness to hinder communication to law enforcement and aggravated battery. You were also arrested in 20 CF 5601 pursuant to a warrant for burglary of a conveyance with an assault or battery, aggravated assault, battery, criminal mischief, and battery. Ms. Bush, did you want to be heard with respect to bond as to count 1 in 20 CF 5601?
Yes, Your Honor, if I may have just a moment. Your Honor, the state would ask the court to take into consideration the facts in 2020 CF 5601, the facts that are contained within the affidavit to issue the arrest warrant. It is a sworn document, and that sworn document contains facts provided by the victim in this matter, the victim who is the ex-girlfriend of Mr. Pritchett, and also the mother of his child. And in those facts, she identifies Mr. Pritchett as the person that did batter her, did commit that battery by entering her vehicle without her permission. The state would ask the court to find that proof is evident or presumption is great that Mr. Pritchett is the person so identified, and hold him at no bond as to burglary of a conveyance with an assault or battery therein. He is entitled to bond on the remaining charges in that matter. And he is entitled to bond in 2020 CF 5154 AO.
Mr. Matos?
Yes, Your Honor. We would like to reserve for the burglary with a battery charge for an author here in downtown. And as in for the felony battery, for the domestic battery, this is the repetition of the one continuous episode of the burglary with a battery. Would ask our client be ROR for lack of probable cause.
I don't think that there is proof evident or presumption great as to count one based upon the information contained in the sworn probable cause arrest affidavit. So I'm going to set a bond for Mr. Pritchett. Bond on count one is going to be $50,000. Bond on count two will be $2,500. Bond on count three is $500. Bond on count four is $100. Bond on count five is $500. And then bond on 20 CF 5154 on count one will be $1,000. Bond on count two will be $2,500. Mr. Pritchett, the victim is the same alleged in each case. You are not to have any contact with that person. You are not to return to the scene. You are to maintain a separate residence, and you're not to possess any weapons or firearms, sir. Do you understand?
Yes, ma'am.
Do you have any questions at all about the no contact order?
No, ma'am. Yes. With the no contact order, how would it work out with our child?
So the no contact order applies to your child as well. So until that order is modified by a court in writing, you are not to have any contact with the child either.
But the
You'll
child
have
is
to have your lawyer file a motion, sir, and have the trial court address that issue.
the child is with me.
Where?
At my mother's. Yes, ma'am. That's why I was asking. The way we have it worked out now is we would go through my mother. She would call my mother and get my daughter, and I haven't talked to her since April. I haven't spoken with her or anything.
Okay.
So I'm asking.
So you live with your mom and your daughter?
Yes, ma'am.
Okay.
She don't come to the residence. My mom would call her. When she wants the child, she would call my mom, and my mom would meet her somewhere at like a McDonald's or something and drop her off.
Okay. Ms. Bush?
Yes, Your Honor. Not addressing that issue, but the state would also ask for a no contact order for any witnesses. In 5601, there are witnesses as well.
Okay. So I will add that to the orders, sir, that you're not to have any contact with any potential witnesses in the case or any of the witnesses listed in the affidavits as better stated. So I looked at the dates on the affidavits. One of the offenses is alleged in April and one of the offenses is alleged to have happened in May.
But
So,
they're the
Mr.
same
Pritchett-
incidences.
Well, Mr. Pritchett, hold on. Just hold on a second. So I'm just trying to figure out the arrangement you're talking about in terms of your child has been the arrangement since April?
Yes, ma'am. It's the same. The two cases, that's what I'm not understanding. One is
Well,
saying,
listen, your lawyer's gonna have to talk to you about the cases, okay? Because I can't talk to you, I can't give you any legal advice about that, so you gotta talk to your lawyer, okay?
yes, ma'am.
All right. Well, I'm gonna put, Ms. Bush, go ahead.
Your Honor, from the sounds of what Mr. Pritchett is saying, it doesn't seem that there would be any problem with the no contact order with the victim. He says that his mother is the one that makes contact with regard to the child and solely with regard to the child, so he would not be having contact with her.
Right, but my concern was
That the
okay, I think that will work because the way that the no contact order is written, it says it's all about the victim, and then when it talks about the children, it says even if it involves contact with your children or legal matters, you may not communicate with the victims or have anyone else communicate with the victims.
Yes, Your Honor.
You must set a hearing with the court to determine whether contact with the children will be allowed.
And from the sounds of it, Mr. Pritchett actually has the custody of his child, and
Right.
his wife only, or his ex only, gets the child from time to time.
It just also says, nor have anyone else communicate with the victims. That's the only part that gives me a pause.
If the court would just put outside of something to do with there can be contact strictly for
Okay.
child visitation.
I'm gonna add that Mr. Here, can I spell it? I'll just write it.
Do you think that was your PC? Do you think you have any more?
Okay. So, Mr. Pritchett, I put in the order that your mother may contact the victim regarding contact with the child, and then that you testified that the child is in your custody, sir. So that shouldn't cause you any problems, okay?
Yes, ma'am.
All right. Thank you, sir.
No problem.
Thank you.
Oh, 5154?
On 5601.
5601. Okay.
Okay. Sir, good morning. Your name?
Good morning. My name is Gabriel Reyes.
Mr. Reyes, this is 20 CF 9357. You were arrested for battery by strangulation, domestic violence. There is probable cause. I'm going to appoint the public defender to represent you. You're not to have any contact with the victim. You are to maintain a separate residence. You may return one time with law enforcement to get your things if necessary. And you're not to possess any weapons or firearms, sir. I'm going to place you on pretrial release at this time. Did you have any questions about the no contact order, sir?
No, ma'am.
Okay, thank you.
Thank you.
Sir, good morning. Your name?
Good morning, Your Honor. Ma'am. Modesto Rodriguez.
Mr. Rodriguez, this is 20 CF 9390. You are arrested for burglary of a dwelling and battery domestic violence. There is probable cause. I'm going to appoint the public defender to represent you.
Okay.
You are not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or firearms. I'm going to place you on pretrial release at this time, sir. Do you have any questions, Mr. Rodriguez?
No.
No?
No question.
All right.
Gabriel Reyes. They can just go up. I don't know if you want to call him up.
Sure. Officer Williams, we're going to have to bring Mr. Reyes back. His victim is now present. Good morning, ma'am.
Good morning.
Could you tell me your name, please?
Nicole Martinez.
All right, Ms. Martinez, could you please raise your right hand to be sworn in?
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right, I'm just waiting for them to bring Mr. Reyes back into the courtroom, and then we can proceed, okay?
Thank you. I really appreciate it.
No problem, ma'am. I understand. Life is sometimes difficult, so I totally get it.
Thank you.
Hello?
Yes, Mr. Reyes. Ms. Martinez has showed up in court, and I'm going to ask her a couple questions, and I wanted you to be present for that.
Okay.
Ms. Martinez, did you want to have contact with Mr. Reyes?
No.
Thank you. I saw something in your hand. Was there something else you wanted to share with the court?
This was the paper they gave me downstairs at intake.
Oh, okay. I didn't know if you had written something down.
I haven't written anything down, but I would like to share something with the court.
Sure, go ahead.
I'm afraid for my life right now. I have 2 small children with him, and I have a 9-year-old who witnessed this act. My 9-year-old told me she felt like he looked like a boxer, and he was beating me like I was a man. No child should ever see that. Last month, he pushed me in front of the children. The police were called. DCF was involved. They had an open case. They found I was the victim. They gave me 4C. I have my children in a wonderful Christian private academy right now because of the help from the state. And I allowed him yesterday to come back in the home under the guise that he would help me with the kids, and he wanted to be here for his children, and I wanted nothing more than for my children to have 2 healthy, functioning parents. And I allowed that, and he snapped on me again. He strangled me. I could not breathe. I broke free. I was pushing him out the door. Please leave. Please, please just leave. He turned around and he proceeded to punch me until I was down on the ground and seeing stars. I was on the verge of going unconscious. I have lumps in the back of my head. And once again, please, my children saw this. I'm afraid for my life. He's told me he will kill me. He's a very dangerous person. He has a drug problem. All of his priors are for cocaine possession. And I know for a fact he's still doing that on in the background. And with, I found pills, Xanax bars in his car a couple days ago.
Okay. Thank you. I didn't mean to cut you off, Ms. Martinez. I'm sorry.
It's a dangerous situation. Please, I need help.
Oh, I hear you, Ms. Martinez. Did the state have any questions for the witness?
I just have one question.
Yes, ma'am.
You said that DCF has been involved in the past. Has there been violence in your relationship prior to this incident?
We've been together 3 years. The first year it was perfect, but for the last 2 years I've been terrorized by this man.
And
yes, there has been prior violence that I have not reported. violence that has been reported. I've just recently started to report it because I cannot live like this. I cannot show my children this.
Thank you.
Thank you.
Mr. Matos, did you have any questions for the witness?
No, Your Honor.
Okay. So based upon the testimony of Ms. Martinez, I'm going to modify Mr. Reyes's order to include no possession of any controlled substances without a valid prescription. And so you're going to be randomly tested through pretrial release.
Yes, ma'am.
Your Honor, the state would ask that he reports weekly.
Mr. Matos, did you want to be heard on that issue?
Your Honor, there's no argument against him reporting weekly.
I can't hear you, sir.
There's no argument against him reporting weekly.
Okay, so I'll also include that he's to report weekly. Ms. Martinez, I just want to give you a little bit of information because I hear what you're telling me. I don't know if you've already attempted to get an injunction, but you can absolutely get an injunction.
Yesterday I did. I'm sorry to interrupt you.
That's okay. Okay, good. So then you've already started that process, and they will know where he is to be able to get that served. Ma'am, I ordered that he's not to have any contact with you whatsoever. He's to maintain a separate residence, not to return to the scene, not to possess any weapons or firearms. If he has things at your home, I believe, did I say one time return? He can return with the police one time to get his things, and that's only if the injunction hasn't been served.
Okay.
Okay, but he has to be with the police.
Right.
Okay? Otherwise, he's not to have any contact with you. If he does, you must call the police.
I will call the police, yes.
I don't know if DCF provided any other resources to you when they became involved. I don't know if you've spoken with anyone through Harbor House or anything in that way.
I have spoken with them. I pay rent at my home. It's a safe home other than what he's been causing there for my children. I don't want to uproot them. I don't want to take them to a shelter. I know by myself I can provide them the healthy, happy home that they deserve. When he's there, it is complete and utter hell.
Thank you, Ms. Martinez, and thank you for coming today.
Thank you.
All right. Thank you, Mr. Reyes.
Thank you.
Ma'am, good morning. Your name?
Melissa Slingerland.
Ma'am, this is 20 CF 9341. You were arrested for possession of cocaine and battery domestic violence. There is probable cause. I will appoint the public defender to represent you. You are not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or firearms, ma'am. Do you have any questions about the no contact order?
No.
You're also not to possess or consume any controlled substances without a valid prescription. Bond on count 1 is going to be $500. Bond on count 2 will be $100. Thank you, ma'am.
Hello, good morning, Your Honor.
Good morning, sir. Tell me your name, please.
Charles Turner.
Mr. Turner, sir, you are here in case number 20 CF 9391. You were arrested for aggravated assault, battery, dating violence, battery, and criminal mischief. And there is probable cause. I will appoint the public defender to represent you. You are not to have any contact with the victims, sir. You are to maintain a separate residence. You are not to possess any weapons or firearms. Mr. Turner, it appears that you're here on vacation. Is that correct?
Yes, Your Honor.
Do you live in Pennsylvania?
Yes.
Okay. So I'm going to place you on pretrial release. You're going to have to call in to pretrial release while you're waiting for the state of Florida to file charges in this case.
Okay.
And the public defender's also been appointed to represent you, so you'll need to stay in contact with their office as well. If you fail to appear for court in Florida, a warrant will be issued for your arrest, and it is a nationwide warrant. Do you understand?
Yes, Your Honor.
Okay. Do you have any questions for me, Mr. Turner?
No, ma'am.
Okay. Thank you.
Thank you. Have a good one.
You too. Good morning. Your name?
Eric Bretz.
Mr. Bretz, this is case number 20MM5702. You were arrested for battery domestic violence. There's probable cause. I'll appoint the public defender to represent you. You are not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or firearms. If you need a one-time return to the house to get your things with the police, you may do so. You are not to possess any weapons or firearms. Do you have any questions about the no contact order?
Your Honor, can I ask a question? The residence is mine. I'm a disabled veteran on HUD-VASH. And
Okay.
the residence, my wife filed an injunction yesterday against my sister because I'm on HUD-VASH and she's taking over my residence. Not supposed to be. I'm on tons and tons of medications.
Right, so I understand your question, and so let me just explain this to you. If the victim is not there, if Ms. Hester is not there, then you're allowed to be there.
Okay,
Okay?
perfect.
All right, sir, thank you.
Thank you.
Did I say a pretrial release? Okay.
Pre-trial release.
Yeah, I thought I said that. Mr. Bretz, I told you you're on pretrial release, correct?
I guess so. Then I could.
Well, I thought I did, but you are.
Otherwise, I'm just able to leave.
Sorry. It's okay. Good morning, your name, sir?
Good morning. How are you?
I'm well, sir. Are you Mr. Buckley?
Yes, ma'am.
Mr. Buckley, this is 20 MM 5662. You were arrested for battery. There is probable cause. I'm going to appoint the public defender to represent you. Ma'am, good morning.
Good morning.
Tell me your name.
Queen Roseberry.
What is it?
Queen Roseberry.
Roseberry?
Yes.
Okay. Ma'am, could you please raise your right hand to be sworn in?
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yeah.
Miss Roseberry, do you want to have contact with your brother?
Yes.
Are you afraid of him?
No.
Do you guys live together?
Yes, but I will no longer be living there when he's released.
Okay. Will your child still be living there?
No, she'll be with me.
She'll be with you? Okay. Do you have any concerns about your safety or your daughter's safety if I were to allow contact between the two of you?
No.
Have there been instances of violence between you and your brother in the past?
Just regular brother and sister fighting.
Okay. But nothing physical, or has it been physical?
No.
No? No. Ms. Bush, did you have any questions?
I do, but it's strictly an administrative type question. Ma'am, would you spell your last name, please?
ROSEBERRY.
Thank you very much.
I'm sure
I
the
have
court
no further
reporter
questions, Your Honor.
Okay, Mr. Matos, did you have any questions?
No, Your Honor. Based on Ms. Roseberry's statements, I was just asked for a non-hostile contact order between the two brothers and sisters.
Okay. Mr. Buckley, I'm going to order that you're not to have any hostile contact with your sister. Do you understand what that means?
Yes, ma'am.
All right. You are to maintain a separate residence, and you're not to possess any weapons or any firearms.
I didn't hear you.
You are not to possess any weapons or firearms?
Yes, ma'am.
Okay. Your bond is going to be $500, sir.
Okay, thank you.
Thank you. Thank you, Mr. Berry. Good morning.
Good morning.
Your name?
Jasmine Casillas.
Ma'am, this is 20 MM 5696. You were arrested for battery domestic violence. There is probable cause. I'm going to appoint the public defender to represent you. You're not to have any contact with the victim. You're to maintain a separate residence. You are not to possess any weapons or firearms. Ma'am, do you have any questions about the no contact order?
No.
Okay. I'm going to place you on pretrial release at this time. Ma'am, good morning. Your name?
Michelle Fernandez, good morning.
Good morning, Ms. Fernandez. This is 20 MM 5692. You were arrested for violation of a domestic injunction. There's probable cause. I will appoint the public defender to represent you. You are to abide by the injunction in 20 DR 80670. And I'm going to place you on pretrial release at this time.
Okay.
Sure. 20 DR 80670. Thank you, Ms. Fernandez.
Is it okay if I ask one question?
Sure, go ahead.
My vehicle and possessions are still in the residence, which is why I had tried to go back in. Am I able to call police to have them escort?
No, you're not. You're going to have to file a motion with the judge that handled the injunction to see how it would be possible to do that. I can't enter an order that's in violation of that injunction.
Okay.
So that's the route you're going to have to take, is to either write that judge a letter or hire a lawyer and have them file a motion to
Okay.
assist you with that issue, okay?
Okay, okay, thank
All
you.
right. Thank you. Abide by the injunction. That's it. Good morning, your name?
Cody Faust.
Mr. Faust, you are here in 20 MM 5700. You were arrested for the battery domestic violence. There is probable cause. I'm going to appoint the public defender to represent you. You're not to have any contact with the victim. You're to maintain a separate residence. You may have a one-time return with law enforcement to get your things if needed. You're not to possess any weapons or firearms. Your bond is going to be $1,000, sir. I'm not going to take any action on the out-on-bond case at this time. Thank you. Ma'am, good morning. Your name?
Good morning, Tony Jones.
Ms. Jones, you are here in 20 MM 5695. You were arrested for battery domestic violence. There is probable cause, ma'am. I'm going to appoint the public defender to represent you. Just give me 1 second, Ms. Jones.
Judge,
Yeah.
when you get a chance, we need to go back to Faust. He had 2 charges. He had 2 cases. He had a battery DV and a DUI.
Thank you. By any chance, does anyone have the case number for Ms. Jones for the felony? I only have the, they only wrote the CT case number down on the out on
my
bond.
life. I promise to God I ain't do this.
CF 2019.
1-2. They know I'm out on bond, and that's why they doing this.
No, that, oh, that looked like a CT. It didn't make any sense.
I didn't do this.
All right, Ms. Jones, you're not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or firearms. You may return to the residence one time to get your things if needed. Bond will be $1,000, and then I'm going to revoke the bond in 19 CF 12168. That's going to be set at none, ma'am. Thank you.
Ma'am, I work from home, and the people, they know that. That's why they did this. I work from home.
Ms. Jones, I understand what you're trying to say to me, but that's something that you're going to have to raise as a defense at trial, and you'll have to talk to your lawyer about that, ma'am.
Okay.
All right? Thank you. I had to bring back Mr. Faust because apparently I missed a case.
We have a policy on it.
You missed the case?
Yeah.
Do we have it?
What was the other case that was not addressed?
You placed, the battery was $1,000, correct? Is that, he had, because he's here on a DUI, but the bondsman just came off the bond, so it was endorsed. But you don't have that one? Okay. But the $1,000 bond, was that for the battery?
Correct.
Okay. Never mind then, Judge.
And then, yeah, he doesn't have a bond on the DUI.
Okay, never mind.
That's revoked. Okay. Thank you, Mr. Faust. There was just an administrative issue that we needed to take care of. We're all set.
Thank you.
Thank you. Ma'am, good morning. Your name?
Look, hi, man.
Miss Mann, this is 20MM 5698. You were arrested for battery domestic violence. There's probable cause. I'm appointing a public defender to represent you. You are not to have any contact with the victim. You are to maintain a separate residence. You may return one time with law enforcement to get your things if needed. You are not to possess any weapons or firearms. Do you have any questions, ma'am, about the no contact order?
No, ma'am.
Okay. Your bond is going to be $1,000. Thank you.
Thank you.
Good morning. Are you Mr. Proctor?
Good morning.
Sir, this is 20MM 373. You were arrested for battery domestic violence. There is probable cause. I will appoint a public defender to represent you. You're not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or firearms, sir. If you need a one-time return with law enforcement to get your things, you may do so. Do you have any questions about the no contact order?
No, ma'am.
All right, sir. I'm going to place you on pretrial release at this time. Thank you. Good morning. Are you Mr. Wilson?
Yes, ma'am.
Sir, you are here in case number 20MM 5703. You are here because it is alleged that you violated a domestic injunction. There is probable cause. I'll appoint the public defender to represent you. Ma'am, good morning.
Good morning.
Could you tell me your name, please?
LaShonda Wilson.
Okay. It has you listed as LaShonda Curtis.
That's my
That's
maiden
you?
name.
Okay.
Yeah.
Could you raise your right hand to be sworn in, please?
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right. Miss Wilson, what would you like to tell the court?
Me getting arrested yesterday.
Can you just move a little closer to the mic
oh,
for me? It's just
sorry.
hard with the masks.
Can you hear me now?
I can. Yes,
Okay.
thank you.
Him being arrested yesterday, this was like the fourth or fifth time that he has been to the residence since he's been served.
Okay.
So it has been to the point that I had to buy a camera, and I'm supposed to be at work today as a teacher, and I couldn't even afford the camera that I bought, but I bought a camera
Right.
because he will not stay away from the residence.
Okay. So he was served on the 29th, is that right?
Yes.
So in the last week, that's 1 week ago from today, how many times has he been at the home?
He was there the day of the injunction from 4:30 until 9 o'clock. He would not leave. He came back the very next day to get his possessions, which was twice, the day of and then the day after. Saturday and Sunday, when I had the locks changed, I was out of town, and he got to the residence twice because he stopped the person mowing the grass and asked them who asked him to mow the grass. And that was on Saturday. I got back in town Sunday. He did not come Sunday. He did not come Monday. And he showed up yesterday. So it's just like, I could care less that I'm not supposed to be here. I'm going to be here.
I never even knew I wasn't allowed to be to the house. When the officer served me an injunction, I was at home. I stayed home 2 days. She was gone. I was there 2 days after the injunction. On my paper, it has check marks on it, what I should and should not do. The check marks on those say not around her. She wasn't home. All I was trying to do was get my things. The 2 times I did come back, by once I called the police myself, and they told me to sit in the driveway until they got there. I called them a couple times. It took like 2 hours for them to come, but they said that they come as priority because I called a non-emergency a couple times. I called 911 a couple times, like, hey, you guys say you guys are coming. You haven't showed up yet. I come one time with my father. The thing is, the only reason why I'm coming by, I came to get the last little bit of my stuff that was in the laundry room yesterday and inquiring about my dog because I have a friend that is willing to take the dog. I know the landlord never wanted us to have my dog there because he was too big. Yesterday, she wasn't home and the police officer was across the street and I stopped him myself and asked. She came home during the time, but I was next door at the neighbor's house while the police officer was doing his investigation. He asked me about my injunction paper, which I didn't have with me at the time. But when she pulled up, I said, there she is. She has the injunction paper. Look at the paper. You ask her for the paper. It's not like I'm trying to stalk her or anything, because when they gave me the injunction, I blocked her on the phone so that not to call her until we go to court. I understand she trying to have a little bit of space, and I'm not trying. Anytime she'll tell you, anytime I came, she wasn't there. It's not like I just want to get my stuff. And when you have a little bit of rides or a small car, I have like work equipment. Like yesterday, my homeboy, he has a truck. I got a buffer pad, 2 mop buckets, stuff for grout cleaning, cleaning solutions, stuff that I do on the side, a job that I was supposed to have been doing this morning before going to work tonight. And that was the whole reason. And I was like telling the police officer, like, hey, man, I just want to get my stuff. At the time, I was telling the police officer that both of our names are on the lease. She's not home. She's changed the locks at this point, but all my stuff is inside the laundry room. I know how to get into the laundry room. Could you stand right here and just let me get into the laundry room? My stuff is right there in the laundry room. I just want to get my stuff, get in the truck before my friend decides he wants to leave, and I don't have the opportunity to get my stuff and go with my stuff. I haven't called her. I haven't had anybody reach out to her. I understand that it's on the 10th, I believe, that we have the hearing. I just wanted to get my stuff. She actually packed all my stuff and put it in. She didn't pack everything, but I just deal with what I got. But at the same time, I have...
Mr. Wilson, I hear you. I hear what you're saying, okay? But
I'm really not trying to harass anybody at all. I just wanted to get
Ms.
my
Wilson,
stuff.
I'm not accusing you of doing anything, okay?
Just making it hard for me to get my stuff.
Mr. Wilson, you're going to want to reread that petition or that order very, very closely. I don't see where there's any exceptions for you to go to the house, so do not go back to the house. You need to abide by the injunction. Do you understand? Whether she's there or not there, you can't go. Do you understand what I'm saying to you?
Yes, ma'am.
No. Just listen.
Okay.
Every time you do that, you're going to get arrested, and it is going to be a new criminal offense, so do not go there. You will have an opportunity to be heard in court on issues in front of that judge. But do not go back to that house. Do you understand me?
Yes.
For any reason.
Yes, ma'am.
You are not to be within 500 feet of that place. Do you understand?
Now I do. I thought it was
Okay. Well, I'm not asking you to comment. I just, going forward from today, do you understand that you cannot go there?
Yes, ma'am.
Okay. Mr. Wilson, I'm going to place you on pretrial release, and you are to abide by the injunction in 20 DR 7647. Are we clear?
Yes, ma'am. Can I ask one question to the court?
Yes, sir.
how would I be able to get my work stuff while I'm talking to you?
Right, so I can't order anything that's against the injunction. I didn't issue the injunction. So you need to write a letter to the judge and on that case, or hire a lawyer who can help you file whatever motion you need to file in that division. Thank you, Mr. Wilson. Anything else, Ms. Wilson?
Well, what I'm not understanding is the fact that he had an opportunity that day when he was served from 4:30 until 9 o'clock at night. Then he came back the very next day.
I don't know.
Then he
I don't know
came
why
back
he didn't
over the
get a statement.
weekend. It's like you're not getting your stuff.
Yeah, I don't know, but I've been very clear that he's not to return, okay? And if he
Right.
does, you need to call the police.
Thank you.
You're very welcome. Have a nice day.
You too.
All right, good morning. Are you Mr. Eugene?
Good morning, ma'am. How are you?
Well, thank you. You are here in 20 CT set 4758. You were arrested for leaving the scene of an accident with property damage and possession of marijuana less than 20 grams. That's in case number 20 CT 4758 and 20 MM 5699. There is probable cause for both of the offenses. I will appoint the public defender to represent you. Bond in the traffic case will be $500. Bond in the misdemeanor case will be $100. I am revoking the bond in the out on bond case. That's 20 CF 8086. That bond's going to be set at none, sir. Thank you. Good morning. Are you Mr. Gibson?
Yes, ma'am, I am.
Mr. Gibson, you're here in 20 CT 4759. You were arrested for driving without a driver's license. There is probable cause. Ms. Bush, do you have an offer for Mr. Gibson?
Your Honor, I believe he bonded out on.
I do not,
He what, Dexter?
I believe he bonded out on the no valid driver's license.
Oh, okay.
and this is Mr. Gibson, correct, Your Honor?
Yes.
The only thing the state has is a contempt of court civil on 2018 DR 3881.
Okay, that's probably because he posted bond on 20 CT 4759. I don't have the contempt of court. What's the contempt on?
It is on 2018 DR 0038810.
881.
Yes, Your Honor.
Well, I bet you they already pulled that and sent it to court in 3.
Okay.
If it's a contempt of court in a DR case, it wouldn't come in here, it would go over there. So
Correct.
we're trying to move the child support writs over there as well.
But that was the only thing I had before me, so.
Do you show that he posted bond on the traffic case? Yes, I'm sorry. Okay. So, Mr. Gibson, you have already posted bond on your traffic case. It looks like you just have the contempt of court in the domestic case, and you'll see another judge regarding that issue.
I won't be getting out?
I don't know what's going to happen on that case, but I will email the judge in the event that somehow it got missed and let them know that you're here, sir, okay?
I still don't understand. There's no bond, I won't be getting out, or?
I don't know. Just a second.
Ma'am, that case was closed, I thought, in 2018. I paid the fines on the court costs and everything. I had to pay that in order to get my driver's license.
So this is strange. On that
I paid
DR
the
Does he have a hold on the DR? Just a second, Mr. Gibson. Does he have a hold?
He doesn't have a hold.
Oh. Okay. Ms. Bush, I don't know why you have that case. Because I see it's just set for a status hearing in December.
Yeah,
Okay.
and I was only responding to, I don't have the no valid, so I can't give an offer.
No problem. Okay, Mr. Gibson, I'm sorry for any confusion, sir. You're going to be released.
I am, thank you very much.
Yes, sir.
Appreciate it.
I had the contempt too. I don't know where it came from.
Yeah, and it says no bond on it.
Are you RR? No, he bonded. No. Okay. Mr. Gibson bonded. Right?
Well, he bonded on the driver's license, but this is, it's a writ. I thought that we were just.
What writ?
And Your Honor, on the paperwork that I have before me, it says, on the contempt of court, it says no bond.
On what? Erwin, can I get that no valid back, I guess? Mm-hmm. But how would he have then he would have a hold? I don't understand. So does he have a hold or not have a hold on the 18 VR case?
It's a charge against the trooper as a no bond, but it's not a detainer.
Okay. Do you know if it's been set in? Got it. Thank you. Okay, so Mr. Gibson, you do have a contempt of court, which you failed to appear for a status hearing back in 2018 in your domestic violence case.
I never
Your
knew
civil
that.
domestic no, I'm telling, this is what I'm telling you. You failed to appear in 2018. There was a writ issued for your arrest for failing to comply. The jail has notified Judge Lattimore that you are here. You will be seen within 48 hours regarding this writ. And then you'll be released regarding the no valid case.
So I have to stay here 2 more days at least?
Yes. Gosh, I'm sorry, Mr. Gibson, about the confusion. Okay. Okay, where are we? Good morning, your name?
My name is Derek Simmons.
Mr. Simmons, sir, you are here in 20 CT 932. You were arrested for driving while license suspended. There is probable cause. I'm going to appoint the public defender. Your bond is $500, sir.
Can I say something first?
Not about the facts of your case, but if you have a question, I can try to answer it.
Not the facts of all my case, but can you tell me how there's probable cause? I don't understand.
Well, that's a legal issue that you're going to have to talk with your lawyer about. Mr. Matos, did you want to make a probable cause challenge based upon the facts contained in the affidavit?
Can I re-look at this affidavit for a second, Your Honor? Simmons Derek. And this is Simmons Derek Alexander?
Yes, sir.
So let me just help you out, Mr. Matos. Mr. Simmons, and I'm not saying anything in the affidavit's true, but all I have to do is conclude that a reasonable person would believe that the crime had been committed and the crime is driving with a suspended driver's license. The officer states in his report that he saw you driving the vehicle, he stopped you, and you admitted to driving the vehicle, and your license is suspended. That's how there's probable cause.
But to be
Right.
honest, ma'am, when I got when we got pulled over.
But listen, I don't want you to talk about the facts of your case. I'm not saying that you're guilty of this crime. I'm telling you you were arrested for and that there's probable cause. Thank you, sir.
Beverly Brown, Your Honor, is medical.
All right, that's 20 MM 5638, Mr. Matos. Do you want to enter a plea of not guilty?
Yes, Your Honor.
Okay. Ms. Brown, this is a regular.
Your Honor, are we going to arraignments now?
Yes, I'm sorry, Ms.
May I have just a moment just to pull my arraignment paperwork?
Sure.
I try not to mix them with the IA.
I understand.
Thank you, Your Honor.
Sure. Okay, so this is Ms. Brown. This is a regular battery. I'm going to reassign this one.
Yes.
Okay. Sue Brown. That's going to be in Division 81. Pre-trial conference is, pre-trial conference is going to be September 24th at 9 a.m. and that is in courtroom 4E.
Division 81.
4B, Your Honor.
E is an elephant.
Thank you. And Your Honor, that's Regional Conflict Council.
Oh, is it?
Yes, Your Honor.
Okay. Oh, thank you. Does that make a difference?
No.
Okay. And
Terrell Golding is also medical, Your Honor.
it's 20 MM 5337. Mr. Matos, would you like to enter a plea of not guilty and waive the appearance?
Yes, Your Honor.
That's Division 50. Pre-trial conference September 14th at 2:30 p.m. courtroom 7C.
Glenn Mathis is also medical.
Mr. Matos, again, your office represents Mr. Mathis. Do you want to waive the appearance and enter a plea of not guilty?
Yes, Your Honor.
That's Division 62 case. That's in front of Judge Cameron. Pre-trial conference is September 17th at 9 a.m. courtroom 9B. Good morning, your name?
Armando Alejandro Montalvo.
Mr. Montalvo, this is 20 MM 4598. This is your arraignment for the offense of trespass on property other than a structure or a conveyance. Ms. Bush, was there an offer for Mr. Montalvo?
Yes, Your Honor. The offer that was conveyed is an adjudication of guilt, 45 days, Orange County Jail, 45 days credit time served. No contact with victims or witnesses, no return to the scene, the WWE Performance Center at 5055 Forsyth Commerce Drive in Orlando. Abide by all trespass warnings and court costs.
Okay.
Your Honor.
Mr.
Your Honor.
Yes, sir. Yes.
Your Honor, I do have court legal documents that I did mail a contract to WWE's lawyers and their property. I did read over their court documents. It says the court should impose a suspended fine and a suspended period of incarceration and extend the injunction to prohibit the defendant with coming in within at least 250 feet of WWE's property or any of its events. Your Honor, I will never return to any of their property or any events of what they do. I'm asking the courts to please take into consideration the time that I have done on this case, to please take it into consideration to try to resolve this case today. If it's,
Yes, Mr. Montalvo, listen, I don't know if you could hear their state or not, but I think she took all of those things into consideration in making your offer. The offer was an adjudication of guilt, 45 days in jail with credit for 45 days time served. So you will be released today as to this case.
Oh.
And you are not to return to the property, and you're not to have any contact with the witnesses or any victims in the case, sir. Do you understand?
Okay, so this case will be resolved today.
That's correct.
Okay. Can I say one last thing to the court real quick?
Sure.
And to the state attorney's office as well. And to the WWE, I never went there with ill intentions. I never went there to create confusion or be what a lot of people try to make me out to be in the city of Orlando. And
Okay.
I really want the courts to understand that, because years ago I was shot by the police.
Okay.
All I wanted to do was try to turn my story around in a positive way. And if you read the affidavit, I was dancing, performing, and nobody was hurt or harmed. And I am
Okay,
not.
sir.
I'm not what people try to make me out to be. And I want to
Okay.
make that clear to the courts, the WWE, and the state attorneys as well.
Thank you, Mr. Montalvo. I appreciate that. Thank you very much. Did you want to proceed with the plea?
So this will resolve this case today, right?
It will, yes.
How many days do I have in jail right now?
45, and you're going to get credit for 45.
I have 45 days in jail right now?
That's right.
Okay, so I'll have time served. I've just got ADHD. I'm sorry.
Okay. Well, stick
Sorry.
with me, okay?
Yes.
So you understand it's 45 days with 45 days credit time served. You cannot return to the WWE Performance Center.
Yeah, we're done with that chapter in my life.
Okay, great. Okay, Mr. Montalvo, did you read the plea form before court this morning?
Yes, I got a copy in my
Good. Do you have any questions about any of the rights that you are giving up on the plea form?
no, ma'am. I'm sorry for all the inconvenience.
You're not inconveniencing me.
I'm sorry to the WWE and the city of Orlando. And
Yes, sir.
And-
Mr. Montalvo, I appreciate that, and you've expressed that. I just need to ask you a few more questions, okay?
yes, ma'am. I've read through
All
the
right.
plea form.
All right. You don't have any questions about any of the rights you're giving up?
No, ma'am.
All right. Are you on probation?
No, ma'am.
Do you understand if you are not a U.S. citizen that this plea will subject you to deportation?
Well, if they could send me over the border, I'd much
You
rather
understand?
be. Yes, ma'am. I'm an American
have you t-
citizen.
Okay. Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
Absolutely not. No
All right,
drugs,
Mr.
no
Montalvo.
alcohol.
Got it. Sir, I'm going to accept your plea, adjudicate you guilty, sentence you to 45 days in jail. You have credit for 45 days time served. You will not be able to return to the WWE Performance Center. You're not to have any contact with the victims or any witnesses in the case. And you are going to have to pay court costs. Those are going to be due by August 5th of 2021. You have 30 days to appeal the judgment and sentence of the court in writing, sir. Thank you.
And, Your Honor, he needs to make sure he abides by the trespass warning. That he
Yes, I think that's clear, Mr. Montalvo. You have to abide by the trespass warning. You cannot return to the property, right?
Absolutely. Can I make something clear to the state attorney's office? In my case where my bond was revoked, I was ensuring the safety of the citizens that were exiting
Okay.
out of the Walmart.
All right, so Mr. Montalvo, I don't know anything about that case.
I
and I don't want you to
understand.
say anything that could hurt any other cases, so I think we should just end the conversation here, okay?
Can I just say one last thing? Listen,
No,
I'm,
no,
I'm,
Mr.
I'm not,
Montalvo.
I'm not,
Thank
I'm
you.
not a bad guy.
I don't think you are. I'm not making any judgments about your character, sir.
I'm sorry.
All right, how about Mr. Pryor?
Mr. Pryor is medical, Your Honor.
All right, he doesn't have a lawyer. I'm going to appoint the public defender to represent Mr. Pryor. He's currently unrepresented. Mr. Matos, do you want to enter a plea of not guilty?
Yes, Your Honor.
Mr. Pryor is going to be in Division 81, which is Judge McGinnis pretrial conference, September 24th at 9 a.m., courtroom 4E.
Julius
Mr.
Spires is also medical.
Okay, what about Mr. Roll?
I'm sorry, Melvin Roll is also medical, Your Honor.
Okay. Mr. Matos, do you want to enter a plea in that case? I'm sorry, a plea of not guilty in Mr. Roll's case?
Yes, Your Honor.
All right, that's 20 MM 5106. He's being arraigned for a violation of a pretrial release condition on a domestic violence case. Division 50, pretrial conference, September 14th at 2:30 p.m., courtroom 7C. And then Mr. Spires is also medical. That's 20 MM 5008. This is his arraignment for violation of a pretrial release condition on a domestic violence case and trespass. He's represented by the Office of the Public Defender. Mr. Matos, do you want to enter a plea of not guilty in that manner as well?
Yes, Your Honor.
That'll be, again, Division 50, pretrial conference, September 14th at 2:30 PM, courtroom 7C. And Mr. Vela?
Medical, Your Honor.
Mr. Matos, you represent him as well. Do you want to enter a plea of not guilty?
Yes, Your Honor.
Mr. Vela's next court date is going to be in Division 61, pretrial, no?
Rotation.
Oh, thank you, it is. Okay, so that is Division 85, Judge Allen. Pretrial conference is September 14th at 9 a.m., courtroom 4A. So those are the arraignments. We're done with that. Now we have the add-on docket.
Hunter, may I have a moment before we go to the
Absolutely,
add-on?
yeah, just let me know when you're ready. Who do I have in front of me right now? What's your name, sir?
Nicholas Ablong.
I'm sorry, sir, tell me, Nicholas Atlong?
Nicholas Ablong.
Oh, Ablong, I see you, okay. This is on out-of-county plea.
And the state's ready, Your Honor.
Okay. Let me just grab all this paperwork. That's Mr. Laquarius. This is Mr. Ablong. Those are the 33 days, okay. Mr. Ablong is represented by Mr. Traben. I'll have to give him a call in just a second. Mr. Ablong, have you signed the plea form? Has your lawyer come and gone over that plea form with you, and have you signed it?
Yes, I have signed it.
You did. Do you have that with you?
No, I don't have it with me.
Did he come and take it? Did he take it with him?
Did who take it with it?
Your lawyer.
My last plea hearing, I signed it, but then an issue caught up, so I had to leave. But I signed it though, last week.
Where is it?
I don't know where it is. I don't. It's not in my possession. I don't have it.
Okay. Well, I'll have to ask Mr. Traben. I can't do this remotely. Okay. All right. Well, my phone is on here, so we try that.
Give me a minute for the number. Want it on speaker?
Do I have the order that you all sent to the judge? This came from Virginia. And this came from, this was attached to the add-on docket. Oh, amazing. But
You online? Good morning, Mr. Traben.
Good morning.
How are you today?
I'm doing very well. How about yourself?
Good, thank you. So I'm looking through the paperwork that was provided to my office, and I don't have a signed plea form with your signature and your client's signature.
So the plea form I provided to Ms. Barnes previously at the clerk's office, I was informed that they would still have it. It had my signature on it, and the understanding was that it would be printed by the clerks and left at the podium so my client could sign it.
Okay, let me look and see if that's scanned. Well,
Okay.
actually, this was signed and filed in the Seminole County Clerk's office?
This is a Seminole County case, yes.
No, I understand, but we're in Orange County.
Correct.
So I guess I'm confused. I don't know how we would have the Seminole County plea form here in the Orange County Jail.
So I had signed it, the scanned copy, and sent it to everyone on the email thread that was involved with setting this.
Oh.
So that was included. I have it. I'd be happy to resend it.
That would be great.
Okay.
I don't know that, was my assistant on that, Brad, or was it previously?
I mean, I believe it was everyone from the. I know it had several representatives from the state, from both Orange and Seminole County. Okay. It had several clerks, but I would be happy to resend them. I was provided with one both from Seminole County and from Orange County.
And, Your Honor, good morning, Mr. Traben. The only thing that we have is the unsigned document, but we also have the email that says that the judge agreed to this, so.
Mm-hmm.
Right, yeah, the plea's been approved. I was just, in the packet of information that I had, it just doesn't have the signed plea form. So, Mr. Traben, would you send that to my JA, Jill Ryan?
Yes, absolutely.
Okay, do you have her email address?
I do. I'm sending it now.
Perfect. So then, I'll have her forward that to me.
And Your Honor,
All right.
the state
I just sent it.
have a copy as well.
Sure, of course.
Thank you.
I'm sorry, is there someone from the state who would like to have a copy of it as well?
Yes, Edith Bush?
Okay, I will forward it to Ms. Bush then right now. I'm sorry about that.
No, that's not a problem.
Thank you.
So, Mr. Traven, what I think I'll do is I'm going to recall your case because I'll have to get that, and then we'll have to print it and get it over to Mr. Ablong to have his signature placed on there. So, I will call you back in just a little bit.
Alrighty, I'm sending it now. I've already sent it to Ms. Ryan, but I'm sending it to Ms. Bush right now.
Perfect. Thank you so much.
All right. Thank you. Bye-bye.
Okay, bye-bye. I'm going to have Jill bring it to me.
Trying to.
Okay. All right. So we'll get there. Mr. Ablong, I'm just waiting for your plea form. Your lawyer just is going to resend it. As soon as I have that, we'll recall your case back up, okay?
Okay, how long would that take?
I'm not sure. Maybe 15, 20 minutes? Okay. Okay. All right. Who's next?
Aubrey Alston, Your Honor, is medical.
Okay, and that's an out-of-county status case out of Alachua County. Per Judge Pena, his bond is to remain at $25,000. Mr. Matos, your office can file a bond motion after talking with Mr. Alston, okay?
Yes, Your Honor.
Frank Alston is also medical.
All right, and then his bond is to remain at none at this time. Mr. Matos, your office again represents him. Maybe you guys can work something out.
Yes, Your Honor. I'll be emailing them.
Good morning, tell me your name.
Joseph Sensendaber.
Mr. Sensendiver, you are here for a status hearing out of Seminole County.
Yes, ma'am.
And at this time, well, if I can get it to scan. Per Judge Rexeidler, your bond is to remain at none, sir. The public defender here in Orange County was previously appointed to assist you with your case, and they'll be able to coordinate with Seminole County while you're here.
So there's nothing being done right now?
No, sir.
All right.
Not in terms of your bond. Thank you.
All right, thank you.
Christopher Taylor, medical, Your Honor.
Okay. That was supposed to be an out-of-county plea out of Volusia County. He was represented by the public.
Your Honor, he may be able to attend tomorrow if you want to reset him.
Okay. We'll do that. I'll reset Mr. Taylor tomorrow. Hey, Joe, Mr. Taylor, you couldn't come to court. That was the other felony plea. Dexter said that he may be able to attend tomorrow, so I'll reset it. Will you call that lawyer and tell him? Okay.
So this is the Orange and this one is Seminole. They both reference the same Seminole case. This is the one that's signed.
Why does it say orange? Just because he filed it? You can't file it here. I think this is a mistake. This is an orange. I have to ask Mr. Traven, but they're both signed. So I think it needs to be this one. I would think. Because it's the Seminole County case. Maybe he just did it to cover all bases. In the packet? Yeah. I think I said right here. Yeah.
Yeah, that's.
Okay, then I'm gonna use that. Then I have to. Sign off. Okay, all right, okay, that's good. Thank you. I'm gonna set this aside. Could I have, could you take that to the defendant, Mr. Avalon? All right, next case, Dexter.
L'Aquarius McCants. It's a competency hearing, his mental health.
Okay, Mr. Matos, do you want to leave his appearance?
Yes, Your Honor.
So, I do. Okay. So that case is 20MM 4900. I reviewed the motion, and it looks like Dr. Danziger found him incompetent on July 30th of this year. Ms. Bush, were you going to stipulate to a finding of incompetency?
Your Honor, at this time, while the state is not stipulating to the finding of incompetence, the state did note that in the order in paragraph 2, the enumerated paragraph 2 says the defendant does not meet the criteria for commitment to a treatment facility of the Department of Children and Families. However, the state just wanted to point out that Dr. Danziger did say that he meets the criteria for involuntary placement, but because this is a misdemeanor, he is not eligible for a state hospital. However, he goes on to say that his recommendation is that he be committed involuntarily by the court to a local psychiatric facility such as Aspire. Then he goes further, and he also states that he believes that Mr. McCants is a danger to himself and is at risk for further decompensating. So the state just wanted to put that on the record to the court. However, the state is not stipulating to the incompetence only because we are not to stipulate. We're to let this be handled in the trial division, Your Honor.
Okay. So
But the state, at this point, without stipulating, will defer to the court as to a finding of incompetence. But
Well, I don't believe that I can't find him incompetent without having an evidentiary hearing if the state is not going to stipulate to the fact that he is incompetent to proceed.
yes, Your Honor, and in the motion, defense actually asked that this be set for a hearing within 20 days.
Is the state requesting to have an expert appointed to evaluate Mr. McCants?
Now that defense has made Dr. Danziger's evaluation part of the record, the state is not requesting a second.
Okay, so then, I'm just wondering, do you know, is your office preparing to file an information? I just don't know if we need to set where I need to set the hearing because it's a Division A case. So I can set it here, but then,
Your Honor, if I may look at that one more time. I'm just
July
looking to see
6th.
if there's any notes in here that.
So it's been about I wonder why a 33-day motion hasn't been filed, because he was arrested July 6th, and today is August 5th.
It appears that written communication, mail was returned to our office, and just yesterday, a message was left for the victim, so we're still trying to contact the victim, Your Honor.
Okay. All right. Well, I guess I'll set the hearing here.
And Your Honor, if the state finds that we are going to either not file or we're going to concede to the finding of incompetence, the state will let the court know.
Thank you. So the hearing will be on August 24th. We'll be here at the BRC, and Mr. Matos, you'll need to have Dr. Danziger ready to testify, okay?
And the time of the hearing, Your Honor, would be 9 o'clock or a specific?
We could do that first. We could do 9 o'clock. That's fine. Thank you, Ms. Bush. And ordinarily, I know on a lot of these, we sometimes end up doing an ROR in the alternative, but based upon the information in the affidavit or in the report by Dr. Danziger, I'm not comfortable with doing that on this case today. Okay, so that one's finished.
Mr. Montes, I will check with downtown to see how they want to go forward.
I just emailed him, so we should be, I just emailed him, so we should be like.
No, I'm saying my office.
Okay.
Because we don't stipulate out here, but they can certainly stipulate down here.
Okay.
denied. No, none of the court said it, so I think we should just.
But I just want them to have an opportunity to read Dr. Janzer's
Defendant incompetent to proceed.
that as
Denied, court said he
emailed and said,
stated
hearing set.
competency not stated.
Don't worry about it, I'll take care of it.
We can do it after court.
Okay.
Okay. That's fine.
Well, you can go there. I just don't want to miss them. Or if you go all the way down to
Good morning, tell me your name.
Jean Demeuse Antoine.
What's his name? Are you Jean Antoine?
Yes.
Okay, so I'm sorry, I couldn't hear you. This is 20 3496. Mr. Antoine, it's my understanding that you're here to enter a plea today to the offenses of resisting officer without violence and criminal mischief. The negotiated agreement is, as to count one, is an adjudication of guilt, court cost of investigation to OPD of $123, and count two will be a withhold of adjudication, court cost, and order in reserve as to the amount of restitution.
And, Your Honor, Edith Bush for the state, that order in reserve has now been modified.
Okay.
And I don't know if I have let Mr. Matos know, and I provided him with the restitution amount. This would turn to an order of restitution
Okay, how much is it?
in the amount of $219.37.
Okay. And is the term also that it's credit time served?
As best as I could make heads or tails of this, yes, Your Honor.
Okay. So, Mr. Antoine, the change in the plea agreement is that now the state has a definite amount of the restitution, as where before I was just going to order it and then allow them to tell us what that amount was later. The amount of restitution is $219.37. Do you still want to continue with the plea?
Yes, Your Honor.
Oh, okay, sir. Did you have a chance to review the plea form before court this morning?
Yes, Your Honor.
Do you have any questions about any of the rights that you are giving up?
No questions, Your Honor.
Would you like to withdraw your plea at this time and enter a plea of no contest?
No, Your Honor.
You do not?
Yes, Your Honor.
Thank you, sir. Are you on probation?
No, Your Honor.
Do you understand, if you are not a U.S. citizen, that this plea will subject you to deportation?
Yes, Your Honor.
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No, Your Honor.
All right, sir. I am going to accept your plea. As to count one, I am going to adjudicate you guilty, sentence you to, do we know how many days, Mr.
I don't know.
7 days.
How many?
7 days.
Thank you. 7?
Yes, ma'am.
Sentence you to 7 days in the Orange County Jail with credit for 7 days time served. You're going to have to pay cost of investigation, excuse me, to the Orlando Police Department in the amount of $123. As to count two, I'm going to withhold adjudication, sentence you to 7 days in the Orange County Jail with credit for 7 days time served. And you're going to have to pay restitution in the amount of $219.37. You will have to pay court costs in all of those cases, which will be due by August 5th of 2021. You have 30 days to appeal the judgment and sentence of the court in writing, sir. Did you have any questions?
No, Your Honor. Thank you.
All right. Ms. Bush?
And, Your Honor, the
God bless.
restitution is payable to the Lynx bus.
Okay. Mr. Antoine, that that restitution is payable to the Lynx bus station.
Yes, Your Honor. Yes.
Okay. Thank you, sir.
You're welcome.
And the state will provide the court with a restitution order.
Thank you, Ms. Bush. Okay, let me go through this. Mr. Oblong, just give me one moment, okay?
Yes, ma'am. Yes, ma'am.
I'm going to send this back. Please go here. Yes, please. All right, Mr. Traven, are you there?
Yes, I am.
Okay, great. I have Mr. Ablong on video here in the courtroom with me. Mr. Ablong, could you please raise your right hand to be sworn in by the clerk?
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Ablong, please state your full name.
Nicholas Michael Ablong,
All right, and your date of birth?
April 5th, 1998.
All right, and sir, do you read and understand English?
Yes, ma'am.
Okay, and Mr. Traven, before we go any further, there was an Orange County admission of violation of probation and the Seminole County. I was going to use the Seminole County form. I wasn't sure why there was both in the court file. Am I missing something?
No, Your Honor, I was provided both. So in an abundance of caution, I included both, but I think you are correct.
Okay, that's what I figured is that's why they were both there. I just wanted to make sure. Okay. Mr. Ablong, do you understand that the maximum penalty for the charges for which you are on probation for is 15 years in prison?
Yes, Your Honor.
All right. And your attorney has indicated that you wish to change your previously entered denial of your violation of probation to an admission. Is that correct?
Yes, Your Honor.
Are you currently under the influence of any drugs or alcohol?
No, Your Honor.
Have you taken any medication today for any reason?
No, Your Honor.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of these at this time?
No, Your Honor.
How far did you complete in your education?
Till college, Your Honor.
Did you read the plea form, sir?
Yes, Your Honor.
Have you discussed your case in the plea form with your attorney?
Yes, Your Honor.
Was he able to answer all your questions for you?
Yes, Your Honor.
Did you understand everything that he explained to you?
Yes, Your Honor.
Do you understand the constitutional rights that were set forth on the plea form?
Yes, Your Honor.
Do you understand by entering this admission today, you're giving up your right to have a hearing on the admissions?
Yes, Your Honor.
All right. Mr. Ablong, actually, Dexter, do you think I could get his plea form brought into courtroom 1, please?
Do you want him to sign it beforehand or?
Yes, if he could sign it now. Thank you. Dexter. All right, Mr. Eblong, I have your plea form in my hands here, and I did watch you sign it on the video. I'm just going to add the date here. All right, Mr. Eblong, are you entering this plea today freely and voluntarily?
Yes, Your Honor.
Has anyone forced, threatened, or coerced you into entering into this plea today?
No, Your Honor.
Has anyone promised you anything other than what your lawyer has actually, what I'll place on the record now? So it's my understanding that the negotiated agreement is to reinstate probation. You are going to be required to have a GPS and completed impulse control class. There's $100 cost of prosecution and $100 cost of defense, and then court costs. All previously imposed terms and conditions will remain in effect. Is that your understanding of the agreement?
Yes, Your Honor.
Okay. And are you satisfied with your lawyer's representation?
Yes, Your Honor.
Do you understand that if you are not a citizen of the United States, that entry of this plea will result in your deportation?
Yes, I understand.
And do you also understand that by entering this admission that you may be subject to involuntary civil commitment as a sexually violent predator upon completion of your sentence?
Yes, Your Honor.
Okay, so Mr. Ablong, do you admit at this time that you violated your probation by viewing, owning, or possessing any obscene, pornographic, or sexually stimulating material
Yes.
on May 15th of 2020?
Yes, Your Honor.
All right, sir. I'm going to accept your admission. I find that you are alert and intelligent, that your admission was freely and voluntarily entered, and that you understand the nature of the allegations against you, and that you are represented by competent counsel with whom you say you are satisfied. I also find that there was a factual basis for acceptance of the admission. I was already provided with the score sheet. Ms. Bush, do you have that as well?
Yes, Your Honor.
Okay. All right, Mr. Eblong, I'm going to accept your admission, reinstate your probation, add the condition that you are to have a GPS monitoring device, which, Mr. Traven, I believe that will occur in Seminole County, correct?
Yes, that's my understanding.
Okay, and I think probation can put that on.
Yes, ma'am.
Do that there. Okay. So I'm going to put that in the order here that Mr. Ablong is to report to probation. I'll have you contact probation within 24 hours of your release, and then they can indicate to you how you're to report. But GPS will be added in Seminole County since we don't have that here.
And, Your Honor, the plea form actually has that he is to report no later than 4 p.m. the next day,
Okay.
the next business day following the entry of the plea. And I don't know, because it has other verbiage that says if it's a pre-sentence investigation.
Right, I do see that on number 1 on the plea form, but the problem is I don't know if he can report to probation by 4 p.m. the next day. I guess it would just be report by telephone by 4 p.m. the next day.
I mean, I think that's prudent just to make sure, especially with the pandemic going on. I don't know if they're willing to have people just walk into the probation office, and I don't want that to cause a problem.
Neither do I. I know in the beginning of the pandemic, people were not allowed to report. I don't know if that has changed, and that's why I don't want to tell him he has to go there. And there's no one there to let him in.
If he calls
by 4 p.m. tomorrow.
By 4 p.m. and makes the arrangements for the GPS.
Did you hear that, Mr. Traven?
Yes, if he contacts by 4 p.m. tomorrow to
Yes,
make the
and-
arrangements.
Correct, to make arrangements for the GPS?
I think that's fine.
Okay. And then I'll also add that here to complete the impulse control class, you have a $100 cost of prosecution and $100 cost of defense, along with court costs. All previously imposed terms and conditions do remain in effect. Anything else from the state?
Nothing further from the state, Your Honor.
Mr. Traymond, anything from the defense?
Your Honor, as part of the sentence for the VOP, I didn't hear if he had any credit for time served, but otherwise, my understanding is he is to be released, and the expected termination of probation is the original date.
That is my understanding. I don't have any additional information that was contained in any of the emails that I read regarding what the negotiated agreement was, and that was approved by Judge Rexeidler.
Yes.
I don't see anything to the contrary of what you just said. Certainly, if you have questions, you could clarify with her, and then you could do a motion to correct something that we need to correct.
Okay.
I'm not going to add anything.
I mean, I've been in coordination with the probation officer as well as the ASA from Seminole, so I don't believe there's going to be any problem.
Okay. Yeah, my understanding based upon this plea that he would be released today.
Yeah.
Okay.
As to this case.
Yes. Yes. Okay. Anything else?
All right. No, Your Honor. Thank you so much.
Oh, you're welcome.
I appreciate your assistance.
Sure. Have a great day.
All right. Thank you.
Bye-bye.
Bye-bye.
All right. Then we only have the 33-day motions left. Ms. Bush, I think I need to have you sign this plea form as well. Oh, you want to approach and sign that? Set to the side. Are we skipping Mr. Benton?
Let's skip him, Your Honor.
Okay.
Yeah.
Good afternoon, sir. Tell me your name, please.
James Crum.
Mr. Crum, this is 20MM 5677. You were arrested for possession of drug paraphernalia and having the identification of another person. There is probable cause. I'll appoint the public defender. Was there an offer for Mr. Crum?
Yes, Your Honor. It would be an adjudication of guilt, 5 days Orange County Jail, 2 days credit time served, and no contact with any of the victims of the false ID.
Mr. Crum, do you want to accept the offer, sir?
Yes, I do.
All right. Did you have a chance to read the plea form before court?
Yes, I did.
Do you have any questions about any of the rights that you're giving up?
No, ma'am.
Are you on probation?
No, ma'am.
Do you understand that if you are not a U.S. citizen, this plea will subject you to deportation?
Yes, ma'am.
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No, ma'am.
All right, I'll accept your plea, adjudicate you guilty as to both counts, sentence you to 5 days in jail with credit for 2 days time served. Those will run concurrent to one another. You will have to pay court costs, which will be due by August 5th of 2021. You're not to have any contact with the victims, and you have 30 days to appeal the judgment and sentence of the court in writing.
Yes, ma'am.
Thank you, sir. Good afternoon. Your name?
Good afternoon, Your Honor. My name's Rubens the Sources.
Yes, sir. Ms. Bush, do you know if an information's been filed on the other misdemeanor trespass case?
Yes.
And, excuse me, Your Honor,
Sir?
could I ask a question?
Yes?
So, I was told the person that worked for the Sunrail Trust to call the police for me, And then he's like, do I need an ambulance also? I'm like, well, first I like to call it to the police. And the police advised the Sunrail person to trespass me after multiple times. And the person told him no. And he kept asking him the same question. So eventually they trespassed me. And the police
So,
also...
Mr. DeSources, let me just stop you for a moment, okay?
Okay.
Let me just stop you. So, Ms. Bush, is there an offer for Mr. DeSources to resolve the out on bond trespass and the new trespass?
Yes, Your Honor.
Okay. Mr. DeSources, you may have a defense to this new case. I don't know, sir, but did you want to enter a plea to this case and your other trespass case today?
Enter a plea?
Yes, sir.
And how could I, if I enter a plea, could I civilly take actions against the person that forced me to leave one property and to the next property where
I cannot
trespassed
give
me?
you any lead. So it sounds like you want to have a trial and talk to a judge, which is perfectly fine, sir. I'm going to stay your bond at the $500. I'm not going to take any action on the out on bond case.
What was the plea?
I don't know, Ms. Bush, what was the offer?
It would have been a 7-day offer. credit
7 days
card.
in jail.
Oh no.
Okay. So I'll stay your bond, sir. You're not to return to the Sunrail or to the Lynx bus station. And you need to appear at all court dates, sir. Thank you.
This is for, which case is this?
It's a new case that you just got trespassed from yesterday at the Lynx station.
So this is for the trespassing?
Yep.
This is trespassing for the Sunrail?
It's related, yes, to the Lynx and Sunrail. It's a new case. You have two trespass cases.
Right, so which trespassing now we're taking care of right now at this very
We're
moment?
not taking care of any.
Okay.
They're all pending. Thank you.
Okay, perfect.
Good afternoon, your name?
Tanya.
Good afternoon, Ms. Harris. This is 20MM 5669. You were arrested for trespassing.
Right there to the speaker.
There is probable cause. I'm going to appoint the public defender to represent you. Ms. Bush, did you have an offer for Ms. Harris?
Yes, Your Honor. It's adjudication of guilt, 2 days Orange County Jail, 2 days credit time served, no return to the 7-Eleven at 3974 South Orange Blossom Trail, no contact with witnesses, abide by all trespass warnings and court costs.
Ms. Harris, did you want to accept the offer?
Yes, ma'am.
All right. Did you read the plea form before court?
Yes, ma'am.
Do you have any questions about any of the rights that you're giving up?
No, ma'am.
Are you on probation?
No, ma'am.
Do you understand that if you're not a U.S. citizen, this plea will subject you to deportation?
Yes, ma'am.
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
I had a few cans of beer about a week ago.
Okay, but nothing that would affect your ability to understand what's happening today, right?
No, ma'am.
Okay. So I'll accept your plea, adjudicate you guilty, sentence you to 2 days in jail with credit for 2 days time served. You're not to return to the 7-Eleven or have any contact with the witnesses. You'll have to also abide by the trespass warning. Your court costs are going to be due by August 5th of 2021. You have 30 days to appeal the judgment and sentence of the court in writing, ma'am. Thank you, Ms. Harris.
You get released today?
Yes, ma'am. Well, as to this case, you are. I don't know if you have anything else.
Okay, thank you.
Okay. Good afternoon, ma'am. Your name?
Tamara Cecily Jackson.
Ms. Jackson, you are here in 20MM 5683. You were arrested for trespass and dwelling after warning. There is probable cause. I'll appoint the public defender. Ms. Bush, there's no offer on this case, is that right?
There's no offer yet.
Okay. Ms. Jackson, you're not to return to the scene. You're not to have any contact with your mother. Your bond is $500, ma'am. Thank you. Yes, the victim. Okay.
Did Jimmy say about competency issues?
You're on the next on the list, LaGreek DeJimmy, mental health.
All right, that's 20MM 374. Mr. Matos, I will appoint your office to represent him. Did you want to waive his appearance?
Yes, Your Honor.
He was arrested for trespass on property. There is probable cause. I didn't see the name. I'm just going to put he's not to return to the scene. I didn't see the name of the store in the affidavit. It's 449 West Main Street. His
Yes,
bond is
Your Honor.
$500. I'm not going to take any action on the out on bond case. Good afternoon. Your name?
Jacob Morales.
Mr. Morales, this is 20MN 5680. You were arrested for petty theft and possession of drug paraphernalia. There's probable cause. I'll appoint the public defender to represent you. Ms. Bush, was there an offer for Mr. Morales?
No, Your Honor.
Okay. Mr. Morales, your bond on count one is going to be. Actually, Mr. Morales, I'm going to release you on your own recognizance. At this time, you are not to return to the Walgreens or have any contact with the witnesses in this case. Thank you, sir.
You're on the next on the list, Palanca Bonded.
Thank you. Good afternoon. Your name?
Krishna Prasad.
Mr. Prasad, this is 20MM 653. You were arrested for resisting officer without violence and petty theft. There is probable cause. Is there an offer for Mr. Prasad?
Yes, Your Honor. It would be an adjudication of guilt, 7 days Orange County Jail, 2 days credit time served, no return to the scene, and I'm looking to see if all of the merchandise was recovered or if it was perishable.
I had my debit card. It declined. I ate some cookies. I got cookies.
And Your Honor, since I can't tell whether or not the cookies were recovered or open, the state would ask the court to order and reserve as to restitution.
Mr. Prasad, did you want to accept the 7-day offer?
So I do 5 days.
Right, you have credit for 2.
No, I want a lawyer.
Well, I've already given you a lawyer. I'll release you on your own recognizance at this time. Sir, you are not to return to the scene of the offense or have any contact with any of the witnesses. Do you understand?
Yes, ma'am.
All right, thank you, sir. Good afternoon, ma'am. Tell me your name.
Jeanette Rivera.
Miss Rivera, this is 20MM 5693. You were arrested for trespassing in a structure or a conveyance. There is probable cause. Ms. Bush, is there an offer for Ms. Rivera?
Yes, Your Honor. It would be an adjudication of guilt, 2 days Orange County Jail, 2 days credit time served, no return to the Steele Apartments at 750 North Orange Avenue, and no contact with witnesses, abide by trespass warning and court costs.
Ms. Rivera, did you want to accept the offer? It's an adjudication of guilt with time served. You can't return to the apartments.
Fine. What apartment is she talking about?
Well, the place you were arrested, you can't go back there.
All right.
They don't want you on the property there, ma'am, okay?
Okay.
Do you want to accept the offer?
Yes.
Did you read the plea form before court?
Yes, I did.
Do you have any questions about any of the rights you're giving up?
No, no questions.
Are you on probation?
No.
Do Do you understand if you're not a U.S. citizen that this plea will subject you to deportation?
I am a U.S. citizen, born and raised here.
Okay. And have you taken any drugs, alcohol, or medication that would
I don't
affect
take
your ability?
drugs, no.
Okay, well, just listen to my question. Not accusing you, I'm just asking you. Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No.
Okay. I'm going to accept your plea, adjudicate you guilty, sentence you to 2 days in jail with credit for 2 days' time served. You're not to return to where you were trespassed, ma'am, which is the Steelhouse Apartments. You'll have to pay court costs, which will be due by August 5th of 2021, and you have 30 days to appeal the judgment and sentence of the court in writing. Thank you, ma'am. Sir, good afternoon. Tell me your name.
Humberto Fuentes.
This is 19MM 836. You failed to appear for pretrial. Ms. Bush, I was looking at this. Can you enter a no info notice or null pros on count 1?
Your Honor, the concern that the state has is that this was before the statute went into effect. This is a 2019 filing.
Okay.
So at this time, the state would recommend that the court ROR as to both counts, if the court is able to do that.
Mr. Fuentes, why did you miss court?
Well, actually, I was present in the courthouse, Orange County Clerk Courthouse. I went there on July 13th. I arrived, and then one of the officers explained to me that the courthouse was going to be closed for 14 days because somebody tested positive for COVID. So I assumed that, I was just going to get another letter in the mail or some type of call. And then the day before yesterday, I looked up my paperwork through the website, and I looked up my name on the records, and then I see that on the same day I went, but then was told to leave. I got the bench warrant set out for me, and then I got word, so that's why I came in yesterday.
Sure. Okay, I understand, Mr. Fuentes. So even at this time, I don't know exactly what the rule was on the 13th of July in terms of in-person for pretrial. But I know that right now it's not in person. It's virtual only.
I'm sorry, can you repeat that?
I'm just,
Sorry.
no, I was just saying, I understand what you're saying and why there was some confusion.
And Your Honor, that's why the state is comfortable recommending ROR as to both counts.
Mr. Fuentes, are you represented by the public defender or do you have a lawyer?
No, ma'am. No, Your Honor.
Okay. Were you in contact with the public defender prior to this case?
No, Your Honor. I believe I pled to a diversion program for my original charges, and then for this new one that recently that just happened, nothing. I assumed I can come explain, but I didn't know.
Okay, so you just have the one case. It's your case, and then this is a failure to appear.
Yes,
Your
yes.
Honor, this is a diversion rejection.
Got it. Okay, so Mr. Fuentes, I'm going to appoint the public defender today to represent you. That way you have someone to talk to make sure you know where to be for the court dates and they can maintain contact with you. You're going to get a form there and it's going to have the contact information for the public defender. So I want you to call them when you are released. You understand?
Yes, Your Honor.
All right, I'm going to give you a pretrial date in Division 85. You have Judge Allen.
Thank you,
Your
Honor.
pretrial date is 9/14 at 9 a.m. and it's in courtroom 4A. So call your lawyer to make sure you know where you should be, whether you appear virtually or you need to be in court if it changes by then. I don't know.
Yes, Your Honor. Thank you.
All right, so I'm releasing him on his own recognizance. You're being released, sir.
Sorry, guys. Not you.
Good afternoon. Your name?
Good afternoon.
Tell me your name.
Felicia Fordyce.
Miss Fordyce.
Yes, ma'am.
You were arrested in 20 MO 808. for state misdemeanors. There is probable cause. Can we resolve all of her cases, or is there an issue?
Your Honor, I did not look at her out on bond matters. Let me see real quickly. In 5142, and information has not been filed.
Okay, there was an info filed in the 2721, and I don't see any reason why she couldn't resolve that case. Did you want to make an offer on the new case and then the 2721?
Yes, Your Honor.
Okay. Ms. Fordyce, were you wanting to enter a plea today?
Yes, ma'am. Plead not guilty.
Well, I'm not going to do that. So you can enter a plea of no contest to the charges?
Yes,
Okay.
ma'am.
And you would be sentenced today, but I haven't heard from the state what that offer may be.
And if I may have, I'm just adjusting for the out on bond or out on release case, Your Honor. The state's offer on the current case, on the MO case, would be an adjudication 2 days credit time served, and no return to the 7-Eleven.
Okay, yes, ma'am.
On the 2020 MM2721, if I could find out how many days credit, I'm thinking a 5-day offer, Your Honor, but
I think she's got
11 days.
8
For the,
on the.
2020 MM2721.
11 days.
Huh?
11.
11 days?
Yes.
Okay. The state's offer would be an adjudication of guilt, 11 days credit time served. And I need to go back to the beginning of this. But there will be a cost of investigation to the Orlando Police Department in the amount of $76.16. And
In the 2721?
yes, Your Honor.
Okay.
And there would be a no contact with witnesses in the 2721. No return to the scene, which is the Popeyes at 45 North Orange Blossom Trail. Abide by all trespass warnings and court costs.
Okay.
Did you want to go ahead and accept those offers, Ms.
Yes, ma'am.
Fordyce?
Yes, ma'am.
Okay. All right. Did you read the plea form before court?
Yes, ma'am.
Do you have any questions about any of the rights you're giving up?
No, ma'am.
Are you on probation?
No, ma'am.
Do you understand if you are not a U.S. citizen, this plea will subject you to deportation?
Yes, ma'am.
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No, ma'am.
All right. I will accept your plea and MM2721 adjudicate you guilty, sentence you to 11 days in jail. You have credit for 11 days time served.
Okay.
You're not to return to the Popeyes or have any contact with the witnesses. You need to abide by the trespass warning and pay cost of investigation of $76.16 to the Orlando Police Department along with your court cost.
Okay.
And then in 20 MO 808, I will adjudicate you guilty, sentence you to 2 days in jail with credit for 2 days time served.
Okay.
You are not to return to the 7-Eleven. Again, you'll have to pay court costs. All of your court costs will be due by August 5th of 2021.
Okay.
You have 30 days to appeal the judgment and sentence of the court in writing. So, Ms. Fordyce, that takes care of 2 of your cases. You still have another case that's pending, another trespass.
Okay.
When you have a trespass warning, Ms. Fordyce, you have to abide by that. Otherwise, every time they see you on the property, they're just going to arrest you, and pretty soon you're not going to get offers from the state to resolve the case. Do you understand?
Yes, ma'am.
Okay, thank you.
All right, thanks.
No action. No action. Thank you. Sir, good afternoon. Can you hear me?
Yes,
Are you Mr. Rutecki?
yes,
This is 20MO809. You were arrested for open container. There's probable cause. I will, actually, Ms. Bush, is there an offer for Mr. Rutecki?
Yes, Your Honor. It's a two-day credit time served, adjudication of guilt.
Mr. Rutecki, it's 2 days in jail with credit for 2 days time served. Did you want to accept the offer?
I'm sorry, what was that, Your Honor?
If you wanted to enter a plea, the offer is 2 days in jail with credit for 2 days time served.
I have to spend another day in jail?
No, you'll be released today.
I will be leaving today?
Does he have any other cases?
I don't understand.
No. Okay. Yes, Mr. Rutecki, you will be leaving today.
All right, thank you.
So, did you read the plea form before court?
Yes, I did.
Do you have any questions about any of the rights you're giving up?
Yeah, is there a fine that I have to pay
No, you're going to have court costs.
Oh, okay.
You're not on probation, are you?
No,
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
no, not at all.
Okay, sir. I'll accept your plea, adjudicate you guilty, sentence you to 2 days in jail with 2 days credit time served. You'll have to pay court costs, which will be due by August 5th of 2021. And you have 30 days to appeal the judgment and sentence of the court in writing.
All righty, thank you.
Thank you, sir.
Richard Scarborough is medical, Your Honor.
Mr. Matos, do you want to waive his appearance?
Yes, Your Honor.
If you want to reset him, Your Honor, it's possible he'll be here tomorrow.
All right, I'll reset Mr. Scarborough for tomorrow. Okay. Ma'am, good afternoon. Your name?
Hi, my name is Jennifer Acosta.
Ms. Acosta, you're here in 20 CF 8856. You were arrested pursuant to a warrant for robbery with a firearm. I will appoint the public defender to represent you. Ms. Bush, were you wanting to be heard with respect to bond?
Yes, Your Honor. And the state would respectfully ask that the state's argument also stands for the co-defendant's case.
Okay.
The state would ask the court to take into consideration the facts contained in the sworn affidavit for the arrest warrant. In that sworn affidavit, the victim in this matter, who is familiar with Ms. Acosta and identified Ms. Acosta as the person that participated in the robbery in which the co-defendant brandished a firearm. The state would ask the court to find that proof is evident or presumption is great that Ms. Acosta is the person so identified by the victim. She is one of the 2 roommates of the location where the victim was staying temporarily. And the state would ask the court to hold her at no bond as to robbery with a firearm for her participation in the robbery of the victim in this matter.
Mr. Matos, any response?
Yes.
No, ma'am. I'm asking your lawyer.
Your Honor, we would like to have this as an Arthur hearing downtown. We'll leave it at the court's discretion at this time.
So at this time, so are you, Mr. Matos, are you then saying that you don't want the state to have to prove the proof evident presumption great and you want to have the entire hearing downtown? Are you waiving that portion?
Your Honor, I would like them to prove it, but I would also like to reserve for an Arthur hearing. Because I've read the affidavit and the weight of the facts. I don't feel like I'm competent. I'm comfortable enough arguing it here.
Right. So what I'm saying to you though is that at initial appearance, The Constitution requires that the state meet a threshold requirement that there is proof evident or presumption great. You can waive that and have it set, the whole entire hearing set downtown if you'd like.
Your Honor, I would like to hear presumption that the guilt is evident and the presumption is great here and leave the rest of the hearing for downtown.
You want me to make the first finding here today?
Yes, Your Honor.
Okay. The state has met their burden to establish that there is proof evident or presumption great. And at this time, Ms. Acosta's bond will remain at none. Ma'am, your lawyer will need to file a bond motion in Division 19 to see if the judge would like to exercise discretion in setting a bond. You are not to have any contact with the victim, you're not to have any contact with the co-defendant or any witnesses in this case, and you're not to possess any weapons or firearms. Thank you, ma'am. Good afternoon, your name?
Good afternoon. How are you doing?
Well, sir, thank you. Tell me your name.
Mohammed Al Haddad. I'm sorry.
That's okay. Mr. Al-Haddad, you are here in 20 CF 9374. You were arrested for battering a law enforcement officer, resisting officer with violence, and possession of oxycodone. There is probable cause. I will appoint the public defender to represent you in both cases.
Okay. Thank you.
Can we get him qualified for PTR?
Yes, Your Honor.
Yes, okay. I'm going to place him on PTR in that case. And then in 20 CT 4757, you were arrested for DUI with property damage. There's probable cause in that case as well. You are not to possess or consume any controlled substances without a valid prescription, and you're not to drive without a valid driver's license, sir. I'm going to place you on pretrial release at this time.
Did you have conditions for the felony case?
Thank you.
You can add no.
Your Honor, that should also be no controlled substances without a valid.
Correct, yes. Mr. Al-Haddad, you understand that you're not to possess or consume any controlled substances without a valid prescription, in addition to no alcohol consumption, correct?
Yes, ma'am.
All right, sir, thank you.
Yes, Your Honor. I'm sorry. Thank you so much.
Good afternoon, your name?
Dej Deshaun Bowie, how are you doing today, Your Honor?
Good, sir, thank you for asking. You're here in 20 CF 9339. You were arrested for possession of cannabis with intent to sell with a weapon, possession of a concealed weapon by a convicted felon, possession of a controlled substance, and possession of drug paraphernalia. Sir, there's probable cause for the offenses. I'm going to appoint the public defender to represent you. Bond on count 1 will be $10,000. Bond on count 2, $150, 3, $150, 4, $100. And I am not going to take any action on your out on bond case, sir. Thank you.
Excuse me, how much was the first bond, please?
$10,000.
Okay, thank you.
Thank you.
So could you help me get the total of that, please?
I don't know, sir. It's 10,000 plus 300 plus 100.
10,000.
10,400.
Your Honor.
Good afternoon. Are you Mr. Britton?
Yes, ma'am.
Mr. Britton, you are here in 20 CF 9067. You have several cases this afternoon. I'll appoint the public defender to represent you in both. In that first case, you were arrested pursuant to a probable cause warrant for grand theft. Your bond is...
One I was going to court for yesterday? I'm sorry.
No, it's a different case. It's a new case. The case that you are out on bond for is 20 CF 2893. This is 20 CF 9067. Bond is $500. You're not to have any contact with the victims or return to the scene.
Okay.
You have 20 CF 9286. You were arrested pursuant to a warrant for grand theft. Your bond is $500. You're not to have any contact with the victim or return to the scene. And in 20 CF 2893, you failed to appear for court. Your bond is $1,500.
Is that for yesterday? No. Well, how did I fail to appear to court today, sir?
And Your Honor, I'm sorry, I didn't hear that
Ma'am,
bond
I'm sorry.
amount.
How did I fail to appear to court today? I got arrested yesterday at the courthouse.
It's not for today, sir. It was a capias that was issued because you failed to appear for court on June 8th. The bond in that matter is $1,500.
Right,
And then I'm revoking the bond in 20 CF 2893. That's going to be set at none.
Okay.
Thank you.
Okay.
Good afternoon. Your name?
Marsha Brooks.
Ms. Brooks, this is 20 CF 9373. You were arrested for aggravated assault with a deadly weapon. There is probable cause. I am going to appoint the public defender to represent you, ma'am. You are not to have any contact with the victim.
Yes, ma'am.
Ma'am, do you live at the Windsor Cove Apartments?
Yes, ma'am.
All right, you're not to have any contact with the victim. You are not to possess any weapons or firearms. I'm going to place you on pretrial release at this time, ma'am.
Okay.
Can I have her weekly contact, please? Thank you.
Yes, Your Honor.
Thank you, Ms. Brooks.
You're welcome.
Good afternoon. Your name?
Good morning, ma'am.
Tell me your name.
Thomas James Charles Burke.
Mr. Burke, you're here in 20 CF 9362. You were arrested for petty theft with 2 prior convictions.
Yes, ma'am.
I didn't find probable cause in the affidavit regarding the 2 prior convictions. Especially, could you point me to where you might see that?
Your Honor, the state does not see. The state does know that there are prior convictions, but the state does not see it within the 4 corners of the affidavit. The state would ask the court to find probable cause for petty theft.
Thank you, Ms. Bush. Court finds probable cause for petty theft. Bond in that matter will be $500. Sir, you also have 20 CF 9363. You were arrested for burglary of a conveyance, grand theft, 3rd degree, dealing in stolen property, 2 counts. There's also probable cause for those offenses, and I will appoint the public defender in that case as well. Bond on count 1 is $3,500. Bond on counts 2 through 4 will be $150. You are not to return to the scene. You're not to have any contact with the victims, and you are not to frequent any pawn shops, sir.
What is this, ma'am? I don't know nothing about this.
I don't know. You'll have to talk to your lawyer about the facts, and they'll be able to explain to you what this is about.
Can I get an affidavit? I don't even have an affidavit on it.
I don't know why you don't have that, sir. Your lawyer should be able to send that to you. Thank you. Good afternoon, sir. Your name?
Kayvon Celester.
What is?
Kayvon Celester.
Oh, Mr. Cardenius?
I'm sorry, Your Honor, he's in the hospital.
All right. I'll reset Mr. Cardenius for 24 hours after he's released from the hospital. Mr. Celestin, is that right?
Yes, sir. Yes, ma'am. I'm sorry.
All right, that's okay. So you're here in 20 CF 8352. You were arrested pursuant to a probable cause warrant for attempted 1st-degree murder with a firearm, possession of a weapon by a convicted felon, and battery. I will appoint the public defender to represent you. Ms. Bush, did you want to be heard with respect to bond on count 1?
Yes, Your Honor. The state would ask the court to take into consideration the affidavit to issue the arrest warrant. That affidavit contains facts attributed to various witnesses and victims. It also includes still photos of surveillance video and iris cameras that track the defendant's movements and track the defendant's actions at the location of the crime. The state would ask that the court find that proof is evident or presumption is great that Mr. Kevin Celestin, along with Veronica Celestin, who is also coming before the court today, were in fact the people identified as the parties that contributed to and participated in, and Mr. Celestin did possess the firearm and fire the shots at the victim, along with 2 other co-defendants. The state would ask the court to find that proof is evident, presumption is great, that he is the person that is so identified, and hold him at no bond as to count 1.
Mr. Matos?
Your Honor, for Mr. Celestin, we have seen that there's a group of 4 people. All witnesses seem to mistake between it being a Hispanic male or 2 black males. We also see that they can identify that there are 2 females, and sometimes they actually pointed out that one of the females is the one of the males. We see a lot of confusion. This is a burden that goes beyond a reasonable doubt. Here in the final still photos, which they claim that Mr. Celestin comes out in the black shirt, he comes out first, and then a second male comes out. We still don't have a point from any of the affidavit that points out that Mr. Celestin is the man with the shooter. And the opposite, he's wearing a black shirt when he comes out, and the shooter is wearing the top of an orange shirt. At this point, the first still photos shows us a black shirt of Mr. Celestin holding a scooter and an orange shirt of Mr. Johnson, who's the alleged second male, wearing the orange shirt. The presumption at this point does not meet the burden of clear and convincing. It's not clear here. There could be any of the 2 males that shot the gun. Therefore, I do not believe that the state had met its burden to show that presumption and guilt is evident.
Thank you. The state has met their burden to establish that their proof is evident and presumption is great based upon all the information that is contained in the affidavit for arrest. As to bond on count 1, Mr. Celestin, that will remain at none. Bond on count 2 is at $4,000. Bond on count 3 is at $500. You are not to have any contact with the witnesses or victims in this case. You are also not to have any contact with your co-defendants. You are not to possess any weapons or firearms.
Your Honor, the state would ask the court to inquire as to whether or not he possesses a passport.
Mr. Celestin, do you have a passport, sir?
No.
Okay. All right. Thank you, sir. Good afternoon, ma'am. Your name?
Veronica Celestin.
Ms. Celestin, this is 20 CF 8351. You were arrested pursuant to a warrant for attempted first-degree murder with a firearm and battery. I will appoint the public defender to represent you. Ms. Bush, did you want to rely on your prior argument as to count 1 with respect to bond?
I do, Your Honor, to also include the facts that the surveillance video shows her retrieving the firearm, and the information, the investigation also shows that the firearms are, that she is registered with 2 firearms. The state would ask the court to hold her at no bond as to count 1.
Mr. Mato.
Your Honor, at this time, we'd like to have the whole Arthur hearing for Ms. Celestin now.
All right. The defense has waived the requirement to make the state prove that there is proof evident or presumption great at this time, so I will not make a finding. However, based upon the waiver, Ms. Celestin will be held at no bond. As to count one, count two, bond is $500. Ma'am, you are not to have any contact with any witnesses, the victim, or any co-defendants. You are not to possess any weapons or firearms. And ma'am, do you have a passport?
Yes.
You will need to also surrender your passport prior to release from the jail. Thank you.
Your Honor, next on the list, Concepcion Garcia, detox.
Mr. Matos, do you want to waive his appearance or do you want it to be reset?
Waive the appearance, Your Honor.
All right, I'll appoint the public defender in 20 CF 9324. He was arrested for burglary of a dwelling, grand theft, third degree, and criminal mischief, along with dealing in stolen property. Bond on count one will be $5,000. Bond on count two, 100. Count three, 500. Count four, 500. No return to the scene. No contact with the victim. And I'm going to revoke his ROR release in 20 MM 4847. That will be set at no bond.
And Your Honor, the count two was 100.
1,000. Did I? And then I misspoke. It wasn't my intent to. Yeah, it wasn't my intent to modify, so all the bonds will be stayed. Thank you. Mr. Derrick?
Your Honor, next on the list is Derek Desmond, mental health.
Mr. Matos, do you want to waive his appearance as well?
Yes, Your Honor.
That's 20 CF 9346. He was arrested for aggravated assault with a deadly weapon. There's probable cause. Bond will be set at $2,500. He is not to possess any weapons or firearms or have any contact with the victim. Good afternoon. Your name?
Stephen Dione.
Mr. Dione, you are here in case number 20 CF 9386 for driving while license revoked as a habitual offender. There is probable cause, sir. I'll appoint the public defender to represent you. Bond is going to be $1,500, and I am not going to revoke your Osceola County bond, sir.
Thank you.
Thank you. Good afternoon. Your name?
Chair Daltrice Griffin.
Ms. Griffin, you're here in 20 CF 9360. You were arrested for grand theft third degree between $750 and $5,000. There's probable cause. I'll appoint the public defender to represent you. Your bond is $500, ma'am. Thank you.
Okay.
Good afternoon, ma'am. Your name?
Kristen Johnson.
Miss Johnson, this is 20 CF 9384. You were arrested for possession of heroin. There is probable cause. I'm going to appoint the public defender to represent you. Your bond is $1,000. Ma'am, I'm revoking the bond in 20 CF 4971. That's going to be set at none. Thank you.
Excuse me, what?
Your bond and your out on bond case is being revoked.
So I can't get out?
No, ma'am.
Please, Your Honor, please don't take no action.
I'm not going to do that today, ma'am. Thank you.
Your Honor, on the CT case, no action.
No, both.
Huh?
Both.
Both.
Revoke on both.
Just clarification. No action on both cases?
They're
or-
both on both.
Okay, thank you.
Good afternoon, sir. Your name?
Jonathan Keel.
Mr. Keel, you're here in 20 CF 8569. You were arrested for grand theft, third degree. This was pursuant to a probable cause capias. So you're not to have any contact with the victim. You're not to return to the scene. I am going to release you on your own recognizance at this time, sir. You'll need to contact your public defender to make sure you know when your next court date is.
Okay, can I ask a question?
Sure.
Who is my accuser?
This is alleged to have occurred on September 28th of 2018. It's alleged that you stole a sewing machine from Kay Huth.
Could you say that?
I don't know if it's true or untrue, sir, but that's
Okay,
what they're
could you
alleging.
say that last name one more time?
Kay Francis Huth, HWTH.
Okay,
Okay?
okay,
Thank you.
thank you. Sorry, my shoes are a little bit.
Good afternoon, your name?
Good morning, Your Honor. Brandon Alexander Knox.
Mr. Knox, this is 20 CF 9385. You were arrested for possession of methamphetamine, possession of cocaine, and attempted destruction of evidence. There is probable cause. I will appoint the public defender to represent you. Bond on count 1 is 1,000. Bond on count 2 is 150. Bond on count 3 is 100. I'm revoking the bond in 20 CF 4166. That's going to be set at none. Thank you, sir.
Keep it on. Yeah.
Good afternoon, sir. Your name?
Joseph Lobo.
Mr. Lobo, this is 19 CF 10120. You were arrested for sexual battery on a person older than 12 but less than 18. This was pursuant to a probable cause capias.
And Your Honor, the state filed an information for lewd or lascivious battery in this matter. Which is an F2.
I have an
So this-
information. Is there new information that was filed? The information.
Let me see, Your Honor, whether or not it was amended.
Okay, because the one I have was signed on July 11th of 2019, and it indicates they charged sexual battery of a person between 12 and 18.
If I may have just a moment to see.
There was. On 7/18, there was an amended information filed.
Honor. I did not see that. Your Honor, is the court record showing the lewd or lascivious as the final information?
Let me see.
Because I too see another information.
I only see the the last information in the clerk's system is July 18th of 2019.
And that's the one for the lewd or lascivious?
No,
Lewd.
that's battery.
It's for sexual battery?
Yeah, that's what they meant.
And that's the one for sexual battery, Your Honor?
Lewd and lascivious battery.
Yes, Your Honor. Yeah, it was amended to lewd or lascivious.
Yeah, I just don't remember. I didn't think it was a second degree felony, but it is.
I'm sorry?
I was just making sure that it was a second degree felony. It is.
Yes, it is, Your Honor.
Okay.
The other charge was a first degree level 8, so it wouldn't have been a PBL.
Right. I just,
Yeah.
for myself, I just, for some reason, remembered that as something else, but I just wanted to make sure that it was correct. All right. Mr. Lobo, at this time, I'm going to order that you are not to have any contact with the victim in this case. You are not to have any contact with any of the witnesses. You are not to have contact with any children under the age of 18. You are not to possess any weapons or firearms, sir.
I do not, and I don't know who they are.
Pardon me?
I said I do not carry a weapon, and I don't know the victims or the witness yet.
Your lawyer will give you a copy of the affidavit, sir, that describes the facts as alleged.
Okay.
And Your Honor, the state would also ask that there be an inquiry regarding passport.
Mr. Lobo, do you have a passport, sir?
No.
Mr. Lobo, do you live here in Central Florida?
Say that again?
Pardon me?
What was that?
Do you live here in Central Florida?
Yes.
How long have you lived here?
I think back October 29th of 2014.
Okay. And do you have family in the area?
No, they're in Florida. Matter of fact, I haven't even been able to contact them because when I got checked in here, they weren't able to put me on the phone to be able to call for bond or my family to update them on the information.
They do live here in Florida or they do not?
They do not. I have relatives that has property in Florida and a sister in Florida, but most of my family is up in Massachusetts.
Okay. What do you do for work?
Trucker, as of recently.
You're what?
As of 2017, I became a truck driver.
I see. Okay. Where do you drive your truck to?
I'm a considered USC driver, which is on the eastern side of the United States. I've been quite a bit, almost all states.
So you leave the state for work?
Yes, which currently I probably do not have because it's been 2 weeks, so I do not know the status of my employment.
All right, sir. I'm going to set your bond at $20,000. Thank you, sir.
Thank you.
good afternoon. Your name?
Blake Milstead.
Mr. Milstead, you were here in 20 CF 7484. You were arrested for burglary of a conveyance and attempted battery. This was pursuant to a probable cause order. I will appoint the public defender. You're not to have any contact with the victim. You're not to return to the scene. Your bond on count 1 is $1,000. Your bond on count 2 is $100. Thank you. Good afternoon, sir. Your name?
Good afternoon, ma'am. Hewlett Moran Jr.
Mr. Moran, you're here in 20 CF 8855. You were arrested pursuant to a probable cause warrant for robbery with a firearm. I will appoint the public defender to represent you. Ms. Bush, are you relying on your previous arguments?
Yes, Your Honor.
As in the co-defendant's case?
Yes, Your Honor.
Okay. Mr. Matos,
I will also reserve this full hearing, Your Honor.
for the full hearing
Yes, Your
downtown? Okay, so the public defender's office has waived their, or waived the defendant's right to have the state prove that there's proof evident or presumption great at this time and has requested that the full Arthur hearing be had downtown. So at this time, bond will remain at none. Mr. Moran, you are not to have any contact with the victim. You're not to have any contact with your co-defendant or any witnesses in this case. You are not to return to the scene, and you are not to possess any weapons or firearms, sir. Do you understand?
Yes, ma'am. What I don't understand is my right to have probable cause was waived. I don't understand what
No, probable cause was not waived. You were arrested pursuant to a warrant, so it was already found.
Okay.
But your lawyer thinks it's in your best interest to have your bond hearing held in front of the trial judge.
Yes, ma'am.
Okay?
Thank you, ma'am.
And they can go over all that with you.
Yes,
Okay?
ma'am. Thank you, ma'am.
All right. Thank you. Good afternoon. Your name, sir?
Kevin Pate.
Mr. Pate, you have a couple cases this afternoon. I'll appoint the public defender to represent you in all of them. You have 20 CF 9376. You were arrested for possession of methamphetamine. There is probable cause. Your bond is $1,000, sir. You have 20 CF 9377. You were arrested for driving while license suspended. Third or subsequent violation. There is probable cause. Your bond is $1,000. You have an out-of-county violation of probation based upon your arrest here in Orange County. There's probable cause for the violation of probation, and in that matter, your bond will be set at none. I will also appoint the public defender here in Orange County to represent you.
Ma'am,
in
is
that
there,
case.
excuse me, is there any way that you can give me bond for the violation of probation?
I cannot legally, you are a violent felony offender of special concern, and I'm not legally allowed to give you a bond.
So how do I get a bond?
You need to talk to your lawyer about that.
Yes, no.
Good afternoon, sir. Your name?
Eddie Swanson.
Mr. Swanson, this is 20 CF 9375. You were arrested for grand theft of a motor vehicle. I didn't see any facts regarding a mask. Did I miss that?
This is Mr. Swanson, Your Honor.
Yes.
Let me get to that.
Sure.
That page. I do not see anything regarding a mask, Your Honor.
I thought maybe they had just, when they typed it in, hit the wrong arrow probably and
Yes, Your Honor.
populated it. Okay. There is probable cause for grand theft of a motor vehicle, possession of cocaine, and possession of drug paraphernalia. Sir, I will appoint the public defender to represent you. Your bond on count 1 is 1,000, on count 2, 150, on 3, 100. You have 20 CF 7276. You were arrested for sale and delivery of cocaine. Delivery of cocaine within 1,000 feet of a community center and possession of cocaine. This was pursuant to a warrant. Bond on count 1, 7,500. Bond on count 2 and 3, 150. You're not to return to the scene. 20 CF 6814, you were arrested for delivery of cocaine within 1,000 feet of a park. This was pursuant to a probable cause warrant. Your bond is $7,500, sir. You have 20 CF 6825. You were arrested for delivery of cocaine within 1,000 feet of a park. Your bond is $10,000, sir. This was pursuant to a probable cause habeas.
10,000.
Thank you, sir. Good afternoon. Your name?
Warrant Jarvis Tarver.
Mr. Tarver, you were here in 20 CF 7684. You were arrested for grand theft by fraud and false statement to obtain property or credit. This was pursuant to a warrant. You are not to have any contact with the victim. Your bond on count 1 is $2,500. Your bond on count 2 is $150. And I'm revoking the bond in, is it 20?
Ma'am, my grandmother's funeral is Saturday.
2019 CF 16976. That bond is going to be set at none. Thank you, sir.
Your Honor, next on the list, Williams Eric, behavior.
I'm going to find a waiver of his appearance based upon his inability to come to court due to his behavior. That's 20 CF 5258. He was arrested pursuant to a warrant for burglary of a dwelling. He's not to return to the scene. He's not to have any contact with the victim or witnesses. He's not to possess or consume any alcohol or controlled substances without a valid prescription or any weapons or firearms. His bond is $5,000.
And the public defender was appointed, Your Honor.
Thank you very much. Mr. Henry?
He's coming, Your Honor.
Okay.
Right here, Your Honor.
Good afternoon. Are you Mr. Henry?
Yes, ma'am.
Sir, this is 17 CF 14008. It is alleged, sir, that you have violated your probation by not completing your 125 hours of community service and by failing to attend and successfully complete the Batter's Intervention Program. At this time, your bond is set at none. I will appoint the public defender to represent you. You will see Judge Whitehead in the next 7 to 10 days, sir. Yes, sir.
I have my hours for my community service, and I also have my enrollment sheet of me enrolling into the battery intervention classes as well.
Okay. So you are going to want to get in contact with your public defender immediately and provide that information so that they can present that to Judge Wilson.
Okay.
Okay?
Even though everything is already presented to her already?
Sir, I don't know what that says. I don't know what the dates on it and when they were completed, so that's something that would be better handled with the trial judge.
Okay.
Can I say that again? Good afternoon. Your name, sir?
Trevor Herman.
Mr. Herman, sir, you are here. You have 3 cases. I'll appoint the public defender to represent you in all of them. You have 20 CF 9381. You were arrested for trafficking in MDMA with a weapon, trafficking in greater than 10 grams, less than 200 grams of MDMA, possession of ecstasy, possession of a firearm by a convicted felon, possession of ammunition by a convicted felon, possession of cannabis with intent to sell or deliver with a weapon, and possession of cannabis greater than 20 grams, along with possession of drug paraphernalia. Sir, there is probable cause. As I said, I'll appoint the public defender. Bond on count 1 is going to be $50,000. Bond on count 2 is going to be $10,000. Bond on count 3 through 7 will be $150, and on 8 will be $100. You're not to possess or consume any controlled substances without a valid prescription. You're also not to possess or consume you're also not to possess any weapons or firearms. You also have 20 CT 4763, driving while license suspended. There is probable cause for that, sir. Bond will be $100. And then you have 17 CF 17085. It is a violation of probation based upon the facts contained in the cases that we just discussed. There's probable cause for the violation of probation, and your bond in that will be set at none, sir. On the VOP, you'll see Judge Whitehead in the next 7 to 10 days.
Okay.
Thank you.
All right.
Sir, good afternoon. Your name?
Rashard Ned.
Mr. Ned, you are here, sir, in 20 CF 9382 for possessing cocaine and resisting officer without violence. There is probable cause, and I will appoint the public defender to represent you. Your bond is $1,000 on count 1, $500 on count 2. You also have a violation of probation in 2006 CF 16855. This is based upon the facts contained in the new law offense. Bond in that matter is set at $1,000.
So I got born on my probation. I'm saying, ma'am, I haven't had a chance to call my family, man. They got me on PC. I ain't been on PC since I've been in here. I need to just call my family. Can I please have the opportunity?
Mr. Ned, you can call your family, but that doesn't have anything to do with our hearing today.
Yeah, what is it? I understand that, but they ain't letting me use the phone, though. Nobody let me use the phone, though. Can I please get at least a 5-minute phone call?
All right, I'm revoking the bond in 06 CF 16855. That's going to be set at none.
Judge, he has reporting
Thank you.
requirements. Judge, he has reporting requirements.
Oh, I forgot. Mr. Ned, you have reporting requirements, sir, when you are released from the jail.
Say what?
Thank you.
What you said again?
You have reporting requirements when you are released from the jail.
So I'm saying I don't got no bond now?
Not on the case you were out on bond for, no. Thank you.
You're on the next on the list. Reynolds Jody, refused. Court.
Finding a waiver of his appearance based upon his refusal to come to court. It's 20 CF 939. It's a violation of probation. Bond is set at none. 20 CF 9379, grand theft of a motor vehicle. There's probable cause. Bond is $1,000. And 20 CT 4765 is a no valid driver's license. There's probable cause. Bond is $100. Good afternoon, sir. Tell me your name, please.
Terrence Sweet.
Mr. Sweet, you're here in 18 CF 4412. You were arrested for violating your probation
Yes, ma'am.
by allegedly failing to report to probation,
Yes, ma'am.
failing to successfully complete 25 hours of community service. You didn't complete the impulse control class. You haven't paid your restitution, and you moved without getting permission. Those are the allegations, sir. Your bond is set at none. You're going to see Judge Whitehead in the next 7 to 10 days.
Okay.
Thank you.
You're welcome.
Sir, good afternoon. Tell me your name.
Rayshawn Young.
Mr. Young, this is 20 CT 4766. You were arrested for driving under the influence. There is probable cause, and I'll appoint the public defender to represent you. Your bond, sir, is $500. You also have a violation of probation based upon the facts in your case that we just discussed. Bond in the VOP will be set at none. You're going to see Judge Whitehead in the next 7 to 10 days. Thank you, sir.
This time.
Sir, good afternoon.
Good afternoon, ma'am.
Are you Mr. Anderson?
Yes, ma'am, I am.
Mr. Anderson, you're here for an out-of-county warrant out of Seminole County for failing to appear for pretrial conference. The bond is set at $5,000.
Yes,
Sir, I
ma'am.
will reach out to Seminole County to see if the judge in that matter would like to modify that bond amount, or if there may be a plea agreement that could be offered to you.
But ma'am, I called the police and turned myself in.
Okay. All right. Well, sir, as soon as I hear back, either you can post the bond, or as soon as I hear back from Seminole County, I'll return you to court to let you know what the response was.
Yes, ma'am.
All right, thank you. Good afternoon, your name?
Good afternoon, ma'am. Jose Abraham Nieves.
Yes, Mr. Nieves, you're here for an out-of-county warrant out of Osceola County for failing to appear in court. Your bond is set at $7,998. I'll appoint the public defender here in Orange County to assist you and reach out to Osceola County to see if the judge would like to make a modification to the warrant, sir, in the event you're not able to post the bond.
Okay, ma'am. Thank you, ma'am.
You're welcome.
We have Mr. Benton here, Your Honor.
Oh, okay.
And Your Honor, if I may have just one moment to...
Good afternoon, Mr. Benton. Just give me a minute, please.
Basically, to find where I put Mr. Benton's. Your Honor, I don't see any change in the booking report or the intake.
Right. Mr. Benton, sir, you were here in 20 MM 5690. You were arrested for resisting officer without violence.
Yes.
There is probable cause. I'm going to appoint the public defender to represent you.
Yes.
Ms. Bush, are you making an offer to Mr. Benton?
I am not, Your Honor.
Mr. Benton, your bond in this case will be $500.
Yes, ma'am.
Ms. Bush, I'm not sure there's probable cause. It says, I was contacted by detectives to stop the arrestee. That's the only information that there is regarding the stop. I don't know why the detectives asked the officer to stop Mr. Benton.
In this, Your Honor, the state would assert that the probable cause is that there were other officers that were in pursuit. They contacted, radioed ahead to this officer, and then this officer also made commands. This officer who was in his patrol vehicle and exited his patrol vehicle and made commands to Mr. Benton to stop. And Mr. Benton turned and looked at him and continued to run. And a foot pursuit ensued. And Mr. Benton resisted officers by fleeing from the officers, Your Honor.
Mr. Matos?
Well, I see that he asked him to stop, but he asked, we have to have probable cause for the actual arrest. I don't see that here. All we know, like you said, is that he was contacted by the other officers. The other officers did not say that there's any probable cause prior to that, and at least it's not in the affidavit.
Ms. Bush, do you want 24 hours to provide some additional
Yes, Your Honor.
information?
The state could have 24 hours to obtain the probable cause, Your Honor.
Thank you. Okay. I'm going to state the bond at 500 and reset this case for tomorrow.
Your Honor,
Yes.
he's currently out on bond.
I'm not taking any
No
action at
action.
this point. No.
Thank you, Your Honor.
You're welcome, sir.
Morning, Mr. Price. Morning. Mr. Price, I'm looking at a affidavit of violation of probation. It was signed by your probation officer, Mr. Hall. I'm going to tell you what the allegations are against you. It alleges a new law offense violation of Condition 5 for something that's alleged to have happened in Manatee County on January 11th, 2020. I'm going to appoint the Office of the Public Defender if they have not previously been appointed on your case. Have you taken care of that issue in Manatee? Is that still pending?
No, it's taken care of.
It's taken care of? Thanks. What I'm going to do is we're going to accept a denial as the allegations that you violated probation in our case in 2017 CF 2600. Give you an opportunity to talk things over with your attorney. They're going to explain to you your options. If the case is able to be resolved, they can get you back before the court and we can resolve it if you guys work something out that's agreeable with all parties. Otherwise, I'm going to give you a violation of probation status date in the future.
VOP status for September 1st.
All right, so we're going to see you on September 1st, if not before. All right, thanks, Mr. Fry. Do we have Mr. Rivera Alamo?
Good morning.
Good morning. All right, we have Ms. Broadway is in our alternate courtroom. Do you think?
Correct, Your Honor, if you could give me a moment.
All right, thanks. Morning, Ms. Day.
Good morning, Judge.
Mr. Rivera Alamo, we're going to go get your attorney. She's in an alternate courtroom right now, which is where she's supposed to be, but I'm going to bring her up so we can address your case. I'm also looking at Ms. Day, who is the Assistant State Attorney. She's on my computer screen, so we're going to talk about your case in just a moment.
Yes, sir.
Hang with me for just a sec. Sorry for the exercise, Ms. Warren. Need a minute to get situated?
No, Your Honor.
All right.
Just maybe catch my breath. On Mr. Rivera, Your Honor, we had ordered the evaluations. We got one of them back from Dr. Arias. We're still missing the evaluation, the written report from Dr. Goodwin. I did reach out to his office. They told us we would have it next week. I asked Dr. Goodwin to have it by Monday, please. I would ask if the court could set this for Thursday.
All right, so the status that we have a We've got a report from Dr. Duros. When was that? That was back on 6/13,
Correct.
2020. We also have a report back from Dr. Arias, and there was a third evaluation?
There was, Your Honor.
Okay.
There was Dr. Arias is the one from APD, and Dr. Goodwin was actually the court-appointed evaluator.
Right.
The evaluation was completed. We did use the courtroom to do it. I've asked Dr. Goodwin to have it back to me by Monday, because if it comes back that it's competent, then I do have a new offer that I need to convey to Mr. Rivera. If he's incompetent, then we'll proceed from there. So I would ask if the court could reschedule that. I do believe the court moved everything to the 13th.
Yes.
If we could just set it for the 13th, my goal would be to accomplish those things before that date.
Okay. All right, then, Ms. Day, we don't have the report back. Any objection to the court rolling this status date to the 13th of August?
No, Your Honor, and I talked to Miss Broadway last night about everything.
Okay. I'd read the reports. Mr. Rivera, Elmo, we have one more report we're waiting on. We anticipate it'll be back. We're going to bring it back on the 13th, which is next Thursday, and I believe that will be at 9 o'clock. So I'm sorry we don't have news for you today. We'll see you on the 13th.
Thank you, Judge.
Thank you.
Your Honor, I have Montel Castillo up.
Thank you. Mr. Montiel Castillo? Good morning, sir. Do you need an interpreter, or are you good in English?
No, interpreter, please.
Good morning, Your Honor. This is Alan Figueroa, State Certified Spanish Court Interpreter.
Good morning, Mr. Figueroa. This is Judge Carson. Have you been sworn yet this morning?
Yes, Your Honor.
All right, thank you. We have at the podium at our jail facility, Mr. Montiel Castillo. Case number is 2020 CF 1791, and you will be interpreting over our PA system.
¿Me escucha, señor?
Sí, sí, le escucho.
The defendant can hear me, Your Honor.
Thank you. Good morning, Mr. Montiel Castillo.
Buenos días, señor Mantillo Castillo.
Buenos días.
Good morning.
Mr. Montiel Castillo, I am holding an information which is the official charging document in your case. It charges 3 counts.
Señor Mantillo, le estoy mostrando acá el documento acusatorio en su caso que lo acusa usted de 3 cargos.
Count 1 is felony battery, great bodily harm, permanent disability, or permanent disfigurement.
El primero es por agresión física calificada en grado de delito causando graves daños, desfiguramiento.
Counts 2 and 3 are both criminal mischief.
Los cargos 2 y 3 son por destrucción.
Count 1 is a third-degree felony allegation.
El primero es un delito de tercer grado.
Counts 2 and 3 are second-degree misdemeanor allegations.
Los cargos 2 y 3 son delitos de segundo grado.
We're going to appoint the Office of the Public Defender to represent your interest in this case.
Se le asignará a la Oficina de Defensor Público para que lo represente en este caso.
We will be accepting a plea of not guilty as to the allegations.
Se acentrará la declaración de inocente en este momento.
Your attorney will be out to talk to you about what your options are in this case.
Su abogado se comunicará con usted para informarle sobre sus alternativas en este caso.
I'm going to give you a new set of court dates.
Le daré nuevas fechas de comparecencia.
Retrial of November 4th, trial date of November 16th.
4 de noviembre, vista preparatoria. 16 de noviembre, la fecha de juicio.
You will be appearing in court again in November.
Usted comparecerá nuevamente en noviembre.
If your case is able to be resolved, they can get you back before the court before then.
Si se puede resolver el caso antes, se puede celebrar una audiencia antes de esa fecha.
Thank you, sir.
Gracias, señor.
Gracias a usted.
Thank you.
Mr. Interpreter, thank you for your help.
Not a problem, Your Honor.
Shamika Sloan present? Morning, Ms. Sloan.
Good morning.
Morning, Ms. Broadway.
Morning, Your Honor.
Ms. Sloan, we're going to place you under oath.
Please raise the right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Sloan, I have been presented a plea form. It looks like this document. It's 4 pages long. On the last page of the document, there is a set of signatures. One is highlighted in yellow. After each of the 26 paragraphs, there are also a set of initials, and it looks like an S and an S. Did you have an opportunity to read and review this plea form?
Yes, sir.
Did you have an opportunity to go over it with your attorney?
Yes, sir.
Did you understand everything on the document?
Yes, sir. And Your Honor, if I could approach for a moment.
Yeah, come on up. Like to be on the record or off? It's yeah. All right, Ms. Sloan. The document indicates to the court that you wish to plead no contest to, looks like 2 counts, counts 1 and 9, count 1 being grand theft first degree, and count 9 being burglary of a structure. Is that what you wish to do?
Yes, sir.
You understand that count 1 is a first degree felony. It's punishable by itself of up to 30 years in prison, 30 years of supervised probation, or a $10,000 fine. Count 9 is burglary of a structure. That's a 3rd degree felony. It's punishable by up to 5 years in prison, 5 years of supervised probation, or a $5,000 fine. Do you understand those are the maximum sentences for the types of charges in which you're entering a plea?
Yes, sir.
You understand you have a right to have a jury trial as to both of those allegations. At the jury trial, the state of Florida would have to prove to a jury beyond and to the exclusion of every reasonable doubt you committed each element of every offense that you were charged with. At that trial, your attorney would have been with you. She would have cross-examined witnesses and examined evidence against you. You would have had a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, you could have asked the court to make them come to court with a subpoena. You could have testified or remained silent and not testified. That would have been your decision after you talked things over with your attorney, and your jury would have been instructed not to consider that decision in any way in rendering a verdict. You would have had a right to have the trial recorded and appeal any error that occurred in that process. Do you understand you are giving up all of your trial rights? Because if the court accepts this resolution, I will go along with this agreement. We will not be having a trial. You understand those things?
Yes, sir.
Is anyone forcing you or pressuring you into making this decision?
No, sir.
Has anyone made you any promises other than what's written on this plea form?
No, sir.
Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making?
No, sir.
You understand if you're not a United States citizen, entry of this pleas would subject you to deportation.
Yes, sir.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of this plea could subject you to involuntary civil commitment. Do you understand that?
Yes.
Ms. Broadway, does the defense stipulate to a factual basis for purposes of this plea?
We do, Your Honor.
We'll accept that stipulation, find that Ms. Sloan appears to be alert, intelligent. She's had an opportunity to think about the decision and discuss it with her attorney. Ms. Broadway, you satisfied with Ms. Broadway's help?
Yes, sir.
Seems like she's been working awful hard for you. Vindicated to me, no one has forced you or pressured you into making this decision. You do so of your own free will. I'm going to go over some of the sanctions on the plea form. I'm not going to go over all of them. Have you had an opportunity to read and understand all the sanctions that you are agreeing to?
Yes, sir.
Court will adjudicate you guilty as to counts 1 and 9.
Your Honor, if I may.
Yeah.
There's also a 3-page plea and sentencing agreement. Due to COVID, the defendant was not able to get her signed portion of it into the defense attorney in time. Ms. Broadway and I have signed our version of it and submitted it to the clerk, and the defendant is sending hers into Ms. Broadway, and I believe once she receives it, she will submit that to the clerk for filing as well.
I did. I sent it in.
Okay, thank you. I just wanted to place on the record that that is part of the plea agreement.
Understood.
And Your Honor, I can verify that Ms. Sloan and I have discussed all of the conditions in there. And I believe, as she's indicated, she signed it, it's on its way back, and I will supplement the clerk's file with her signed version.
All right, thank you. Ms. Sloan, you understand we're going to be incorporating anything in that written plea agreement, that 4-page document that you signed and is on our way back into your sentence. You understand that?
Yes, sir.
All right, thanks. As to count 1, you will be adjudicated guilty. You're going to be sentenced to 24 months in the Department of Corrections. That is to be followed by 10 years of supervised probation. As a condition of your sentence, you are not to return to the scene where this occurred. You're to have no contact with any witnesses or the co-defendants. You are agreeing to restitution in the following amounts. It's going to be $14,796.33, and that's the Department of what? Finance?
Forestry?
Division of Forestry.
Forestry.
Yes.
That's the Division of Forestry. You're agreeing to $2,300 in restitution to Taylor White. There's a cost of investigation, the amount of $2,708.56, and that goes to whom?
The Osceola County Sheriff's Office.
I'll go to the Osceola County Sheriff's Office. There's a $308 cost of extradition that will be imposed, and court costs.
Court costs of $415, a $3 teen court fee, a $100 cost of prosecution, a $100 cost of public defender lien, including the extradition, cost of investigation, and the restitution. That totals $20,730.89.
Those costs are going to be imposed as a condition of your 10 years of supervised probation. The restitution is joint and several with any co-defendants. There are some other sanctions that are memorialized on the plea form. You are going to remain with us in the Osceola County Jail. You're going to have 30 days from today's date to appeal the judgment and sentence. If you wish to do so, you must do it in writing. Can't afford an attorney, won't be appointed for you. I don't see a sanctions separately as to count 9. Is that time served, or is that a concurrent probation sentence?
It would be concurrent, Your Honor, to, well, it would be just the 5 years, because that's an F3.
I guess it would be 24 months minus the 5 years.
All right.
3.
So I guess that would be, court's going to sentence you to 24 months Department of Corrections as to count 9, followed by 3 years of supervised probation. You are going to get credit for the time that you've already served with us,
239 days.
239 days.
And, Your Honor, I do have a few housekeeping matters. The first of which is Ms. Sloan is from Colorado. Upon completion of her Department of Corrections incarcerative portion of the sentence, she would like to go back to where her mother resides in Colorado. If the court would have no objection to when that time comes for a travel permit while she's pending. I don't want her to be out here homeless while she's pending a transfer. If it's denied, she's aware she has to come back. But just for the interim during the permit, during the approval process, if she could have a permit. And I do believe that the state and I had discussed, and I apologize if it's not memorialized in there, that upon completion of all the conditions, she can apply for early termination. And that would include the payment of all the restitution costs.
Thank you. Ms. Sloan, as part of this plea, the state is indicating that they will not object to an early termination of your probation if there are no subsequent violations and you are all complete with the sanctions and paid up with your financial obligations. I also have no objection to, after you have checked in with probation in Osceola County pending your release, you return to your home state pending your transfer.
Okay, thank you.
And Your Honor, I have no objection. The court, I don't believe the court inquired to the score sheet. I do believe here in Florida she's entitled to a PSR, which we would waive at this time for the negotiated plea.
All right, thanks. We'll accept the waiver of the pre-sentence investigation and state as to counts 2 through 8.
Yes, Your Honor, state would announce a null process to counts 2 through 8 and count 10.
All right. Thank you. Anything further, Ms. Broadway?
Not on Ms. Sloan, Your Honor. Thank you.
Said anything further?
Nothing further. Thank you, Your Honor.
Ms. Sloan, if you need me while you're there, let me know.
All right, thank you very much.
Good luck, Ms. Sloan.
Cortez, Portello.
All right, do we have Jose Martinez?
Yeah, exactly. I'm gonna go. Okay. Morning, Judge.
Morning, Mr. Sauer. We have your client, Mr. Martinez, present.
Okay, he's in the courtroom or?
He is on our jail feed.
Okay. Judge, I pre-trial request a 90-day jail offer.
All right.
Which he signed a plea form for, and I
Who is the state?
I should take it on behalf of the state. Judge, I have the score sheet.
All right, we've got a score sheet. Sauer, you filed the plea form? Is it?
Yeah, I did.
All right, we'll take a look. Mr. Martinez, while we get situated, we're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Mr. Martinez, do we have a score sheet? I mean, plea form?
I don't have anything. Let me look. Oh, it is in there.
Right. Okay, we have a score sheet filed in our file. It indicates to the court that you wish to resolve your case. You're going to print that out. Mr. Martinez, it indicates to me that you wish to plead no contest to driving while license suspended, while that driver's license was revoked as a habitual traffic offender, that you wish to plead no contest to possessing cocaine. Both of those are third-degree felonies, are both each punishable by up to 5 years in prison each, 5 years supervised probation each, or a $5,000 fine each, and that you wish to plead no contest to count 3, possession of drug paraphernalia, first-degree misdemeanor. Is that what you wish to do?
Yes, sir.
You understand you have a right to have a jury trial as to all of those allegations. At the jury trial, the state of Florida would have to prove to a jury beyond and to the exclusion of every reasonable doubt you committed each element of every offense that you were charged with. At that trial, your attorney would have been with you, would have cross-examined witnesses and examined evidence against you. You would have had a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, you could have asked me to make them come to court with a subpoena. You could have testified or remained silent and not testified. That would have been your decision after you talked things over with your attorney, and the jury would have been instructed not to consider that decision in any way in rendering a verdict. You would have had a right to have the trial recorded and appeal any error that occurred in that process. You understand you're giving up all those trial rights because if I accept your plea of no contest this morning, I'm going to go along with this agreement that you've worked out with the state, and we're not going to be having a trial. You understand all that?
Yes, sir.
Anyone forcing you or pressuring you into making this decision?
No, sir.
Has anyone made you any promises other than what's written on your plea form?
No, sir.
Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making?
No, sir.
You understand if you're not a United States citizen, entry of this plea would cause you to be deported.
Yes, sir.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of this plea could subject you to involuntary civil commitment. Do you understand that?
Yes, sir.
All right. Mr. Sauerhaber, are you stipulating to go factual basis for purposes of the plea? Did I lose you? All right. Lost you. He's back. We lost you.
Yeah. I heard you go into the plea colloquy.
All right. Thanks. Last thing I asked was, is the defense stipulating to a factual basis for purposes of the plea?
Yes, Your Honor.
All right, thanks. Based on that stipulation, I'm going to find I have a factual basis with which the court can accept your plea, find that you appear to be alert and intelligent. You've had an opportunity to think about this decision and discuss it with your attorney. Satisfied with his help?
Yes, sir.
Yeah, it seems like he worked you out a good deal. You've indicated to me no one has forced you or pressured you into making this decision. You do so of your own free will. The court's going to adjudicate you guilty as to counts 1, 2, and 3. As to counts 1, 2, and 3 concurrently, meaning running at the same time, you're sentenced to 90 days in the Osceola County Jail. You'll get credit for the time that you've already served.
17 days.
Just 17 days. There's going to be some court costs that you're going to be responsible for upon your release.
Court cost of $415, a $3 team court fee, a drug case fine of $350, a $100 cost of prosecution, and a surcharge of $15 for paraphernalia surcharge for a total of $883.
$883 that you owe upon your release. I'm going to give you a period of 18 months to pay that off. You're going to make regular payments to the clerk of the court collection program. As long as you're making some payments, you'll have no issue with them. If you're unable to make payments, let them know what's going on. They'll try and work with you. If you don't pay and they don't hear from you, they could suspend your driving privileges. Do you understand that?
Yes, sir. Can I pay that while I'm incarcerated?
Sorry?
Can I pay that while I'm incarcerated?
Can you pay it while you're incarcerated? Yeah, you can pay it off. I think they have an electronic way that you can pay, or it can be taken out of a cash bond if you post a cash bond.
Can I do one full payment, or it has to be payment?
I can't hear you so
Can I pay
good.
one time only, or does it have to be paid?
No, you can make payments. You can pay it all at once, you can make payments, whatever you prefer.
There's also a driver's license revocation, I believe.
All right. I do have to suspend your driving privileges on the possession of cocaine allegation for a period of 6 months. I have no objection to you obtaining a work permit should you qualify. 30 days to appeal. If you wish to appeal, you must do it in writing. Can't afford an attorney, won't be appointed for you. Sorry, have I missed anything?
No, I believe that's it, Your Honor. Thank you.
Mr. Tagdiri?
Nothing from the state.
All right. Good luck to you, Mr. Martinez. Thanks.
That's all I have. Thank you, Your Honor.
Yeah. We have Mr. Portela Estrada.
Morning, Your Honor. Alex Johnson on behalf of Mr. Portela Estrada.
Morning,
I'll
Mr.
show you on behalf of the state.
Good morning, sir. All right, I have this for a police status this morning. Any movement, Mr. Johnson?
Your Honor, in this case, I was speaking with the previously assigned attorney on this case. We were attempting to refer Mr. Portela Estrada to the drug court program. It does not look like he wants to accept an offer from the state at this time.
Okay.
I was trying to get an update as to what's going on with court dates for the drug court program. However, the attorney that put in for the drug court and the social services worker that put in for the drug court with their office are both no longer with our office. So I'm trying to follow up as much as I can, but I haven't heard anything back from them.
Right.
I'd be asking if today we could potentially reset this so I can see what's going on with drug court and see.
Have we pre-tried this already?
Not on this case, it looks like. Based on the notes that I had from the previous attorney and discussions.
Judge, we just had pretrial on this case, this past pretrial. I had made an offer to defense. They said they were going to go over the offer with Mr. Portela, and then we were set for police status today. I didn't know about the drug court, so this is the first I'm hearing of it. It's okay.
All right. Here's what we're going to do. I'm going to put it back on. I'm just going to put these cases and leave them on for the trial counter. I'm not sure that we're going to have jurors by September, but hope springs eternal. So we're going to place this on for trial on the September 8th through September 25th trial period. That'll give you about a month.
Okay.
Try and sort this out.
Thank you.
Portela Estrada, we're going to put you on our trial calendar. We're hopeful that we're going to have jurors back sometime in September. If not, your attorney will have some additional instructions for you. In the meantime, he's going to be exploring drug court, see if he can get you there.
I'm sorry.
Thank you, sir.
Yes. No, we've already pre-tried him. Thanks.
Thank you, Your Honor.
All right, thank you.
Your Honor. This is Teodoro Leal, Spanish interpreter. The interpreter has already been sworn. He's here on Jean Luis Diaz, 20 CF 2092.
Morning, Mr. Leal.
Morning.
Let's see where we're at. You're here on Diaz.
Yes, on our calendar, it shows for 9:25 today, our calendar anyways.
All right, we're running a little behind based on us having to switch back and forth.
It's okay, Your Honor. Cherish Adams for the state. I think that's actually supposed to be 9:45, which would make a little bit more sense for the interpreter. I don't think defense counsel is here yet either.
All right.
I'm here, but.
Thanks. All right, Mr. Interpreter, if you can hang out with us for a little bit. I've got some other matters, and we don't have an defense attorney quite yet. Ms. Christie. Good morning.
Your Honor, if Your Honor doesn't mind, the interpreter will take a really quick break. Just had a long hearing.
Not a problem.
But we'll be right back. Like in 3 minutes, the interpreter can log back in.
Yeah, not a problem.
Thank you, Your Honor.
Thanks, Mr. Lamb. All right, we're going to call Jerry Seal. That's 2019 CF 3831. Who's the state on Seal?
Paul Shtagdir on behalf of the state covering for Mr. Abreu.
All right, thanks. Shtagdir, Mr. Kelly's office is indicating a miscommunication. I'm going to reset him for 1:30 this afternoon.
Okay.
I want to see Mr. Seal present at the courthouse. Thank you. And there is.
Okay. Thank you.
Hi, George.
Hello, Ms. Chrysler. We're going to go off the record for just a moment. All right. I do not see Mr. Mills yet joining it. Oh, sorry, Mr. Mills. I didn't recognize Mr. Mills. We're going to call Hector Solano. This is 2019 CF 2349. After this hearing, we're going to switch back to our in-person hearings.
Good morning, Your Honor.
Good morning, sir. Mr. Solano, we're going to go ahead and place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Mills, I have a copy of your motion to set bond in this case in 2019 CF 2349. This is based on an allegation of violation of probation. The probation affidavit indicates a new law offense of a punishable by life crime and charging affidavit 210-57694. Do you anticipate witnesses or evidence, Mr. Mills?
Just my client, Your Honor.
All right, thanks, Mr. Solano. You've been sworn. Mr. Mills is present with me in the courtroom. He's going to ask you some questions.
Mr. Solano, how old are you?
I'm 28, sir.
All right, where would you be living if you were going to be released on bond in this?
I currently reside, I'm renting at a friend's.
Do you have family members who reside in the Central Florida area?
I do.
Who is that?
I have my father. I also have 2 brothers and step family as well.
Do they live in Osceola County?
Yes,
All right. Would they be the ones helping post your bond in this case?
that is correct.
Prior to being arrested, where were you working?
I was working at Westgate Resorts as a culinary assistant.
How long had you been working there for?
I've been working there for almost 7 months.
Do you know if you still have that job if you were going to be released?
I was currently on suspension before the situation. I am not 100% sure.
Okay. If you're going to be released, would you maintain full-time employment?
Of course.
And you would, of course, stay away from the alleged victim in the new case, correct?
Yes, sir.
Does she work there at Westgate?
She no longer works there.
Do y'all live near each other, to your knowledge?
No, sir.
You don't have any children in common or anything like that?
No, sir.
Has there ever been an injunction against you?
I had one injunction prior, but was taken care of. It was for a year.
Okay. Was that filed by her?
No.
If the court were to impose a curfew or, any other conditions of release, would that be a problem for you?
No, sir.
Have you ever intentionally failed to appear in court before?
No, sir.
Will you appear at all of your court dates for this violation of probation and your new case?
Yes, sir.
If the court were to post bond or to set bond in somewhere in the neighborhood of $2,500 to $5,000, something along those lines, do you think that your family could post that along with the bonds in your other case?
I believe so.
Okay. I don't have any other questions, Your Honor.
Thank you. Mr. Taglieri?
Judge, may I approach the score sheet? Charging affidavit.
Thank you.
Mr. Solano, what is the address you would be staying at if you were released?
2540 North John Young Parkway, Lot 22, Kissimmee, Florida, 34741.
And do you have a passport?
No, sir.
Do you have any bank accounts?
Yes, sir.
And how much money do you have in those bank accounts?
I am not aware at the moment right now, sir.
No further questions, Your Honor.
Thank you. Mr. Mills? No, you're right. Thank you. Additional witnesses or evidence, Mr. Mills? Nothing. Thanks. Argument?
Judge, state has one witness.
I apologize.
And Your Honor, if I may question the witness, it's the victim in the new violation case, Lauren Demers, on behalf of the state.
Okay.
The state would call Ms. Nicole Carmona to the stand.
Morning, Ms. Carmona. If you'll come on up to the podium, I'm going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you please state and spell your last name for the record?
Carmona, C-A-R-M-O-N-A.
Thank you, Ms. Carmona. How do you know the defendant in this case, Hector Solano?
We worked together at Westgate Resorts, and then he was my boyfriend from March to May.
And do you remember specifically when you broke up?
May 24th,
And
2020.
I'm sorry?
May 24th, 2020.
And what was the reason for the breakup?
He was upset that I wanted to go see a friend. He became very manipulative and jealous. We've had arguments prior to this. We've had to the point where he's made me feel that he was not the person I wanted to be with. He didn't trust me, and I felt like he wanted total control, so I ended the relationship. As he was driving me and my nephew home, who was 5 years old, he got upset because I told him that I was going to a friend's house in about 4 hours away, and he wasn't comfortable with that. So he got upset and said that he was going to take my car and take all his things from my apartment or my house that I'm staying with at my sister's. And he left me on the side of the road with my nephew, slammed the car door as hard as he could, and walked away. And he left me and my nephew on the side of the road, and that's when I ended things. I climbed over into the driver's seat, made sure my nephew was okay, and I drove home, packed up his things. He came in an Uber to the house, and my brother-in-law drove him back home with all his belongings, and he was no longer residing with us. I blocked him on all social media, and I tried to leave him alone, and he would not. He emailed me, he added me on social media. He was already back at Westgate. I, as a chef de cuisine of the resort, was making more money. He was an hourly employee. I was making $65K.
So they took a
Let
while.
me ask you, when did you guys return back to work?
He was returned back to work prior to the incident on the 24th. So I believe, I don't know the exact date, but he was back early May,
And when did you return to work?
June 5th.
And then the incident for his new allegations, did that happen mid-June?
Yes, it happened the night of the 19th or morning of the 20th, depending on how you'd like to look at it. It was that Friday night into Saturday of Father's Day weekend.
All right, and you reported that incident to law enforcement?
I did.
And
And there was a previous incident at Westgate on the 13th that I reported to security. It did not become physical, it was just verbal, but I called security and he left. But security never reported it, and I feel like that's partial on Westgate, because if they would have reported it, there could have been a mediation between the two of us, and the incident that happened, we would not be here currently.
Right. And then at this point, are you scared for your safety?
Yes, I don't know his mindset. I haven't spoken to him, and this is the first time I'm seeing him since the Saturday before Father's Day.
And are you scared for the safety of your family?
Yes, my niece and nephew,
And who do you currently reside with?
with my sister, her husband, and my niece and nephew.
And,
And he lived with us during quarantine.
okay.
So he knows where we live. Like, we've changed the lock code and stuff like that, but he knew the lock code. He knows where they go to school. Like, I mean, he lived with us. He was family.
And at this point, are you seeking an injunction against him?
I did, and he should have been served yesterday, to my knowledge.
Okay. And was that in Osceola or Orange County?
In Orange, just because I live in Orange, but I do have the paperwork here with me.
No further questions.
Mr. Mills?
Good morning, ma'am. You reported this to law enforcement immediately, right?
I reported it on the 26th. The incident happened on the 19th, morning of the 20th. Westgate had found out after me bringing it to the attention of my executive chef on the 23rd or the 22nd of June, where I was interrogated, and then Hector was called in and he was interrogated, and we were both suspended on Tuesday, the 23rd, prior to investigation. I didn't hear anything. I was not allowed to speak to anybody. He wasn't allowed to speak to anybody. And then on July 1st is when I got fired. The same day he was picked up. I went to speak to Officer Rumbaugh on the 26th, and that's when I pressed charges.
7 days after the incident, correct?
Correct.
All right. This argument over the phone, that was an issue about him wanting to see what was on your phone, is that correct?
Correct. We have been in previous arguments because he was going through text messages. He blocked and deleted 15 people from my phone because he didn't trust, he said he trusts me, but he didn't trust them. So we had a conversation after those arguments and said we were willing to work it out with each other if he would start trusting me and stop going through my phone. So the fact that the night of the argument, he said, why aren't we talking? Why don't you want to be with me? And I said, I am done. Just leave me alone. And he grabbed my phone out of my left breast pocket.
And that was in an effort to look through it, correct?
To look through it because he wanted to know who I was talking to, and also so that I couldn't call for help because he knew on the previous date, on the 13th, that previous Saturday, that I had called security.
Okay. You did not call law enforcement on the previous occasion, correct?
On the 13th, no.
right.
I called security because I was on Westgate property, but since they didn't do anything, that's why I went through law enforcement.
Did you ever attempt to call 911 on June the 19th?
I did, on my work cell phone,
You
and
did?
that's now in custody of Westgate.
All right. Did law enforcement respond?
They did, but during the shuffle, when he pushed me against the car seat, and that's why I bit his neck, the phone fell underneath the seat, so I never got to actually speak to anybody, but the phone was dialed, and they did try to call me back, but I wasn't able to get to answer to speak to anybody because he was tussling in the car, and that's when the phone fell underneath the passenger seat. Because I'm a chef, so my phone was in my left breast pocket, so he had pulled it out, so he already had that. My work phone was in my right pants pocket, so I was leaning over I was in my driver's seat and trying to dial the number, and that's when he reached across, and that's why I bit his neck.
But you're certain that you made a call to 911?
Yes.
And ultimately, when this incident on the 19th concludes, you end up with both of your phones, right?
Correct.
So then why do you wait several days to contact law enforcement?
Protection, Your Honor, relevance?
I waited because I knew he was on probation, and I know he's not a bad person, so I wasn't trying to go after him. But the fact that he didn't listen to the suspension, he was still adding me on Facebook, which I have proof of. He's emailed me. He sent me a box that I have in my car with 300 reasons why he loves me and all these things when we're not supposed to communicate. And he's constantly emailing me and texting me and trying to communicate. I felt like
I didn't know what was coming next. If he already verbally abused me, now he's gotten me suspended. He has put his hands on me. He has made me feel fearful for my life. So I went and pressed charges because I felt like Westgate wasn't doing anything. I tried to go through the job thinking he would go his way and I would go mine. So that's why I pressed charges. After pressing charges, I found out that this isn't the first time he's put his hands on a female.
What, has any of those things that you just mentioned, sending a box and all those things, none of that's happened since he's been in custody, correct?
The box came in after he's been in custody, but obviously was purchased beforehand. There's no way he would have done that, correct? He has not contacted me since he's been in jail, no.
Thank you. I don't have any other questions.
Thank you. Rewrite.
No follow-up, Your Honor. Thank you.
Thank you very much, ma'am. Additional witnesses or evidence from the state?
And from the state judge.
Thank you. Argument?
Judge, we believe that he's eligible for a bond based on the charges that have been filed, since the burglary with the battery was not filed on. There's no indication that he would not participate in the court process. He's never willfully failed to appear in court before. He's got a very limited criminal history. Certainly, he understands the significance of the charges that have been filed against him, or he will when I explain them to him. He wasn't aware that they had been filed when I met with him this morning. But you have a 7-day delay in reporting where there's no allegation of anything violent taking place or frankly, anything other than kind of pathetic attempts to reinitiate a relationship between the time of an incident and his arrest. He was extremely cooperative with law enforcement, even offered a statement to explain the situation. There's a lot of physical evidence that corroborates his version of events. And he's on probation for a drug-related third-degree felony possession case where he received a withhold. So we believe that he should get a bond, Your Honor, so that he can defend his case while not being stuck in jail indefinitely for the time being. And he will reside here in Osceola County. He's got a lot of family members and connections to the community and does not pose a flight risk.
Thank you. Mr. Tagdiri?
Judge, state would just ask that you take judicial notice of the charging affidavit in 20 CF 1863. Judge, we're here. Defendant was on probation and is not entitled to a bond when on probation, and he violated his probation with a new law offense, Judge, which has some very serious allegations. If you read the charging affidavit, you heard from the victim. She said she's scared for her safety. She's scared for the safety of her family. She's seeking an injunction that has been served. As for the delayed reporting, we heard from the victim. She tried to report this through security. She was trying to handle this another way. That didn't happen, so that's why she got law enforcement involved. So, Judge, the state would just be asking that defendant would not get a bond in this case. Thank you. Thank you.
All right. The court is faced with Solano being on probation for a felony allegation. Appears that there's probable cause to believe that Mr. Solano committed a new law offense, which has been filed this morning by information. The court's going to go ahead and arraign Mr. Solano on the new law offense, that is 2020 CF 1863. Mr. Solano, there are 4 counts in the information. Count 1 is tampering with a witness to hinder communication to law enforcement in a second-degree felony proceeding or investigation that is charged as a first-degree felony. Count 2 is burglary of an occupied conveyance. That is a second-degree felony. Count 3 is robbery, sudden snatching. That is a third-degree felony allegation. Count 4 is criminal mischief, a second-degree misdemeanor allegation. Mr. Mills, are you privately retained?
On the VOP, yes, Your Honor.
All right.
I don't represent him yet on the new law.
Thanks. All right, Mr. Solano, the court's going to appoint the Office of the Public Defender to make sure that you have an attorney on board. I am going to accept a plea of not guilty as to those serious allegations, and we're going to give you a new set of court dates to give you a chance to talk things over with your newly appointed attorney. If you wish, you may retain Mr. Mills on these charges as well, and he can substitute in, but I want to make sure that you have an attorney to represent your interests. So we're going to give you a pretrial date.
Pretrial date of November 4th, trial date of November 16th.
Thanks. I am faced with the situation of Mr. Solano being charged with a first-degree felony while he was on felony probation. He's not entitled to a bond. The new felony allegation alleges a crime of violence. I've taken a look at the charging affidavit. Seems to have damage to property as well as what is alleged to be defensive actions by the victim that appear to be substantiated by the physical evidence. The court is going to find probable cause of a new crime involving allegations of violence. Mr. Solano is not entitled to a bond. He will not receive a bond on the violation of probation. So he's going to remain in the Osceola County Jail on no bond on the VOP allegation. As to the new law offense, have bonds previously been extended?
Your Honor, there were bonds, however, the state did file the tampering instead of the burglary with the battery, so I don't know how the jail represents that. It would be slightly different because there's an additional charge.
I think he's entitled to bond on the...
He would be entitled, Your Honor, so I have no objection if Your Honor wants to just clarify the bonds.
Let me take a look at the first appearance paperwork. Thank you, Anna. He was granted a bond of $5,000 on the burglary with assault or battery. That subsequently was not filed. It was filed as a first-degree felony allegation of tampering with a witness. So the court is going to set the same bond amount as to count one in the information, in the amount of $5,000. So he has bonds on the new case, but shall remain on no bond on the violation of probation allegation. Does Mr. Solano have a VOP date?
A VOP hearing date for 9/3, so September 3rd.
Mr. Solano, you have a date for September 3rd. Mr. Mills will be attempting to see if the case can be resolved, if the court is called upon to participate in those discussions. I can do that as well, and he'll get you back before the court if the case is resolvable. Thank you. That's going to conclude our hearing.
Thank you, sir.
Okay. All right, I know I have a number of in-person cases. I also have the, I think I have the interpreter, or I did have the interpreter. Do we still have the interpreter with us? I see Mr. Leal.
Yes, Your Honor, interpreter is still present.
All right, thank you. I'm going to include Mr. Andrade, do our 9:45. At that point, I need to take a break from the jail feed and go do the in-custody or the out-of-custody cases. Let me include Mr. Andrade. This is Mr. Diaz Varela.
Cherish Adams for the state.
All right, Mr. Leal. Mr. Diaz Varela is present at the jail facility. I'm going to put my microphone up to my computer so hopefully he can hear your interpreting.
Yes.
Mr. Andrade, good morning.
Buenos días.
On his behalf.
Buenos días.
Mr. Diaz Varela, we're going to place you under oath. Can you hear the interpreter?
Señor Díaz Varela, va a tener que prestar juramento. ¿Usted escucha al intérprete?
Sí.
Yes.
Mr. Diaz Varela, we are here for a motion, to reduce bond. We're going to place you under oath.
Señor Díaz Varela, estamos aquí para una petición para que se le reduzca la fianza. La vamos a poner bajo juramento.
Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Juro y afirma que el testimonio que hará en este caso será la verdad, toda la verdad y nada más que la verdad. ¿Lo jura por Dios?
Lo juro por Dios.
I do.
Thank you. Mr. Andrade, I've taken a look at the motion. It appears that he was charged with 10 counts, each of them being a first-degree felony allegation. He was granted a bond of $1,000 on each count. Go ahead.
Estoy examinando aquí la petición y al parecer habían 10 acusaciones dentro de ese cargo por delito de primer grado y cada una meritaba $1,000 de fianza.
You wish to present evidence or testimony?
¿Va a presentar evidencia o testimonio?
I believe they were 10 third-degree felonies.
Creo que eran de tercer grado las 10.
Judge, there were actually 10 second-degree felonies. They were each reclassified to a second-degree felony because of the number and type of images. The state did subsequently file an information, and I filed a motion to increase or set bond on the counts that I had filed. So I did file a 51-count information. So it's 50 counts of possession of material depicting sexual performance by a minor. Each of those are reclassified to a second-degree felony because of the nature of the images he possessed, and then a count of production of child pornography, which is also a second-degree felony.
All right, so
Solamente quería decirle que el delito lo había reducido a delito de segundo grado. Esto lo aumenté debido a que habían imágenes. Entonces la Fiscalía interpuso la petición de que más bien se subiera la fianza por los 51 cargos del escrito de acusatorio. Eran los 50 cargos por la representación de donde había sexo con menor, siendo delito de segundo grado, y también la producción de imágenes.
I'm sorry, Mr. Interpreter.
Ms. Adams, was the motion to increase the bond, was that set for a hearing today?
Yes, it was, Your Honor. Your Jay told me that it would be set today, that she just added on for today. Do you not have a copy? I'm happy to email it.
Sí, la petición era para aumentar más bien la fianza. Yo no sé si su asistente se lo dijo, si no le puedo mostrar la copia de que teníamos esa petición de aumentar fianza para el día de hoy.
Perdón.
I can forward the email, our email chain back and forth. That will
I don't
have the attachments.
Voy a enviar el correo electrónico.
Your Honor, if I may be heard,
Yes, sir, Mr. Andre.
I'm just, Your Honor, just to, the interpreter can barely hear Mr. Andre. Just let him know if he can speak louder or augment the volume or something like that. That's all.
is this better? Can you hear me better, Mr. Interpreter?
Yes, counsel, thank you.
Okay. Your Honor, it's kind of a bit of a pickle. I don't know how you'd like to handle it. Oh, Jesus. Am I still there?
Yep.
Yes, okay.
Sí, un poco difícil la situación. Yo no sé cómo su señoría va a manejar este caso.
I don't know if you want to reset this. Here's my concerns and why I say this.
Voy a decir una cosa y ve aquí lo que a mí me preocupa, su señoría.
Obviously, when we were retained by his family. He's a young man, 19 years old, unemployed, which is why we were doing a motion to reduce bond.
Nosotros aquí, obviamente, pues la familia me contrató a mí. Es un muchacho joven de apenas 19 años que no tiene trabajo y por eso era que más bien queríamos pedir que se redujera la fianza.
When we got hired, initially there were 10 counts of what we saw as a third-degree felony. Obviously, yesterday we received from the state the new information, the new charging document.
Y nosotros, por ejemplo, teníamos que el delito era de tercer grado, pero eran 10 cargos del delito de tercer grado. Y obviamente nosotros ayer apenas fue que recibimos el escrito acusatorio de la Fiscalía.
Now we just received it, we printed it out today. It's 52 counts, obviously, of second-degree felonies. It's kind of a horse of a different color, which is fine. Obviously, the state can charge them how they feel is suitable.
Ahora, tome en cuenta que apenas acabo de recibir la información, son entonces 52 cargos con delito de segundo grado. Ya es eso caimán de otro pozo y entiendo que la Fiscalía va a interponer la acusación como lo desee.
Part of the problem is I now have to talk to the family who were barely put together for the initial lesser degrees and lesser amounts of charges.
Y obviamente que voy a tener que hablar con la familia porque ya la familia tenía ya dispuesto que se iban a pagar una cantidad mucho menor por cargos menores.
And see if they still want me to continue with this new voluminous amount of charges.
Y a ver si ellos quieren que yo continúe con este número de cargos tan voluminosos.
If they do, I'll be more than happy to stay on the case, Your Honor.
Y si ellos así lo aceptan, pues yo con mucho gusto voy a permanecer manejando este caso, su señoría.
If not, I also note the PD had been placed on the case.
Si no, pues yo sé que también el defensor público también está en el caso.
Yeah, Judge, I'm not trying to jam up defense counsel at all. I did send, for Your Honor, I forwarded you and copied defense the motion that I filed to increase bond and to set it on the additional counts, as well as a copy of the information so that you had it. The JA did indicate, oh, I'm sorry.
We don't have.
Su señoría, no es que yo estoy intentando de abrumar a la defensa. Yo sí había interpuesto los cargos, yo había enviado las copias a la defensa y yo sí había presentado mi petición para aumentar los cargos, aumentando el número de cargos y con las copias respectivas. Thank you, counsel.
I am so sorry, Mr. Interpreter. So the JA did indicate we were set today for the motion to increase bond. So I think that's my concern, is that he has a much lower bond for something that is now essentially it's a punishable by life offense, which is why I filed the motion that I did.
Yo ya había pues mencionado esto con la asistente judicial, que se había ya indicado que hoy yo iba a interponer la petición para que se aumentara la fianza, porque a mí me preocupa el hecho de que la fianza sea reducida justamente cuando se trata de una pena que se puede sancionar con cadena perpetua. Por eso fue que yo interpuso esta moción.
Ms. Adams, when was the information filed?
¿Cuándo se interpuso, señora Adams?
I believe, Judge, that it was filed on Tuesday. Yes, I was in the office yesterday, so it was filed yesterday, I think late morning.
Creo que fue ayer o tarde de la mañana, porque el martes, pero es que yo estaba ayer en la oficina en la mañana.
We don't have a copy of the information.
No tenemos la copia del escrito acusatorio.
Like it's not actually uploaded on Benchmark yet.
No está en Benchmark todavía.
Madam Clerk is indicating they don't see it on their system either.
Y tampoco aparece en el sistema de las actuarianas.
So
I'm not sure. Yeah, I'm not sure what the delay is there then, Your Honor. So if we need to reset it for a couple of days to allow everybody to have that. I was trying to get it sort of emergency filed so that you would have it for today's hearing, and that's why I forwarded a copy to everybody.
Sí, no estoy seguro por qué el atraso, pero estoy dispuesto entonces de que se recoordine y se postergue por 2 días más para que todos tengan una copia respectiva. Yo por eso había tratado de enviar las copias.
here's what the court's going to do. I'm going to set this for a hearing next Thursday.
Okay, entonces vamos a coordinar la audiencia para el próximo jueves.
I am going to reserve on the request to reduce bond.
Ahora se va entonces el pedimento de reducir fianza.
I am not going to address the request to increase bond until we have an information file.
Y entonces no voy a tratar el asunto del aumento de la fianza hasta que la información ya no tenga los expedientes aquí conmigo.
Ms. Adams, if you feel that this is an emergency situation, you may have this addressed with our admin judge or any judge on duty.
Y señora Adams, si usted cree que esto es una situación de emergencia, usted lo puede entonces llevar a colación con el juez administrativo o el juez de turno.
And that will
Your Honor?
Yes, Mr. Andrade?
What time on Thursday, I ask? Only because I have 2 virtuals at 9 o'clock the 13th already.
¿A qué hora, señor? Porque yo tengo 2 audiencias virtuales a las 9 ya.
Tell you what, if you will, Ms. Adams, if you will contact Ms. Hafner and get a actual time set aside.
Señora Adams, si usted contactó a señora Hafner y ustedes se coordinan la hora.
Ms. Hafner is actually listening in and indicate that I have time at 11 o'clock on Thursday.
Ya está escuchando. A las 11 el jueves, está bien, 11.
All right.
And I'll follow up and see.
Thursday, August 13th at 11 o'clock.
El jueves, agosto 13 a las 11 en punto.
In the interim, I'll speak with the family and see how they want to continue too, Your Honor.
Mientras voy a hablar con la familia, a ver si ellos quieren continuar también, su señoría.
Thank you.
Gracias.
All right, that's going to conclude our hearing for Mr. Varela's case today.
Por eso concluye la audiencia para los señorías.
Mr. Varela, we'll see you back next Thursday.
Nos vemos de nuevo el jueves, señor.
Gracias, señoría.
Mr. Leal, thank you for your tough work on this one.
I I'm sorry.
Good morning, Your Honor.
Ms. Den, you are here for arraignment, and that's on 2020 CF 351. I have the official charging document here. It looks like this. And what it says is it has 3 counts. Count 1 is possession of methamphetamine. Count 2 is petty theft. And count 3 is possession of drug paraphernalia for something alleged to have happened on February 2nd, 2020.
Nicole Dupre on behalf of Ms. Den.
Representative from the Office of the Public Defender, Mr. Dupre, is present with me here in open court. And I'm going to ask the state whether they have an offer of resolution. Mr. Tagdiri, I'm going to put that on your shoulders as I don't have any ASAs on.
Yeah, just as Mr. Brady's case, I don't see that an offer was conveyed yet. Let me look.
Deputy, if we could get word to Mr. Felicier and
Right here,
courtroom.
Judge.
Oh, you're here. Got it. Okay. Ms. Den, we're trying to sort out whether there's an offer to resolve your case.
I just reached out to Mr. Brady, Judge.
Thank you.
Your Honor, I have not received an offer. I don't believe there's one at this time, so we'd be okay with entering a not guilty plea at this time.
All right, Ms. Den, we're reaching out to the state. They're not under no obligation to give you an offer to resolve your case, but they may in the future, and it may be something that is acceptable to you. Mr. Prey, who will be appointed on your case or has already been appointed on your case, is going to enter a plea on your behalf of not guilty, which is fine. You can always change your mind later and come back before the court if you wish to resolve your case. I'm going to give you some new court dates in the future.
Pre-trial date of September 30th, trial date of October 12th.
We'll bring you back on September 30th. If Mr. Prey can work out a resolution that's acceptable to you, we can bring you back before then.
Okay.
All right.
And I'll be reaching out to you, Ms. Den, okay?
Okay, thank you.
Thanks. And the last case, officer?
It will be Samuel Gonzalez.
All right, thank you.
He's on his way up.
Great. After Mr. Gonzalez, I understand he needs to be brought up separately. We will need Mr. Payne-Juan Davis.
No, that's Lauren Demers. She'll be coming up, I hope. Okay. On that case, okay. I'll let her know. Yeah, yeah. No worries. Sorry. You can hear it? Okay. Okay. All right. Thank you.
waiting, could I just address a quick case that was set for 2:30 this afternoon?
Yes, sir, Mr. Johnson.
We had Patrick Gilligan set for 3 cases this afternoon.
Yes.
Looking it up this morning, it appears he's still in custody of the state hospital, so I'd be asking if we could just reset this and
All right.
save the trouble for the afternoon.
Thank you very much. 2018 CF 1583, 2018 CF 3307, and 2019 CF 2098. It appears we do not have Mr. Gilligan in the Osceola County Jail based probably on COVID transport protocols, so we're going to go ahead and cancel that hearing today to be reset by defense.
Thank you, Your Honor.
Thank you.
Lauren will look at it when she. Yeah, she's coming. She'll be. Oh, okay. Lauren's outside the courtroom.
Dumbos, we're probably going to be running about 20 minutes late, so if you could let your doctor know, I'm sorry for the delay. It's a little bit of a delay built in based on COVID protocols.
I will let my office, I can text them.
Thanks.
Thank you.
Yes, sir? No, we just have to wait, but I need to know why she's denied access.
I don't know why.
Because if it's one of the COVID questions, she cannot come in.
I know, she's not answering.
Okay.
Yeah, I will
I'll
call
call
her
down,
again.
if you can give me her name, I'll
Her
call
name is
security.
Rebecca Wright.
Rebecca Wright.
Right.
Okay. Let me see what I can
She
find
may be
out.
needed as a witness.
Let me see what I can find out, because if it's something that she didn't pass the questionnaire,
Right.
then she won't be allowed in.
I'll step out and call her too and see.
I'll also look and see whether I got any communication.
Oh, she is.
They find a veteran. Thank you.
It's a little bit more juggling than what we're used to doing. Pray, Mr. Johnson, the only case I have left is Gonzalez. Is that what you guys are here on?
Yeah, they're done in that one. For the day. Okay. Okay. You're welcome.
All right, we have Mr. Gonzalez.
Yes,
Good morning.
sir.
And officer, we have Painuan Davis and Heath Wright on deck.
Yes, sir. I have them standing by.
Awesome, thank you. Good morning, Mr. Gonzalez.
Good morning.
Mr. Gonzalez, you are here for arraignment. It is alleged that you have violated your probation with a new law offense, a violation of Condition 5 on July 28th, 2020, as well as an allegation that you violated Condition 7 for possessing some material electronically. We're going to make sure that you have an attorney on board. So I will appoint the Office of the Public Defender if they were not previously appointed.
I have an attorney. She called me yesterday.
All right. We haven't seen them file their paperwork.
The I think he's
Yeah.
referencing the PD. He had.
Yeah, no,
Okay.
we have previously been appointed. I'm here covering for Ms. Jimenez, who did contact him
All right.
yesterday, and we'd be entering a denial in this case.
Thank you. So the Office of the Public Defender is aware of their appointment, and they are actively representing your interests. We're going to accept a denial as to these allegations that you violated your probation, and I'm going to give you a violation of probation status date. Your attorney's going to be out to talk to you about what your options are. But this will be the next time that you are on our calendar. If the case is resolvable or there's a change in circumstance, they can get you back before the court before this date.
VOP status date of September 1st.
All right, so we'll see you back on September 1st, if not before.
Okay.
Thank you, sir.
Thank you, Your Honor.
Your Honor, the other two will be here in just one moment.
I appreciate that, officer. Thank you.
That concludes matters for the public defender. May we be excused?
Have a good day. Thank you. Got Mr. Felicier's bond hearing and then Mr. Stumbos's plea. Can we grab Mr. Felicier from the hallway and he'll be next?
I'm here.
Oh, I'm sorry. I keep overlooking you. Everybody's in masks, so it's kind of hard to. Yeah, you can bring in his witnesses. They can sit on one of the socially distanced crosses that we have set up out there.
Thank you. Good morning. I'm good, how are you?
Good.
That's good, I don't need to sign it.
You don't?
Nope, because
Yeah,
it's
I
clean to
mean-
the judge, so.
Yeah, he still, I think, wanted you.
Just got Mr. Davis's
Review.
case.
Washington, your sentence, I think is what is maximum sentence of? 5 years on each
What am I printing out? I'm sorry.
with credit? Or if I'm too close.
Okay. Yeah, it's all F3, so 5 years.
I don't have.
I can't, I'm not gonna sign it because I'm
Okay.
to the bench.
Got it.
I have Gemini. Other than the remand in open court, that's it, other than your, thing. I have the file. Oh, I'm sorry. Totally.
I have
I'm sorry. You're welcome.
Good morning, Mr. Davis. Mr. Davis, can you hear me?
This is Mr. Davis.
Can you hear me?
Yes, sir.
Yes, sir.
All right, thank you. Mr. Davis, your attorney, Mr. Felicier, is present. We are here on a motion to set bond or in the alternative to release you on your own recognizance. We're going to place you under oath at this time.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Mr. Davis, you are in custody. I have a recollection of the previous proceeding. It was a state motion to revoke your bond based on the allegation that you had had hostile contact with the alleged victim as well as possessed a weapon in violation of the conditions of bond. Mr. Felicier, I have read the motion, and do you wish to present evidence or testimony?
Outside of the fact that the state has filed a no information notice on the underlying case,
All right.
I do have 2 witnesses along with testimony from.
All right, thank you. Well, the court will consider the no information notice on the new law offense. Was that the case previously, or is that a new circumstance, Mr. Taggier?
It was the same one from last time, Judge.
All right.
Yeah.
It had been no info the last
no.
time? All right, thank you. All right, Mr. Felicier, when you're ready.
Yes, Judge. The witnesses are coming in shortly, but I'll proceed with Mr. Davis.
All right, thank you, Mr. Davis. You've been previously sworn.
Sir, would you please state your name and spell it for the record, please?
Payne Juan Davis, sir. Payne-WJUAN. Last name Davis.
Mr. Davis, where are you currently?
Osceola County Jail, sir.
And how long have you been in the Osceola County Jail?
70-something days.
And I see that you have a mask on. It's not covering your face, but do you have a mask?
Yes, sir.
And that's a facial mask?
Yes, sir.
Is that a mask that they've provided, the jail has provided for the purposes of this hearing?
Yes, sir.
Do you normally wear a mask in jail?
No, sir.
When you are out in general population with other inmates, are you provided a mask?
Yes.
So you are given a mask while you are in jail?
Yes, sir.
And do you wear a mask?
I do, sir.
Does everyone in jail wear a mask?
No, sir.
In your particular facility, let me ask you this, what part of the jail are you housed in?
F2B, general population, sir.
And in the general population that you're in, does everyone there have a mask?
They do, but not everybody wears them.
Are there enforcement mechanisms for people who do not wear a mask?
Not all the time.
Do you wear a mask while you're in jail?
I've been wearing my mask as much as possible, sir.
How long have you been provided a mask for?
Since I came in.
And when we've seen each other at the jail, have you had a mask?
I believe so.
Did you wear one when we speak?
Matter of fact, at that time, no, I didn't have a mask.
Okay. Now, with regard to the other folks in jail that are not wearing masks, what happens to them for not wearing masks?
Nothing really, sir.
And the people that where do you sleep?
In a cell with another person, sometimes 3 people in one cell.
Currently, how many people do you sleep with?
Right now, just me and another guy.
And are the people that you sleep with, do they wear masks?
Not all the people I've been with.
And
Mr. Davis, we're having a difficult time hearing you, and we are recording your responses, so I want to make sure that there's a clear record of these proceedings. So if you could speak up just a little bit for us, thank you.
Yes, sir.
And how many people at one time are congregated in your particular part of the jail?
It's 32 cells. It's approximately at least 2 to 3 people in each cell. So 32, 64. Downstairs was that?
Are you guys
128 almost.
Are you guys able to maintain 6 feet distance between each other at all times?
No, sir.
And why not?
That just hasn't happened since I've been here at all.
Are you guys physically capable of maintaining 6 feet distance apart?
Not with how many people we have, no. We're not capable of that.
What about staff at the jail? Do they rotate in and out? In other words, do employees leave and return based on their shift?
Every day.
And how many shift change are there in a day?
2.
And are there people outside the facility other than correctional staff that come into the jail?
Yes, sir. I've seen people, attorneys, and different people come in as well.
With regard to any medications that you may be taking or other inmates take, are there nurses that provide that medication?
There are.
And is there more than one nurse or are there multiple nurses?
Several.
And do they wear masks when they see inmates?
Some do, some don't.
Mr. Davis, if you were to be released on your own recognizance or on bond, would you stay with your mother, Marsha Ingram?
Yes, sir.
And to your knowledge, does Marsha Ingram abide by CDC guidelines regarding social distancing?
I'm sorry, I couldn't make out everything you said, sorry.
Sure. Does your mom, to your knowledge, practice social distancing?
Oh, absolutely, absolutely. Yes, sir.
And if you were to live with your mother, well, how many people live at your mom's house?
It's just my mother, sir.
And how big is her house?
3-bedroom, 2-bath, 2-car garage house, about 1,800, 2,000 square feet.
Is there sufficient space inside your mom's house to maintain, perhaps not at all times, but maintain at least a 6 feet apart distance between each other?
Absolutely, sir.
Are you willing to wear a mask and comply by social distancing guidelines if the judge grants a bond and you're out on bond in this case?
Absolutely, yes, sir.
I have no further questions of this witness, Judge.
Mr. Tagdiri? Yes, Mr. Davis, if you were released on bond, would you immediately go and live with your mother?
Yes, sir.
You would in quarantine for 2 weeks, seeing as if you'd just been getting out of jail?
I've been in quarantine a few different times in this jail. We just
right.
came off of quarantine, but
So you'd be willing to put your mother at risk immediately?
Objection, Judge.
So you'd be willing to put your mother at risk immediately?
I don't believe I'll be putting my mother at risk, sir. I've been making sure I've been wearing my mask pretty much the whole time since I had one, at all times.
Yes, but how do you know you're not asymptomatic?
I actually got tested. I went to the medical just yesterday, to be honest with you. They tested me in medical yesterday.
Did you get those results?
Nah, but they tested my temperature and everything, the basic test.
Did they test you for COVID-19 or did they just take your temperature?
They were testing me for something else, but they did check my temperature while I was there the same way they're going to do it if they release me, I believe, sir.
Okay, but you do realize there's other symptoms besides your temperature?
I'm aware, sir.
Okay, no further questions.
Thanks. Redirect.
Mr. Davis, are you currently or have you within the last 14 days suffered from a fever?
No, sir.
Have you had uncontrollable coughs?
No, sir.
Have you had runny nose or flu-like symptoms?
Not at all.
Have you encountered anyone at the jail that you know of that has had these symptoms?
No, sir.
You said you were tested yesterday. Did they check your temperature?
They did, sir.
Was it within normal range?
Yes, sir.
Did they do a exam of your mouth and your nose?
I don't believe so.
Did they otherwise provide any results regarding your testing?
I didn't have no positive results to anything. They checked my temperature, they checked my blood pressure, different things like that, but everything was fine with me.
Thank you.
So, with regard to if you were to be released, would you be able to self-quarantine for 14 days?
Absolutely. I have my
would you be able
own bathroom at the house.
I'm sorry, I interrupted you.
Sorry, I have my own bathroom, own private entrance, everything in the house.
So, with wearing protective gear to include a face mask, you'd be able to have your own part of the house and remain self-isolated for at least 14 days?
Yes, sir, that's not a problem.
I have no further questions, Judge.
Thank you. Additional witnesses or evidence, Mr. Felician?
At this time, I called Marsha Ingram.
Thank you. Good morning, ma'am.
Good morning.
We're going to place you under oath. I need you to speak into that little microphone so we can both record you and so everyone can hear you.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And would you please state your name and spell it for the record?
Marsha Ingram, Marciaingram.
And Ms. Ingram, are you related to the defendant in this case?
Yes, I am.
And what's your relationship?
I'm his mother.
Where do you live?
4941 Lazy Oaks Way, St. Cloud, Florida, 34771.
Is that a home, townhouse, or apartment?
It's a home.
How large is your home?
It's pretty close to 1,900 square feet.
And how many rooms does it have?
3 bedrooms, 2 baths.
Do you live with anyone else?
No.
Do you practice social distancing?
Yes.
What do you do to practice social distancing?
I have my mask on, and the house has a split plan, so there's a bath on both sides of the house. So if there's someone else there, it would be my son. He would be on one side of the house, and I would be on the other. And yes, I wear my mask.
And do you also apply hand sanitizer?
Oh, yes, I have that.
Do you
have shoe covers.
I'm sorry?
I say even have shoe covers.
And why do you share that?
I'm just germophobic, I guess. Yeah.
So you go above and beyond with regard to making sure that you are not in contact with surfaces that may contain germs.
Correct.
If Mr. Davis were to be released either on his own recognizance or on bond, would he be able to safely keep at least 6 feet distance between you and him?
Yes, sir.
For at least 14 days?
Oh, yes, yes. The house has a split plan, so the only common area would be the kitchen, and we can always alternate who's in the kitchen.
Ms. Ingram, if the judge were to grant a bond in this case, what bond amount would you be able to afford?
$100?
I have no further questions, Judge.
Nothing from the state, Judge.
Thank you very much for that information, ma'am. Additional witnesses or evidence, Mr. Felician?
Ms. Davis-Blatz, Judge.
Thank you. Good morning, ma'am.
Morning.
I'm going to place you under oath.
Okay. Please raise your right hand. Your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God? Yes, I do.
Ma'am, would you please state your name and spell your name for the record?
Crystal Flats, and it's Kristalflatts.
If you'd be more comfortable at that microphone, you're welcome to use that.
Okay. That's better. Thank you so much. Okay.
Of course.
Ma'am, are you disabled?
I am.
And what disabilities do you have?
I about a year ago, I had a stroke. I have high blood pressure. A couple other things. I recently had surgery in my hand. There's just a couple different things.
And
But the stroke has left me paralyzed on my right side.
I'm sorry, I'm having a hard time hearing you.
I'm sorry. The stroke left me paralyzed on one side, on my right side.
And is that the reason why your medical condition, is that the reason why you need the assistance of a walker?
That is correct.
And is that what you came to court with today?
Yeah, couldn't bring the wheelchair.
I'm sorry, Your Honor, defense can't be heard.
Need to get you by a microphone. Mr.
And is that the reason, is that how you came to court today?
Yes.
And is the assistance of, what would you call it, a walker?
It's a walker.
Is it with the assistance of a walker that you manage day to day to make your daily errands or to move around?
Yes.
With regard to Mr. Davis, did Mr. Davis assist you in your daily tasks when he was out of jail?
Yes. My daily task, he assisted me with my appointments. He assisted with like medication. I'm very forgetful. All of a sudden, like my brain used to be like this, but I'm a little bit slow now. So he did assist, yes.
Okay. Now you mentioned that you're a little bit forgetful and a little bit slow now. Is that attributed to the stroke?
Yes.
How are you being assisted now while Mr. Davis is in custody?
Mom?
And who is mom?
Mrs. Ingram, I'm sorry. I'm sorry.
That's okay. And how does she assist you?
Boy, let me start. Every which way. She helps me get to my doctor's appointment. She helps me with the kids, her grandkids. She's everything.
Are the tasks that she helps you with the tasks that Mr. Davis would normally assist you with?
More or less the same thing, but just a little bit different.
With regard to getting to your doctor's appointments, would Mr. Davis be the one that you would rely on?
He would assist, yes.
Let me ask you this, do you have any family members that live here in the States?
My mother lives in Trinidad, overseas. My family is up north. So my family here is Miss Ingram and Mr. Davis.
And Miss Flats, do you recall an incident that happened back in May of 2020 of this year?
Yes.
At any point, did you speak with the officer in that case?
Very briefly.
When you spoke with him, did you write a statement?
Well, I couldn't write because my right hand, so it's hard for me to write. So I did tell him the first 3 things I told him is that he came in around 9 o'clock. And I said, what do you do? No, I actually used a bad word. I said, what the F are you doing here? Because I know at that time he's at work. And then the officer asked me to write a statement. And I said, well, I can't write. And he said, okay, I'll write it for you. And I said, thank you.
At any time, did you tell the officer that Mr. Davis had a knife?
No, no,
At
not at
any,
all.
at any time, did you tell the officer that you had seen Mr. Davis, or had heard Mr. Davis, pulling out or doing some kind of movement that would have indicated to you that he had a knife?
No,
Was there anything with regard to a weapon in general? Did he possess any weapons?
no,
Did you
no.
tell the officer at any point that he did indeed possess a weapon?
No, I didn't even know about it. When the officer told me about it, he just asked me to look up. Well, I'm short. So when you say look up, I'm looking, and he said no. He said up there. And that's when I saw the knife. But he never asked me, and he said, did you see him with a knife? I said, no, absolutely not. I said, he would never do anything to hurt me.
Did you believe that Mr. Davis had a knife?
No, that's a fishing knife. That knife, we have, those are my knives, they're our knives, but that's what we use to like clean the fish.
Okay, so how large is this knife?
Like 3 or 4 inches.
And for the record, Ms. Davis Latzo was holding up her hand as a measuring reference. I have no further questions, Judge.
Thank you. Mr. Tagdarian. Ms. Flats, did Mr. Davis have permission to be in the home?
Mr. Davis? Well, I think he thought something was wrong with me. He wasn't supposed to be there. He was supposed to be at work.
But did he, you wrote in your statement that he did not have permission to come in.
I didn't know he was coming in. I didn't write that he had no permission. I didn't give him permission, but he heard the crashing of me falling. And so he wanted to come to see what was wrong with me.
How did he hear the crashing of you fall?
I fell in the house. I fall. It's unfortunate, but that's what happened.
But where was he that he heard you? Wasn't he?
He was in the garage.
Okay. And was he supposed to be in the garage?
It's our home. He has a garage opener, but there should have been nobody there, but I don't have a problem with him being there.
On the statement, I know you didn't write it, but you reviewed the statement before you wrote your initials, correct?
No.
So, may I approach the witness, Judge? Yes. I'm showing witness the statement she wrote. Those are not your initials?
No, they probably are. I haven't, when they left, this is what I wrote. I swear to God, around 9 o'clock, he came through the door. That the rest is not my handwriting, the only thing, but I tried to write, and what I told the officer is it's very painful, and I said, I can't write anything. And he said, don't worry about it, I'll write the rest. This is the one sentence Crystal writes. The rest of it, fine, who write that?
Okay, I know, but you didn't review what they wrote before
I never reviewed, and honestly,
initialed?
no, that wasn't filled out in front of me. When we were speaking at the counter in the kitchen, he asked me to write. I started, but remember, I had just fallen. So I was kind of like shaky. So I'm trying to write, but then he asked me to write everything that happened word for word. He would have been there all day. I said, I cannot write this right now.
Thank you. No further questions, Your Honor.
Thank you. Redirect.
No redirect, Judge.
Ma'am, I have a couple questions. When it was pointed out to you that there was a knife in your garage, was the knife, how was that placed? Was it stuck into the wall?
It was stuck into the wall.
Thanks. And is there a DCF plan in place regarding your son?
There is.
All right. Thank you. Are you a party to that DCF plan?
Of course.
You are. Okay. And is that going through the dependency system here in Osceola County?
A dependency? No.
No? Okay. So
I don't
it's...
know what the dependency is, but I am the, what do you call it? The caregiver
Right.
for my children.
Has DCF put any tasks for you to accomplish?
Yes, they have. Yes, they have.
Okay. All right. Do you have a caseworker?
I do, Miss April.
Does the child have a guardian ad litem?
Yes, Michelle. I
Okay.
spoke to her yesterday.
All right. Thanks. But you haven't had any court hearings, is that right? On them?
Yeah, we have.
Okay. So you go in front of Judge Schaefer?
Laura Schaefer.
Mhm.
That is correct.
Okay. All right. Any follow-up questions?
Yes, sir. Is the plan with regard to the DCF case plan, is the ultimate goal reunification?
That is correct. That's, yes,
I'm sorry?
that's what they call it. They want to reunify the family.
Okay, no further questions, Judge.
Mr. Aguirre?
Nothing from the state, Judge.
All right. What's the contact agreement in, that Judge Schaefer has put in place?
He cannot see the children, he cannot see the children without supervision
Right?
by them. And I don't have anything against me. So April knows that he was taking me to when I used to go. Since COVID, everything's crazy. So I just tried to, you know, not go to physical therapy and stuff. But he cannot see the children without them saying so.
Are you guys allowed to cohabitate together?
Yes, we are. Like,
Does he live at the house?
oh, no. He lives 4941 Lazy Oaks Way.
Okay.
The house consists of me and my children.
Do you have family members that could, if he wished to have visitate, well, he visits through the DCF folks, right?
Yeah, he has to visit through, but I've been trying to get mom appointed as that person because it would be easier, because remember, I don't got nobody but them.
Right. How old's your son?
My son is 15,
He's 15?
yes.
All right. With this latest event and finding the knife sticking out of the wall, do you have any concerns for the safety of your son?
No, because here's why. Mr. Davis would not do anything to hurt me. I know he got in, he's been, wrapped up in this going crazy. I'm not concerned about the knife. It's one of our fishing knives. My daughter goes to my tackle box and she dumps it out. So that's not the only hole that's in our garage. That was the one that I saw that day. But sometimes, like when we come from fishing, I can't do nothing with this hand. But like sometimes, like if she dumps it out, I'll pick up like some of the hooks and stuff like that, and I chuck it in the wall because it's easy for me to get. But I mean, we stuck things in the wall before, but not that day. You know what I'm saying? I'm not scared. He doesn't need to be there, Judge, because if he's fighting a battle, he can fight it at home. He don't have to be around people that could get him sick, that could maybe make him die. If he's a violent criminal or something like that, I need him home. I need him making money. I'm struggling. I pay all my bills with the help of mom. And honestly, I need help because I'm feeling that she's doing everything. It's not fair. If he was sitting there and they said, okay, tomorrow you have to go to jail, you did this, yes, he gotta go. But he's just sitting there taking up space when he could be home helping his mom, who's helping me.
Thank you for that information. Any follow-up questions?
Nothing from the state, Judge.
Nothing from the defense, Judge.
Thank you very much for your testimony. Any additional witnesses or evidence?
None from the defense, Judge.
State?
Nothing from the state, Judge.
All right. Thank you. Thank you, ma'am.
Okay.
Take your time. Mr. Felicia, argument?
Judge, outside of what's in the motion, I have no additional arguments outside of what's in the motion.
Mr. Tagdarian?
Just renew my arguments from the last hearing.
All right. Mr. Felicia, I am not the least bit compelled by the argument regarding COVID-19. Your client has pretty much indicated that he's got no symptoms. There's been nothing presented that he's of substantial risk. He's got access to medical intervention and has indicated that he's taking all precautions. There's nothing to indicate that the jail population is at any greater risk than those folks who all have masks sitting in this courtroom. So I'm not persuaded by the argument as to COVID-19. What is persuasive to the court is we've had an opportunity of the one and only witness that was present for the event to come in and give additional testimony. The court does find the additional testimony to be persuasive. It gives the court additional information with which to make a determination as to whether the motion to revoke bond was warranted. The court had indicated at the time Mr. Davis was taken into custody that the court would consider additional information. Been sworn testimony, although the witness is not the alleged victim, that is the 15-year-old son. The court notes that Department of Children and Family, as well as a dependency case, has been enacted, that the child has a guardian ad litem that will advocate on the child's behalf. Mother has testified that the child is not, she doesn't consider that the child is in danger. The court is inclined to consider a bond on the case. The condition will be that he not return to that home and will include a monetary bond. Do you wish to be heard as to monetary bond?
I think there was testimony, yes, Judge. I think there was testimony with regard to what the family can afford. I believe it was the mother who said $100, so $1,000 bond, Judge.
Thanks. Was there an information filed in this case? The underlying information, Mr. Tegder?
Yeah. In which case, Judge?
Case that
That'd be 2020 MM 1214.
That case was dropped, Judge.
that case was no info. I'm talking about 2019 CF 4032. What was the original bond amount?
The only charge that was filed, Judge, was the battery on a law enforcement officer.
Okay. What was the bond in that case?
One second, Judge, let me look it up.
Thanks, I've got it.
I have, Judge, that the original arrest charges were child abuse, and there was a $5,000 bond, and then battery, there was a $500 bond, and then aggravated battery, Leo, in which the defendant was released on his own recognizance.
All right, thank you. The child abuse allegation was apparently not filed by information. The battery allegation was not filed by information. The new law offense has been no infoed, so it finds that the state's in the best possible position to weigh those strengths and weaknesses of the case and have chosen not to move forward with prosecution. The court has heard from the original alleged victim. However, that criminal offense was not charged. The court's going to agree to set bond in the aggravated battery on a law enforcement officer. Bond will be set in the amount of $2,500 with the special condition that currently there is a DCF intervention at the scene of the offense on the bat Leo. The court's going to order that he not return to that house, not go within 500 feet of that house. He may continue to have contact with the mother. The court will expect that the DCF orders under the dependency case are followed. Mr. Davis, you may not possess any weapons. Do you understand?
Yes, sir.
All right. If a weapon is found on you or around you and attributed to you, the court would consider that an egregious violation of your bond, and the court will again find itself in this circumstance.
I will not. I don't possess weapons, sir. I will not have no
All right.
weapons, sir.
And wherever the minor child, LD, lives, you may not go within 500 feet of that house. Do you understand? Until
Yes,
this
sir.
is resolved?
Yes, sir.
Anything further, Mr.
Just,
Solicitor?
until this is resolved, are we referring to this particular case or the DCF case?
As far as the conditions of bond, if this case is resolved, I got no more authority over the conditions of bond. He's obviously ordered to comply with any DCF and will suffer the ramifications if he chooses not to.
Yes, Judge.
All right, thank you. That'll conclude our hearing.
Judge, do we have any court dates for this? Or?
Are we set?
We're not set. We would have to set it for trial.
I'm going to give it a pretrial date while we're talking. Pretrial date is going to be August 25th with a trial period that begins, when was this case filed?
This case,
I want to short set it.
December
December of 2019.
It hasn't got a pretrial date yet? Pretrial is going to be August 25th with a trial period that
Well,
begins.
this might have been one of those cases that we pre-tried and then it didn't get a trial date, so.
We give it a new pretrial date, August 25th with a trial period that begins October 12th through the 30th.
Excuse me, Your Honor.
Yes, sir, Mr. Davis.
DCF came to see me while I was here. And,
Yes, sir.
They're basically trying to close out the case so we could be back as one. So how does that work if there's no court date for the future?
Yeah, it's a reunification plan. That's between you and Judge Schaefer. You should have been appointed an attorney if you qualified to represent your interests in the dependency case, if there is an active one. So that's really a question for that attorney. Maybe Mr. Felicier can sort that out for you, but I don't have any additional information for you. I'm sorry.
Thank you, sir.
Yes, sir, Mr. Davis. Good luck.
Thank you so much. Thank you.
Thanks. Mr. Stumbos, thank you very much for your patience. Mr. Davis, we're completed with your hearing. You do have a bond on the one and only count with those special conditions.
Thank you so much, Your Honor.
Thanks.
Look better for questioning purposes, if that's all right.
All right, thank you.
Your Honor, this is the case where they filed the third amended BOP affidavit that he hasn't been technically arraigned on.
Mr. Merce, is there an amended affidavit that you're aware of?
Yes, Your Honor. There is in total 4 VOP affidavits, a regular affidavit, and an amended 1, amended 2, and amended 3. The third amended VOP affidavit alleges the new law violation. That would have come in around the beginning of June.
Judge, I don't have the amended violation of probation on the new law violation.
It's in the court, it's on benchmark. From what I can see, it's line 138. It's highlighted, filed on 6/4/2020. Third amended violation of probation.
All right, Mr. Stumbos, I'm showing a third amended violation, affidavit of violation of probation stated 6/4/2020 by Officer Pena.
Is there a copy in the court file that I can peruse?
The sole amendment is the violation of condition 5/2020 CF 1499. Is that correct?
That's my understanding, yes, Your Honor.
And that's the new law violation?
Oh, yes.
Yes. Here, I've got a copy of it, Mr.
Well-
Stumbos. I just need to know which affidavit he's,
Judge, I can tell you.
it doesn't encompass any condition 5 violations anyway.
We are not going to be entering a plea to an amended violation of probation that includes that arrest. My understanding was we're moving forward with an amended, with a violation of probation without the new law arrest. Unless the court, through indications that it has not been filed, somehow agrees that that's not going to be a part of the sentence. I can't admit to the new law violation arrest, Judge.
I don't know if it fundamentally makes a difference. If there's an admission to violation of probation, there's an admission. I don't think there's a requirement that the defendants admit each and every one of the allegations.
At this time, Your Honor, the state's not in agreement to dismiss that violation of probation. It was my understanding this was a plea to the bench as charged to all of the violations, which, I mean, defense was on notice that he had picked up a new law. I'm sorry that, I don't know why the amended affidavit didn't make it over to defense. It's been in the court file since June 4th. But the state, I mean, the state's not agreeing to dismiss that right now because it was my understanding that he was pleading as alleged in all of the violations. I don't know, I don't think that the state would necessarily turn around and use that admission to then file formal charges against him. I don't think that would be the case. I'm not that prosecutor, but.
Yeah, but Judge, fundamentally, we never saw that. I can tell you that right now. We've pulled up everything we can, and we're working out of the house a whole lot. I understood that, and just with some discussions we've had with the state, when the no information had been filed, I assumed nobody's pursuing a violation of probation on a new law violation.
That was not a conversation that was had. It's always been that you guys were going to enter the plea, so.
Do we want to take some testimony from Dr. Danziger and the detective, or do we want to reset this for another day? I'm happy to work through lunch.
Let's take some testimony from Dr. Danziger, Judge.
I'm inclined to accept the admissions on 1, 2, 9, and 7. I'm not inclined to accept a best interest admission. It does not encompass the new law offense. So either he's going to admit, Mr. Stumbos, that he violated probation for conditions 1, 2, 9, and 7. Well, I understand a best interest admission is important when there's an allegation of a violation of condition 5, because he doesn't want to violate his constitutional rights by admitting the allegations or the elements of a new law offense. So why is he pleading best interest on counts 1, 2, 9, and 7?
Judge, I'm sorry?
Why is this a best interest admission?
Well, Judge, a couple things. One, on condition 1, on the failing to report,
right?
My client and actually went over some phone records with Mr. Steinmeier. He did not appear, but he did make phone calls there on July 3rd. So kind of in mitigation, and considering, Judge, that these are, per the statute, the lowest level violations, and it is a third violation of probation, I don't see it as that material, whether it's 1 or 2 or 3 different violations of probation that are at the lowest level. You know, he didn't report, but he certainly called. Officer Steinmeier knows that. Then when you go to condition 2, we have caught up that money and have paid the cost of supervision.
Right.
And so then we go to condition 9, on July 26, 2019, I showed Officer Steinmeier some phone calls, and I don't think we're in disagreement. His file shows that he made some calls to him. He spoke to another probation officer. So we have confusion present, and Officer Steinmeier indicates my client did speak on the dates that we're talking about in August, but spoke to a different probation officer, and then he was supposed to show up for probation, which supposedly he did not do. Then we're sit with violation of condition 7, which is the intoxicants. That's really, in my estimation, the fundamental admission there. You know, he admitted, you know, a day later, called him up and said, yes, I was, you know, I did use. And that's kind of where we're at, why it's, quote, best interest on 1, 2, and 9. And in essence, 7 to some degree from the perspective of what Dr. Danziger is going to say in view of his mental health issues that's been diagnosed.
All right. The best interest admission is a little bit of a legal fiction that the court allows for violations of condition 5 so that there's not an unintentional admittance of elements of a crime that have yet to be proven beyond and to the exclusion of every reasonable doubt. I don't think I've ever taken a best interest admission on technical or substantive violations other than a condition 5 allegation of additional law offenses. So you want to have that discussion with Mr. Wright? Either he's going to admit that he violated probation and the court will try to determine a sentence, or he's not. And I don't have a preference which.
But you're okay with not pursuing the new law violation or seeking any admission or any plea on that?
Correct.
Okay. I'm okay with that, with regard to admitting these violations. The fact that he didn't appear, Heath, that you didn't necessarily appear when you were told, it's mitigation that you made the phone calls for probation, but it doesn't.
Yeah, he won't be able to hear you, Mr.
Oh, okay.
Yeah, I can't hear it all, sir.
Sorry. Okay. Thank you. I appreciate it. Can you hear me, Heath?
Yes, sir.
Thank you. Mr. Wright, couple things. You and I had talked about admitting the violations of probation that dealt with failing to report, remember, on June 6th?
Yes, sir.
And you were then told to report to probation on July 3rd,
Yes, sir.
correct? And
Yes, sir.
you recall discussing entering a plea, meaning admitting that. The judge has indicated not a best interest plea, but in essence an admission, which says, hey, I didn't go there. But you also have told me repeatedly, and phone records that I've reviewed show that you actually did call over there, but you didn't go.
Yes, sir, that's correct.
And the only reason you're offering that those calls, and Judge, just for time purposes, you admit that you didn't go there, but you did call.
Yes, sir.
All right. And then the second one is, that I'm looking at, is there's some cost of supervision of $411.26 in arrears, meaning owed for September 6, 2019. You remember owing that?
Yes, sir.
You also remember that when I received money from you and your family, that has been paid in full.
Yes, sir, correct.
But at the time, you had owed it when the violation had been filed.
That's correct, yes,
So
sir.
are you okay to enter an admission to that offense?
Yes, sir. That's
All right. So the next one is, you were supposed to call, on July 26th, the offender instructed to call Officer Steinmeier to make an appointment in August, correct?
Yes, sir.
And you recall, per my discussions with you, in the August calls, you admit that you made a couple of one-minute calls over there, correct?
Yes, sir.
But did not get a hold of him.
Correct, that's correct.
All right. And then there's a third call, or another call that you made on the next day, August 27th. Do you remember that?
Yes, sir.
All right. So again, you didn't set an appointment in August for whatever reason, and it is the lowest level violation in my opinion, actually per the statute. And I indicated to you that, are you okay with admitting that violation?
Yes, sir.
Okay. So the next one is the meth case, meaning the use. And you have indicated to me on or about August 26, 2019, Officer Steinmeier questioned you about that. You initially denied it, correct?
Yes, sir, I did.
And then you subsequently were told, look, think about it and let me know. And you proceeded to call next day or two and indicated that you unfortunately had used meth.
He actually, sir, he told me that he was going to find out when the test results come back. And like you said, I told him that I had no, I didn't use nothing, and I left out of the office, and I made it home to my house and sat in my truck and decided that I couldn't go without calling him and telling him the truth. I had to tell him the truth, so I called him back as I was within an hour and told him that I did use, I screwed up, and I was sorry, and to please.
And that was the one and only time you had used?
Yes, sir, positively.
Okay. And I understand it was because of, I guess you were stressed over a breakup.
Yes, sir, I was having a hard
So
time.
are you okay with entering a plea to that, to the judge?
Yes, sir, I am.
All right.
All right, thank you, Mr. Wright. We're going to place you under oath.
Yes, sir.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, I do.
Mr. Wright, you're going to be presented with an admission of violation of probation form. You're going to sign it before the sentencing. I want you to go over it. Have you had a chance to go over each of the paragraphs with Mr. Stumbos?
No, sir, I haven't.
On the phone?
Oh, yes, sir. Yes, sir.
So you understand that if the court accepts this admission, you will be admitting that you have violated probation in conditions 1, 2, 9, and 7 for the reasons that your attorney in a detailed way just went over with you. Do you understand that?
Yes, sir, I do.
Is that what you wish to do?
Yes, sir, it is.
Do you understand that you have a right to have a hearing contesting the finding that you had violated probation? At that hearing, Mr. Stumbos would have been with you. He would have cross-examined any witnesses and examined any evidence against you. You could have presented your own witnesses and your own evidence. If your witnesses had not wanted to come to court, you could have asked me to make them come to court with a subpoena. You could have participated in that hearing, had it recorded, appealed any error that occurred in that process. At the hearing, the state would have had the obligation of proving to me, the judge, by a preponderance of the evidence that you had violated your probation in a material and willful way. Do you understand by admitting that you have violated probation in conditions 1, 2, 9, and 7, you give up your right to have a violation of probation hearing, and I will determine a reasonable sentence based on future information that your attorney and the state is going to present to the court. Do you understand that?
Yes, sir. Like I said, I'm guilty of what I did. I screwed up, and I admit that. So yes, sir, I'm aware of all that.
Mr. Mercer, hold on just a sec.
And I'm sorry, Your Honor. I did note, the probationer officer did point out, there is, along with 1279, condition 5, there's also a violation of condition 3 for his absconding and for changing his address. And I just wanted to clarify for record purposes, are we going forward on the third amended violation of probation, and Your Honor's just not taking an admission to condition 5, or are we just going forward with the plea on the amended violation?
It's also alleged that he didn't report after September of 2019.
Correct.
Mr. Stumbos, is your client admitting that he has violated probation in that way? Was that on the second amended or the first amended?
I believe it was on the first amended, and then there was more absconding that was then on the change of address. Based on my notes,
There's a condition 3 violation, Mr. Stumbos, is your client admitting that?
Judge, that's one that I just have not had a discussion with him about, unfortunately. We didn't receive this amended violation.
second amended violation back on December 17th, 2019, which alleged violation of condition number 3, his changing his residence without procuring consent, and he had not had contact and moved back approximately September 30th, 2019. The third amended violation only alleged the new law violation. All of the absconding, the moving, and failure to reports were all contained and subsumed in the original violation of probation from 9/16/2019, the amended violation 11/25/2019, and then a second amended violation on 12/17/2019. And he did not turn himself into probation until March 9th, 2019, but I believe Mr. Stumbos had filed his NOA
March
back in
9th,
October.
2020?
2020, yes.
Judge, a question I have for the state is, do they intend to go forward with a violation based on the new law violation after today?
That's not what they're talking about, Mr. Stumbos.
No, I know, but I'm asking that question.
Oh.
Are you prepared, depending on what the judge does on this, on a downward departure, is it your plan to move forward on a subsequent violation of probation based on the new law arrest?
Quite frankly, the state had not thought that far in advance because I thought this was a plea hearing as to everything today.
Well, I kind of need to know that, Judge, in order to determine whether or not today is the day for the plea or not.
The condition 5 was no info?
Yes.
That'd be a tough sell, but I
haven't had an opportunity to review that. I had been told for weeks now that it was going to be a plea. So I did not file a witness list. I did not speak to those witnesses. I did not speak to that ASA in detail about the new law violation because I have been told since the VOP status hearing that we had a while back in June, where defense advised the court that it would be a plea. We were setting it for a plea cutoff date and a hearing date, but it was never their intention to go forward on a hearing.
That's correct, on what we just talked about. But if the state is telling me that they do not agree that they will not move forward with a violation of probation on the new law arrest, I understood that that had been done. Now, had I received the witness statement that I was just handed today for rebuttal purposes or anything else, I might have been following up with her and indicating, okay, where are we on this? I need to know. Because if you're moving forward on a new law violation, then, you know, it likely needs to be set for an entire VOP hearing on everything, as you can imagine, Judge. That's my problem today.
Right.
I don't intend, Your Honor, after whatever the sentence is that's made today, to continue this case any longer, quite frankly. I expected today to be a plea to everything. The state's ready and has been ready since 11 to present its witnesses. And I did receive contact from the victim that it's telling him that the link is expired. I don't know why, but he keeps trying to log in and it keeps telling him that.
I don't know what he's trying to log into. I have both you and Dr. Danziger in the waiting room, so I don't know.
I'll see if he can call in on the conference line and see if that works.
Okay.
But
So the
I don't
question,
intend on having a full-fledged hearing on a new law violation. I don't know if the court is then dismissing Condition 5, if we're just taking the plea on the amended second violation, but I've just never, the thought never even crossed my mind. I provided the statement about the new law with the anticipation defense was going to use the lack of new law.
Yeah, with the state saying that they're not going to pursue the subsequent violation of probation based on the new law arrest, if that's what I'm understanding,
That
then
was
we can move
not my
forward.
intention, because it's always been
so
scheduled.
as to the second amended violation affidavit, that does not include the new law offense, right?
Correct.
Is the state comfortable with the court taking an admission to the second amended violation of probation affidavit that would then resolve the violation of probation in its entirety?
Are they pursuing the absconding too?
Absolutely. He has not reported to probation since July of last year. I mean, it's all laid out in all of the violations of probation affidavits.
I got it.
That would be a substantive violation, so either,
Amended 2 ultimately just extends what we had already laid out in violations 1, amended 1, and then amended 2 just kind of is the continuation of the absconding and the lack of being able to locate him with some more details from what the probation officer was trying to do to locate him.
okay. Here's what the court's gonna consider. If anybody needs additional time, I'm inclined to grant you that additional time. It seems like there's a number of things that there's not a meeting of minds between defense and the state. If you need additional time, I'll grant it. I'll give you time next week to try and sort this out and continue on with our sentencing hearing. If you guys are comfortable with moving forward on the second amended violation of probation, that would be a admission to the allegations in the second amended violation of probation. I'm happy to do that this morning or this afternoon now and continue on with the hearing. So do you need a minute to ponder that, or?
That's fine, Your Honor.
Judge,
do
I just
wanna-
don't want the absconding in it right now, so
Oh, well.
as long as we're.
I think that's, then if he's not gonna admit that, well, I'm not gonna.
Judge, I'm okay with it, just if I can somehow have a 2-minute conversation with him so he understands.
I need a 5-minute break anyway. All right, court's gonna take a 5-minute recess.
Yes, sir. No, sir. It doesn't see, I don't think so, sir. I think I may have one time though, but I'm not 100% sure. Yes, sir.
Record. Mr. Stumbos, what is the defense's request at this point?
Dr. Danziger, are you available to go forward today with your testimony still?
I can do it right now if that's all right. I'm supposed to be at the Seminole County Jail at 2, but anything His Honor wants me to do would trump that. But if we can go now, I'll go now. If we could go at 1, I can go at 1, whatever, or I'll do whatever His Honor asks me to do.
Smers?
Your Honor, I think we need to finish the admission and make sure that the admission is entered, and then we can proceed with Dr. Danziger's testimony. I know I have a handful of questions for him. His report wasn't very long. My questions are pretty deep, like to the point. So if we need to continue the hearing after, because we're gonna have to pause it at 1 o'clock. I don't know how long defense is gonna question Dr. Danziger for, but.
Well, there's two avenues. Are you prepared to stipulate to the fact that he is an expert, of course?
Yes.
Are you prepared to stipulate to the admissibility of his 2 reports, subject to still you being able to question?
Yes, I have questions about the reports. I don't mind, I have no objection if they come into evidence, but I have follow-up questions for him based on those reports.
Okay, I'm okay, Judge, as long as, I had talked previously, as long as they're both admitted, meaning the January 10th evaluation as well as the May 18th, 2020 addendum to the evaluation. I'm okay with potentially moving forward, but you only have till 1, and I may have some follow-up.
It's somewhat unorthodox. Mr. Mers, I don't see a legal prohibition taking Dr. Danziger's sworn testimony. I'll consider that for purposes moving forward, whether that be for hearing or admission. But at some point, Mr. Stumbos, I'm going to ask if this defendant is admitting to the second amended violation of probation. So let's get Dr. Danziger on his way. Dr. Danziger, we're going to place you under oath. I'm going to point you over here.
Do you solemnly swear affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth so help you God?
I do.
All right, for purposes of the record, this is 2016 CF 1450 and 2016 CF 3017 regarding Heath right, I am looking at Dr. Danziger on my computer screen. I'm well familiar with Dr. Danziger. He's been sworn. Mr. Stumbos, when you're ready.
Yes, Dr. Danziger, how are you today? Real briefly, I'm checking to see if I can hear you, really. Hey, Dr. Danziger, how are you? I'm well. Good, thank you. Now I can hear you. Now, do you recall doing an evaluation on January 10th, 2020 on my client, Mr. Heath Wright? I did. Okay, and did you do a report on that evaluation? Yes. All right, and based on, I guess, the report of January 10th, 2020, you subsequently did an evaluation or an addendum to the evaluation on May 18th, 2020, correct?
Yes, just consider that an addendum. I did not reevaluate him. I just added additional opinions.
Okay, and if you could, sir, in a nutshell, just give us, state you have no objection to both of these documents, these reports going into evidence?
That's correct.
All right, and just in a nutshell, briefly, can you please tell us what your findings were, very briefly, if you could?
After meeting with Mr. Wright, also speaking with his mother for collateral information, I offered the opinion he suffered from ADHD combined type dating back to childhood. He had not been receiving treatment for that condition, which continued to trouble him. So, from a diagnostic standpoint, ADHD combined type. From a forensic standpoint, my opinion, he does suffer from a mental disorder unrelated to substance use. He is a bit amenable to receiving treatment. Right. Secondly, he admitted to the single use of methamphetamine when offered to him in August 2019 that led to one of the probation violations. He said he was an impulsive action, upset at a breakup with his girlfriend. My opinion, it was an isolated incident, unsophisticated, for which he has expressed remorse. These were the opinions that I offered.
Okay, and based on your findings, you agree, and correct me if I'm wrong, that he has a very short attention span, correct?
Yes, that is one of the core features of his ADHD. He may act impulsively at times, short attention span, poor concentration, fidgety, rather classic symptoms. And again, the collateral information from his mother was that this goes back to childhood.
From childhood, and then all the way up till high school, he was under some level of care, correct, medically?
Yeah.
And then
That's
after
correct.
high school, he was no longer under medical care for the last 15 years or so, is that correct?
That's correct. He found the side effects were poorly tolerated.
All right, and when you say the side effects, he had stomach problems and couldn't tolerate it, correct?
Yes, also it dropped his appetite and weight loss, which also led to his stopping.
All right, and in here, you also made a finding that, or at least in your opinion, that potentially medical marijuana could be potentially helpful to him, is that correct?
Well, that was based on his self-report. As I noted, cannabis or medical cannabis really has not been studied in ADHD, although some people anecdotally report it helps them. But I also wrote in the report that I have no idea if for someone on probation, medical cannabis would be approved or wouldn't be approved, especially for something that's not an indicated condition. So I just noted his anecdotal report. While whether it works in general for ADHD, there's no data really to show that consistently.
I need you by a microphone.
And Dr. Danziger, and interestingly, he had noted to you that the methamphetamine that he had used actually seemed to make him calmer.
Yes, which is actually a hallmark for ADHD. For people without ADHD, when they use amphetamine medication, whether it's legitimately prescribed Adderall or dextroamphetamine, or whether it's illegally obtained methamphetamine, they all act similarly. If you don't have ADHD, you take such stimulant medication, you're stimulated, accelerated, you talk rapidly, you feel speeded up. But if you have ADHD, it has the paradoxical effect of making you feel calmer and better focused. So his report that methamphetamine makes him calm, you consider that a pharmacologic probe that he likely does have ADHD.
I gotcha. And so from there, it in essence confirms that something's off in his mind, correct?
Well, his self-report is certainly consistent with an ADHD diagnosis.
Yes. Would you find an individual that is suffering at the level that he has with the ADHD that we talked about, that in stressful situations, he has a very difficult time in dealing with them, correct?
Well, he may act impulsively, act without thinking, may not concentrate, may, in essence, act without thinking. So that's certainly common.
I got you. Okay, thank you. And based on your discussions with him, my client is amenable to getting help, correct?
Yes.
He has indicated that to you?
He did.
All right. And he has also shown remorse for the use of that drug, correct?
Well, that's what he told me, that he certainly regrets what he did. It was a one-time foolish thing, and he was upset at the time about his girlfriend. It was offered to him. He certainly regrets it and knows the foolishness and stupidity of doing it.
All right. And based on your diagnosis, would you agree that the capacity of my client to appreciate the criminal nature of his conduct, or to conform that conduct to the requirements of law was substantially impaired?
I didn't offer that opinion in my report. I believe he knew using was wrong. He was just upset and acted in a foolhardy fashion.
In an impulsive fashion?
Yes.
All right. And it was in an unsophisticated manner, correct?
In my opinion, yes. It was offered to him. He was upset and he used it once.
All right. And you did also confirm that this particular ADHD actually runs in the family. There's a bloodline, correct?
That was what his mother related to me, that there's a strong family history. I didn't ask specific relatives. I didn't want to violate anybody's privacy who's not a party in this case, but the mother simply said it runs all over the family.
Okay. Judge, I believe I've moved these into evidence. Are you okay to accept them?
Yes, well,
All
we
right.
received this defense 1 and 2. Have they been marked, Mr. Steenbush?
No, Judge, they've been filed. All right.
One and 2 without objection. So receive this defendant 1 and 2 without objection. Any additional questioning?
No, sir, not for the time being.
Mr. Murphy?
And Your Honor, I have him on my computer screen if you want to turn your computer around. I can turn my camera on for him. I know it's very untraditional. Good morning, Dr. Danziger, or I guess afternoon.
Good afternoon.
Just a few follow-up questions. Prior to your evaluation with Mr. Wright, I know you mentioned a lot of self-reports. Did you have any documentation, any medical records, anything like that that you reviewed prior to the evaluation?
I did not. the history I had was that he was treated as a young person by Dr. Joel Weinberger, who's a family care doc in the Hunters Creek area. I did not have those records. They would have probably been from, a dozen or more years ago. They would have been difficult to obtain.
And were you given any information about his violation of probation besides the use of methamphetamines?
Besides what, Ms. Demers?
Besides the use of the methamphetamines, did you review like the affidavits, anything like that?
Well, I have the affidavit violation of probation, which lists the various causes. I have the warrant, how violation occurred, and then a copy of the laboratory drug test. I think I noted in my report of January, there's a section violation of probation affidavit, which briefly summarizes the allegations contained.
Okay. And at the time of the evaluation, did you know that there was an outstanding warrant for his arrest?
Well, he was, let's see. Well, I had a warrant dated September 12, 2019. I didn't know if that was active or not. He was in my office, so he wasn't in custody. Whether that warrant was still active or not, I did not know.
Okay. And I know you mentioned in your report that he requires specialized treatment for the ADHD. Can you elaborate what kind of specialized treatment he needs?
Well, he would benefit from seeing a psychiatrist to find a medication regimen that he could tolerate and provide benefit with regard to the ADHD symptoms. He might benefit from a behavioral type of psychotherapy to help him focus, concentrate, be more mindful of his actions and reduce the impulsivity. So those strategies can be very helpful in adult ADHD.
Is there anything different about that recommended course of treatment from treating any other adult with ADHD?
Every patient is a little bit different, of course, and some things work better for some than others, but that would be it. Some people do best with medication alone. Some people do well with therapy and don't tolerate medications. Other people do better with a combined approach. So I think it's a reasonable strategy that I'm offering for someone with adult ADHD. And as far as what medication would work best or what therapist you would work best with, that's what happens when you treat somebody and you figure out what works best for them.
Of course. And to your knowledge, and you may or may not have an answer to this question, but to the best of your knowledge, do you know if he would be able to receive medication management and treatment from a psychiatrist while incarcerated?
Obviously, every correctional facility in the state of Florida, whether it's the local jail or DOC, has access to psychiatric and mental health. They usually don't prescribe amphetamines in prison or at the jail. That would be rare. But I know they do have mental health treatment in DOC and in local county jails.
And then based on your conversations with Mr. Wright, you did not determine he had any other type of mental health diagnosis. Is that correct?
That's correct. I did not diagnose anything else.
All right, I have no further questions, Your Honor.
Thank you. Mr. Stumos?
Yes, briefly. Dr. Danziger, in your records, do you recall you and I talking sometime in, when is the first time you know that you and I talked where we tried to set up a conference or an evaluation date with you? Do you recall it being in September?
That sounds about right. It was sometime in the fall of last year.
Okay.
And at age 63, I'm not going to be able to tell you the exact date.
Okay. Thank you. Additionally, do you also recall that you had indicated to me that the only way you could do an evaluation in this case would be if he came to your office? Meaning that you would not go out to Osceola Jail and do an evaluation anymore? Back then.
Yeah, with no disrespect to Osceola, given the other work that I have, I try not to go out to the jail there. It usually eats up a whole day, and so I've been trying not to go to the jail.
And do you remember having that conversation with me?
I don't recall it exactly, but I don't doubt that I said.
Okay. And do you also recall that in September when I talked to you, we set up an initial evaluation in December as the earliest date you could get him in for an evaluation?
Usually my staff tells me when I can see people. I just listen to what they tell me with scheduling, but
I get it.
If that's what was said, I don't recall that, but I'm not doubting your recollection.
All right, well, we had and hopefully this may jog your memory, I actually called you on your cell and indicated that I wanted to get my client in for an evaluation as fast as possible. But with, just Christmas coming, December, your schedule was very, very packed. And the earliest you could get me in was December. And we actually texted back and forth on that. Do you recall that?
I recall texting with you, but not the details. It's been 8 or 9 months, but what you say sounds correct. And yes, I was busy in the fall of last year.
Yes. And do you also recall that when we were finally set up in December, that something came up in your office and we were then moved to January?
Yes, it's possible there might have been a trial or something I had to be at. And as you know, oftentimes I hear there's a 1 week or 2 week trial period. I don't know the exact date. And when I'm called to show up, I show up in court. That was, of course, I haven't been on a witness stand in 6 months with COVID, but probably what happened in December.
Do you have your cell phone there with you?
I do.
Your Honor, I'm going to object at this point. I'm not quite sure what the relevance is.
Judge, I want to correct, meaning, do you have a text March 11th where I indicated to you, actually May 16th, let me know if you're available to discuss Heath Wright Monday morning or any time you are available, a May 16th text.
A May 16th.
Of last year.
2019?
Of 2020.
I don't have it because a lot of times I go through and delete old text messages. So I don't have it.
Okay. Would that make sense to you that we were talking that early?
I'm sorry, I missed the first half of your
Would
question.
that make sense to you in May?
Oh, yes, no, I know we've communicated. I know we have, I just don't have the exact
Actually,
dates.
my
I know we
apologies,
have
my
communicated.
apologies. I've got the year wrong on that. You're correct then on when we talked, but you don't recollect that 3 or 4 months later was the first time you had an appointment available in December, and you have no reason to question that it was potentially moved to January.
I have no reason to question any of that.
Okay, so if I represented that to you, we're good, correct?
Okay, yes.
All right, I got you. Thank you.
Follow-up questions?
No, Your Honor.
Dr. Danziger, thank you for your patience and thank you for joining us.
Thank you, Your Honor. Good afternoon.
All right, Mr. Merz, do you have any witnesses that you would like to take out of order? I lose the jail feed in about 5 minutes.
Your Honor, I do know that I believe the victim had tried to call in. I'm not sure if he is showing.
I do
up
have,
there.
I'm showing someone waiting in our virtual lobby.
And then I also have the probation officer here.
Who's been here for some time.
Yeah, I can't accomplish both in 5 minutes, and I don't know how much questions defense has for either. So I don't know if there's much at this point that, quite frankly, we can do in 4 minutes.
Mr. Stumbos, I am up against a hard stop. I would continue to donate my time towards this hearing. However, the initial appearance judge needs the jail feed at 1 o'clock to complete initial appearances. That I won't have the jail feed back until this afternoon, and frankly, I'm sharing the jail feed with drug court this afternoon, so I may not even have it this afternoon. So my thought is this. Despite our best efforts, we have been unable to accomplish the plea and sentencing in the hour allotted, and we were given the full hour for this hearing. I'm inclined to reset this for an additional, how long do you think is reasonable? An hour?
Like I said, Your Honor, I have brief questions of the probation officer as to some of the absconding and recommendations. I know the victim wanted to make a statement. I don't quite have questions as much as I know he did want to address the court. And then I think defense still possibly had more witnesses they wanted to call, so I'll leave it to defense and Your Honor to figure out
Mr. Stumbos?
time-wise.
Judge, you know, I may have a little bit of witness now that we've had, meaning just the mother to testify to some history is all. My client can testify to it too, but it shouldn't be that long, to be honest with you.
I'm going to set this case for another 90 minutes of hearing time. Mr. Stumbos, I'm going to set this for a admission, and I don't know whether it's going to be an admission on this date or not. I need to have a signed admission form from your client, from the jail, that indicates what he is admitting and what conditions he is admitting. The second amended affidavit includes a allegation of absconding, a condition 3 allegation. I need to know whether he is admitting or denying that allegation before the court can make a determination as to whether this admission is taking care of this allegation or not. I have jail feeds on Wednesdays. My next date will be on next week. The next data that I have is August 19th.
You have next Wednesday and then August,
I do not have the 12th. I'm out of state.
you don't have, just August 19th.
Correct.
Okay.
Mr. Mers, your availability on
Your
the
Honor,
19th?
right now, that day is open. I do know I have a lot of defense attorneys biting for that afternoon, so this will take priority. So if we want to set it for that afternoon, it's fine. I don't have anything set in stone yet. Right now, my calendar looks wide open.
Okay.
Are you available?
We check with Mr. Probation Officer. He's been here for quite some time. I have a 10:30 time available on the 19th.
That would be,
It's more advantageous to both sides. Mr. Stumbos?
August 19th? Should be okay, Judge.
Okay. All right, we are going to continue with a admission hearing. The court will file defense exhibits 1 and 2. My apologies to all of the witnesses that have donated their morning. Despite our best efforts, we were unable to complete our hearing. We'll set that for another 90 minutes, beginning at 10:30 to noon on August 19th. We'll complete our hearing this afternoon. All right, sir. Mr. Wright, we'll see you back at my earliest available date, which is August 19th at 10:30.
Okay, sir.
We'll be in recess.
What's in recess?
Sorry we weren't able to accommodate the hearing to its completion today. We're off the record.
there are no
Is that person with?
Bernardo? Christian? Douglas? Lopez? Pupo? Quick? Roman? Sepulveda? Sharma? Bernardo? Bernardo? Vaughn? Vaughn? Hennessy? Hennessy? Justin Hennessy. Who's Vaughn?
Good afternoon, everyone. My name is Mike Murphy. I'm a circuit judge. I'll be conducting the initial appearances today. The purpose of the initial appearances is to advise you advise you what the allegations are that are holding you in custody, and then to make sure you're advised also that if you can't afford a lawyer will be appointed to represent you. The public defender's office are attorneys that would be appointed to represent you if you can't afford your own attorney. There is no obligation on your part today to tell us anything about any prior criminal history that you might have. That obligation is entirely on the state of Florida. When your case is called, I'll have you come on up to the podium, and then I'll advise you of what the allegations are. You will hear me say something about probable cause. The law says that probable cause is a determination made upon the police report, and it's a non-adversarial determination. Traditionally made even prior to me coming to the courtroom. I've reviewed your paperwork and then determined whether probable cause exists or not. There's no requirement that there be probable cause for 48 hours, and then after 48 hours, the state can ask for additional 24 hours under certain circumstances. But if probable cause does exist, the rules say for the initial appearance judge to announce that the probable cause does exist. I will then ask the pretrial release office to tell me about any prior criminal history you have, and then I'll set conditions of release. Most of you have had bonds set pursuant to a bond schedule, but the bond schedule is just for convenience to allow people to bond out prior to coming to initial appearances. It's not binding upon the court in any way. Sometimes the conditions of release that the initial appearance judge gives will be more or less than what the bond schedule says, based upon prior criminal history and the allegations. Do you recognize under our Constitution, if you're charged with a new offense, you're presumed to be innocent. And the presumption typically is on a non-monetary release unless circumstances justify otherwise. Some of you are in custody based upon VOP warrants. The initial appearance judge does not have the authority to change any bond conditions on a VOP warrant. So if the VOP judge set your bond at no bond, I can't do anything about it. Your attorney can schedule a hearing in front of the judge assigned to the case, and your attorney can have the bond hearing and perhaps convince the judge to set a bond on your case. If you're picked up on a capias that was issued after you failed to appear for court, the initial appearance judge doesn't have the ability to change the bond amount on a capias. Some of you might have been picked up on what's called a probable cause warrant, where a judge was presented with a non-violation of probation warrant and a judge set a bond, sometimes set a bond at no bond. On a probable cause warrant, the initial appearance judge does have the ability to set conditions of release. In those cases, I'll hear about from any prior criminal history, I'll look at the allegations, and then I'll set conditions of release. Some of you are in custody on cases where there is a listed victim. Traditionally, that's on a domestic violence case. The law says that if the victim's not present, I have to order that you have no contact with the victim. No contact means no good contact, no bad contact, no direct or indirect. Send $1 million to the listed victim, that's a violation of the no contact order. Send roses, violation of the no contact order, it'll cause you right back to be back in jail. If you relay a message to your best friend, his or her best friend, aunt or uncle, post on Facebook. Those are examples of indirect contact that'll cause you to be right back in custody. So when I say no contact, it means no good or bad contact, no direct or indirect contact. Most of you who are facing a no contact condition should have been given a sheet of paper that lists in detail what no contact is, just so it's clear, because we don't want you to violate it. If I order that you're not allowed to return to the victim's residence, there is an exception one time with law enforcement to collect your belongings. You'd contact the law enforcement agency that has jurisdiction over the property. They would meet you somewhere other than the property and accompany you to the property to make sure everything goes smoothly. If you just go directly to the property, when the police get there, they're going to arrest you and you'll be back in jail, no bond. Don't do that. Contact law enforcement. Tell them you're allowed to return one time. I promise you, you won't be the first person to ever contact them with that. Some of you are in custody based upon perhaps a warrant from another jurisdiction. Under those cases, we contact the other jurisdiction to come and get you. We have an administrative order that requires these other jurisdictions to pick you up in pretty short order. And if they don't, then you can be released again. So that's how this goes. So now we have a representative from the State Public Defender's Office and also pretrial services. I'll have them state their names for the record, starting with the State Attorney's Office.
Lauren Demers on behalf of the state.
Elinette Perez on behalf of the Public Defender's Office.
Thank you. Pretrial Services.
Officer Pat Hill on behalf of PTR.
All right, the first case I have is Nelson, last name Argueta. If you come on up to the podium, please. You hear also the clerk will say things such as PD approved. There you go, PD approved. It means the public defender's office is going to represent you. I don't need to specifically say public defender appointed. Once she says PD approved, it means the public defender's office is defending you, and there's a representative here who's taking notes. Also, once I conclude your case, the clerk will tell us if you have a next court date. If you're arrested for a felony, the court date is something that's called on demand, which means they wait to find out whether the state's even going to file any charges. If it's a misdemeanor, you'll have a next court date. All right, so, sir, your name, please?
Nelson Argueta.
All right, thank you. You're in custody on a probable cause warrant, which means I'm going to get to set the conditions of release in your case for the allegations of domestic battery by strangulation, tampering with a witness, and also domestic violence battery. The victim's not present, so I have to at least order no contact, maintain separate residence, no weapons or firearms, don't return to the victim's residence, except for one time with law enforcement and the procedure that I mentioned. But now I'm going to set the remainder of your conditions. Pretrial services, any prior history?
He has no priors.
All right. So your bond in this case, based upon the allegations, is 1,000 on count 1, 100 on count 2, 100 on count 3, plus pretrial release after you post the bond with the conditions that I mentioned. Do you understand, sir?
Yes, Your Honor.
All right, thank you.
Next court date on demand.
Next case is Christian, last name Bernabel. When you get to the podium, tell us the correct pronunciation of your name, please.
Good afternoon, Your Honor. It's Bernabel.
All right, thank you, sir. You're in custody on 2 capiases that were issued by Judge Whitehead after allegedly failing to appear, and the bond is no bond. As you heard me explain, I don't have the authority to change that, but your lawyer can schedule a hearing in front of Judge Whitehead to try to get you a bond. Do you understand?
Yes.
All right, next court date?
Next court date today at 2 p.m.
Oh, there you go, today, in less than a half hour. Next case is Julian Stefan Santos Ayala.
PD approved. Your Honor, defense waives reading.
This is just a violation of probation. All right, hi there.
Good afternoon, Judge. Michael Kennedy here on behalf of Mr. Santos Ayala.
All right, thank you. All right, so in custody on a violation of probation, where the bond is no bond, you heard me give my speech that says I don't have the ability to modify a VOP bond, but your attorney has the ability to go in front of the judge assigned to the case to try to get you a bond. The clerk is going to tell you the next official court date, but remember, your attorney can always schedule a hearing sooner than that court date to try to get a bond. I just don't have the authority on initial appearance. I don't know if you wanted to say something or if you're just meeting with your client to make sure you understood that.
I did, if I may, Judge, I certainly understand the court's position on that, but I did want to let the court know, Your Honor, I'm in the process of speaking with ASA Rosado in this case, and I unfortunately was hoping to speak to the ASA present today before court, but obviously that's not possible with the coronavirus situation going on, Judge. But essentially, in this case, Mr. Santos Ayala was at work, Your Honor, when he was found in this violation. So it's not willful. We're in the process of getting it dismissed as a result of that. I understand the court's position on the no bond status, Judge, but what I have here is proof of the schedule from both of Mr. Ayala's jobs and as well as letters from his managers stating that on the day in question, July 23rd, he was working, and I have proof to that, Your Honor. If the court would consider placing a reasonable bond in this, Judge, looking at the violation.
The best that I could do is roll it till tomorrow, see if you can get an agreement by the state, and if they agree, then I can take an agreement between the state and the defense.
That would be great, Your Honor.
So, all right, so it's,
Tomorrow, I think I could.
all right, so the next court, okay, so this is a little bit confusing. Next court date is,
August 13th in courtroom 5A at 8:45 a.m.
but we're going to also roll it till tomorrow in here before me to see if you get an agreement. If when I come in here, if there is no agreement, obviously there's nothing I can do on the case.
Sure, Judge.
Okay.
I would just recommend reaching out to Ms. Rosado and getting something in writing for whoever the ASA is that'll be covering initial appearances tomorrow.
And I'm
Absolutely, Your Honor. And Judge, would it be better for me to send an email to your judicial assistant potentially if we do get a deal worked out to give you notice of that?
It might be the best just for you either to come to the courtroom tomorrow or email the clerk, and the clerk because they'll keep all the paperwork together. But if you ultimately get an agreement, it might be the best to just send it to the judge assigned to the case, and the judge would be able to, because that ASA actually probably works multiple divisions based upon the charge, right?
I guess it's based on the courtroom. It's probably in Judge Wooten's courtroom. And I know Ms. Rosado is pretty quick with emails and such, so I'm sure Judge Wooten would review something if there is something to say.
All right.
Thank you, Your Honor. I appreciate the
Have
time.
a good day. Next case is last name Sharma. When you get to the podium, tell us the correct pronunciation of your first and last name, please.
Committee approved.
Hi, your name, please?
Good evening, sir. What's your name? Oh, my name? Jagdish Sharma.
All right, thank you. You're in custody on a violation of probation where the bond is no bond. Your lawyers can go in front of the judge to try to get you a bond. Do you understand?
Yes, sir.
All right, the clerk's going to tell you your next court date.
Next court date, August 13th in courtroom 4E at 8:05 a.m.
Next case is Justin Hennessy.
PD approved.
Oh, that's all, sir. Thank you.
Your Honor, he refused to be brought up.
All right, so KPS $2,999. We'll reset him tomorrow to see if he attends. Diamond, last name Bakaran.
PD approved.
Your correct pronunciation of your last name, please?
Balakaran.
All right, thank you. Your probable cause to believe you committed an aggravated assault with a deadly weapon. The victim's not here, so I have to order the no contact, maintain separate residence, no weapons or firearms, don't return to the victim's residence except for one time with law enforcement to collect your belongings, no alcohol. Now I'm about to hear about any prior criminal history for me to set conditions of release. Actually, before I hear that, I see a note that the victim has indicated that they want to have contact, but if they're not present in the courtroom to tell me in person, the law says I have to order no contact. But your lawyer can schedule a hearing in front of the judge assigned to the case to try to modify that and where the victim can be present. But remember, even though the victim might want to have contact, no contact means no contact. And if you violate it, it's going to cause you to be right back in jail. Make sense?
Yes, sir.
Okay, so wait, hold on one moment. So let me hear about prior criminal history, and then we'll go to the next step. And then if there's something you still want to tell me, we can talk about it in a moment.
He has no prior
I have no criminal history.
Okay, remember at the beginning I said don't say anything about prior criminal history because I don't want you to say anything, any of you all to say anything that can be used against you on any level. All right, so was that the only thing you were going to say, or was there something else you wanted to say? Well, don't talk about the facts of the case, but I just want to make sure I'm not missing something.
No, my wife and I,
Wait, hold on. So don't talk about the facts of the case, and remember, I have to, no matter what you say, I have to order the no contact, but your lawyer can schedule a hearing later to change it from no contact to something else. Does that make sense?
Good.
Okay, so other than contact and other than the facts of the case, and don't say anything about their prior criminal history, is there still something else you wanted to say?
well, I married this woman for 39 years.
Well, okay. So there, you have no prior criminal history, that's very important, and so your conditions of release are gonna be based upon this $250 bond plus pretrial release with the condition that I mentioned. Your lawyer, there's a representative right here who can reach out to the victim and try to schedule, your lawyer can reach out to the victim, you can't, your friends can't. The lawyer can reach out to the victim to try to schedule a hearing to try to modify the no contact to something else. You understand?
Yes, sir. And meanwhile, I'll have to go home and get some stuff.
Yeah, you're allowed, contact the law enforcement agency that has jurisdiction over the property. They'll accompany you to the property to make sure it goes smoothly. Don't just go to the property. Okay? All right.
When is my court date?
Next court date on demand.
Which means the state has to make a charging decision. They might, who knows, they might not even file charges. So you don't have a court date just yet. All right, thank you. Robert Douglas.
PD approved.
All right, Mr. Douglas, there's probable cause to believe that a misdemeanor battery occurred on a family or household member. The victim's not present, so I have to order no contact with the victim. Don't return to the victim's residence. You have to maintain a separate residence from the victim. Don't possess any weapons or firearms. Don't possess or consume any alcohol. You're allowed to return one time with law enforcement in the method that I mentioned before, which means you contact law enforcement, they'll accompany you to the property. All right, do you understand all that so far? Okay, so prior criminal history of any?
He has no priors.
All right, it's a misdemeanor, so I'm required to order at least some monetary bond, so $150 bond plus pretrial release with those conditions that I mentioned. Do you understand?
Yes.
All right, don't violate any condition or it'll cause you to be right back in jail. Next case is George Lopez.
Next court date for Mr. Douglas is still in jail, August 13th. It filed September 1st in courtroom 5B at 11:30 a.m.
Thank you. All right, George Lopez. All right, thank you.
Hi, Your Honor, how you doing?
I'm doing all right.
Good.
All right.
I'm also requesting for ROR. I started a job.
Well, hold on just a moment. So the legislature lots of times puts restrictions on judges. Sometimes they tell judges we can't sentence people to less than a certain amount unless the state attorney's office agrees to it. Battery on family or household members are one of those things that the judge, under zero circumstances, is allowed to give someone an ROR or straight PTR without the PTR office's approval. So in a moment, I'll ask PTR if they agree to straight PTR, although I do this for a living, I know the answer is they don't agree to it. But I'll still ask them because you never know, maybe something has changed in the last day. But we'll come back to that in just a moment. But that's a long way of me saying I can't give you what you're asking for, even if I wanted to. So anyway, there's probable cause to believe the battery occurred. At a minimum, I have to order that you have no contact with the victim, maintain a separate residence, no weapons or firearms, no return except for one time with law enforcement as I described before. Now, okay, pretrial services. Any prior criminal history for this gentleman?
Yes, Your Honor, he has 6 priors out of the state of Florida. Some failure to appear, fraud in 2014, which was adjudication withheld, a prior battery domestic in 2015, which was dropped, unknown victim, and drug sales in 2015. It appears he has no convictions. He has a 2019 criminal mischief out of New York, but unknown disposition on that.
All right, does he qualify from pretrial release for straight pretrial release?
Unfortunately, due to the admin order, we are not allowed to release on a non-monetary status for battery domestic charges.
All right, Mr. Lopez, your bond is $250 plus pretrial release with those conditions that I mentioned. Do you understand?
Yes, Your Honor.
All right, the clerk will tell you your next court date.
Next court date is still in jail, July 13th. It filed. Hold on, Judge.
All right, hold on just a moment. Apparently that wasn't the right court date.
It's still in jail, August 13th. It filed September 11th in courtroom 4E at 11 a.m.
All right, thank you. Joshua Quick.
PD approved.
All right, there's probable cause to believe you committed a trespass from Wawa. Now I'm about to hear about prior criminal history for me to set conditions of release.
Yes, Your Honor, he does have multiple priors out of the state of Florida dating back to 2007. Drug charges, failure to appear. He does have an open case, failure to appear on a direct information filed. And then he is, oh, that's the one that's Yeah, he has that open case, it's a direct file. The charge is petty theft. Underlying charge is petty theft on the failure to appear.
Judge, it's not an FTA, it's a.
I can't hear what she's saying.
She's saying you did not fail to appear, it's just a direct charge, and that it's not a case where you had what it was like a summons?
It was, yeah, and he didn't come to arraignment, so Judge Arendes, instead of filing an FTA, she gave him a rule to show.
Okay, got it. Got it. It just means that I'm not going to revoke the conditions of release in the other case. That information is given to me to decide whether I wanted to revoke conditions of release, so I'm not. So I'm just going to set your bond in this case here, which is that your bond is $250, no return to Wawa, and that's your condition. Do you understand?
Yes.
All right, the clerk's going to tell you your next court date.
Next court date is still in jail, August 13th, if out, August 31st, in courtroom 4E at 10 a.m.
So August 13th?
August 13th is still in jail, if out, August 31st.
All right. So no pre-trial release?
No. The next case is Julio Roman.
PD approved.
All right, so in this case, the allegations are you committed a battery on a family or household member. Is that phrase is defined by law? So the victim's not here, so I have to minimum order no contact with the victim, no return to the victim's residence except for one time with law enforcement in the manner that I described earlier. You have to maintain a separate residence, don't possess any weapons or firearms. And now I'm about to hear about any prior criminal history, if any, for me to set conditions of release.
He does have priors dating back to 1996, disorderly conduct, no valid DLs, dwellers. He does have current injunctions from 2012 and a previous injunction, same victim in 1998 out of Miami-Dade.
There's a note here that says the previous injunctions were dismissed. Is that, see that on the corrections department sheet?
Oh, yes.
Okay.
They were dismissed.
All right.
The one with the same victim.
Oh, got it. Okay. So your bond is $1,000 plus pretrial release with those conditions that I mentioned. Do you understand? Yes, sir. All right, thank you. Your clerk will tell you your next court date.
Next court date is still in jail, August 13th, if not, August 31st, in courtroom 4A at 3 p.m.
Thank you. Next case is last name V-A-R-N-A-D-O.
Yes, sir. Good morning.
Good morning, or good afternoon for, I know time feels a little bit different there. All right, so the allegations is that you trespass from a Wawa, there's probable cause. I'm going to order you not return to Wawa while the case is pending. Now I'm about to hear about any prior criminal history for me to set conditions of release.
He does have priors, he has priors out of the state of Louisiana from 1996 to 2018. Drug charges, batteries, public intox. He has the 2019 out of Oklahoma, carrying a firearm during probation, public intox. And there's possibly an active warrant for a BOP, but that's out of Oklahoma. He is currently on ROR status out of Osceola case 20MM1706, which is a trespass, not the same location.
All right, $250 bond, no return to Wawa. Do you understand?
Yes, sir.
All right, thank you. No.
Next court date is still in jail, August 13th, if out, August 31st, in courtroom 4A at 3 p.m.
Thank you. Russell Vaughn.
PD approved.
Good afternoon. I believe this is the case, and I'm not asking for you to answer the question. I'm going to ask the clerk here. This is a gentleman who already had a case with Judge Jansevich earlier today. Okay. So there's probable cause to believe that you committed the driving while license suspended, and your bond in this case is $2,500. The charge that they charge you with is a felony, so you don't have a next court date on this case here because the state's going to make a charging decision. It's possible that they think it's only a misdemeanor and they charge you quicker. I understand from your other case you have in front of Judge Jansevich, you're in custody for probably a little bit more than a week. So, all right, so you understand on my case here, you have a bond, and you have a lawyer representing you. Understand? All right.
Next court date on demand.
All right, so we have two. All right, so let me call the Spanish interpreter.
Okay. I think I got it. Okay, it's calling now.
Good afternoon, Your Honor. This is Carlos Morales, State Certified Spanish Court Interpreter. The interpreter has been sworn in already today.
All right, thank you. The first case we'll be calling up is Wilson Pupo Castro.
PD approved. Case number 2020 CF 2198.
Hello, your name, please?
Wilson Pupo Castro.
Buenas tardes. ¿Cómo se llama usted?
Wilson Pupo Castro.
Okay, Wilson Pupo Castro.
Even if you understand 99% English, go ahead and let the interpreter finish interpreting before you start to answer. I just want to make sure you heard everything, and whether you use an interpreter or not, you're treated exactly the same.
Aunque usted entienda un 99% de lo que se está diciendo, por favor espere que el intérprete se lo traduzca al español, y porque quiero asegurarme que usted entienda todo lo que se está diciendo y que se le trate igual que los demás.
The allegations are that you possessed methamphetamine and you possessed drug paraphernalia.
La acusación es que usted estuvo en posesión de metanfetaminas y de adminículos para uso de drogas.
There's probable cause to believe each of the offenses occurred, and we're here today for me to set conditions of release and to tell you that you now have an assistant public defender representing you.
Hay motivo fundado para determinar que se cometieron cada uno de los delitos y estamos aquí para que yo le imponga las condiciones sobre su libertad y para dejarle saber que se le ha nombrado un defensor público para que lo represente.
I'm about to hear prior criminal history, if any, for me to set the conditions of release.
Estoy a punto de escuchar antecedentes penales si acaso existe alguno para poder determinar las condiciones.
Yes, Your Honor, he had a possession of marijuana and paraphernalia in 2016. It was adjudication withheld. And a FTA in 2019, also adjudication withheld, no convictions. He does meet the criteria for PTR.
Is the interpreter still there?
Yes, Your Honor, but the interpreter can't hear whoever was speaking, and
got it.
there's
Okay.
also background noise.
Got it. I'll just repeat it. So he had one fail to appear in 2019, and he had one prior offense in 2016, and he qualifies for pretrial release.
Los antecedentes penales son como sigue. Tuvo una incomparecencia en el año 2019 y un caso anterior en el 2016 y reúne los requisitos para el programa del Departamento de Libertad Provisional.
So you will be released without having to post any money, but you'll be on pretrial release with weekly drug tests to make sure you're not possessing or consuming drugs that are not prescribed to you.
Muy bien, entonces usted va a poder salir bajo el Departamento de Libertad Provisional, no va a tener que pagar dinero como una fianza para tener que salir, pero va a estar va a tener reuniones semanales o se le van a hacer evaluaciones o pruebas de drogas semanales para asegurarnos de que no esté en posesión o consumiendo drogas que no le hayan sido recetadas a usted.
The clerk is going to tell
I
you the clerk's going to tell you your next court date.
Next court
La
date on
secretaria Sala va a
demand.
anunciar la próxima fecha de la vista.
Next court date on demand.
La próxima vista se le dejará saber cuándo se determine.
All right, thank you. The next case is Eric Sepulveda Torres.
PD approved. Case numbers 2020 MM 1825, 2020 CF 2199, and 2020 CT 1900.
Sir, you have 3 different case numbers here. The first case is a resisting without violence. The second case is a grand theft auto, and the third one is a no valid driver's license charge.
Bueno, usted tiene 3 números de causas aquí. El primero es por resistirse sin violencia. Hay otro que es hurto mayor de un vehículo y el último es conducir sin una licencia válida.
The Public Defender's Office is appointed to represent you on these cases.
Se le ha nombrado a los defensores públicos para que lo representen en estos casos.
And it appears that you have an upcoming court date in a separate case number where you're charged with charges including a no valid driver's license.
Y al parecer usted tiene una vista que se avecina en otro caso separado que también es por conducir sin una licencia válida.
On that case, where you have a court date of next week, the bond is going to be revoked and you'll be held in custody until you get conditions of release again.
En ese caso, que será la próxima semana, I'm sorry, did Your Honor say that bond was going to be revoked?
Yes, sir.
Okay. La fianza que depositó en ese caso queda revocado y será bajo custodia, seguirá estando bajo custodia hasta que se vuelvan a determinar condiciones sobre su libertad.
Turning to the new cases, on the resisting without violence, the bond is $500, the grand theft $2,500, and the no valid driver's license $500, and no contact with the victim.
Ahora, hablando de los casos nuevos, en el caso de que es por resistirse sin violencia, la fianza es de $500. Hurto mayor de un vehículo, $2,500 y por conducir sin una licencia válida, $500. Pero también le está prohibido el contacto con la víctima.
The clerk is going to tell you your next court date.
Next court
La,
date. Sorry.
la secretaria Sala está a punto de anunciar o decirle la fecha de la próxima vista.
Next court date for 2020 CF 2199 on demand. And for 2020, MM 1825 and 2020 CT 1900, if still in jail, August 13th, if out, August 31st, in courtroom 4A at 2:30 p.m.
All right, thank you.
Bien,
The next group's on the way up.
All right, thanks. I'm going to do a civil hearing while I'm waiting.
Yes, sir.
You're going to be forced, sadly, to be able to, you're going to hear it on the overhead. And then when the people are up, like yesterday, the people were all up and they weren't on the screen, so I didn't know you all were ready, so I kept going with my hearing.
That's okay,
So if you
yeah.
can wave or something when you have everyone up there, then I can know to speed up my hearing, okay?
Yes, sir.
Off the record, okay. So remind me to go back on the record and. Right, yeah. Thanks. And then I still have to do those two that.
Yeah, there's these two.
And hopefully this will be working today.
And Your Honor, I apologize for being a few minutes late this morning. I was downstairs with Judge Karsten and had
I was
witnesses.
told that it was not an issue.
So,
See, my clerk didn't admit everyone into the room. All right, sorry to keep you all waiting. This is case number 2019 CA 3715. If there's, my clerk before we begin if there's a court reporter, needs the name of the court reporter and then the agency that the court reporter works for. So if there's a court reporter, can you just give us that information? I'm not hearing anyone identify themselves as a court reporter, either by the phone number or based upon anyone waving their hand or whatnot. All right, so can I have the names of the attorneys first for the plaintiff, please? All right, thank you. Any other attorneys for the plaintiff?
No, sir.
All right, for the defense?
Yes, Your Honor, Judge.
All right, thank you. Sometimes we get a little bit of feedback if you have your microphone unmuted when you're not speaking. So I'll try to remember to do that myself, to mute and unmute myself. Okay, and then for the, any other defense counsel before I hear from the intervener? Not hearing anything? All right, counsel.
Your Honor, this is Jennifer Haynes for Raven Painting and Custom Design.
All right, thank you. Before I hear from counsel for the intervener, any other attorney on the phone or video?
Good morning, Your Honor. Elizabeth Stelias, or good afternoon. Elizabeth Stelias for Carpenters.
All right, thank you. Anyone else other than the intervener? Not hearing anything? All right, counsel for the intervener, your name and who you represent.
Sure. Greg Grossman, I represent Brighton Landings Homeowners Association.
All right, and so we're here on your motion to intervene, so I'll let you go first, and then I will hear for the other counsel.
Sure. So I sent some of these authorities to Your Honor, but obviously Florida Rule Civil Procedure 1.230 says anyone claiming an interest in pending litigation can be permitted to assert a right of intervention. A little bit of background. This is a construction defect case with regards to improperly installed stucco and among a litany of other things. I represent the homeowners association that this property is situated in, and the homeowners association is responsible for enforcing covenants, restrictions, rules, regarding the aesthetics of the property. The main reason why is because they are charged with ultimately protecting the aesthetics of the property as well as the property values. There are several homes throughout this community that are having issues, or I'll say alleged issues, with the construction defects, some of which are in litigation, some of which are not, some of which are represented, some of which are not. And of course, the association has to uniformly enforce these restrictions. There's several options with regard to this. They can take self-help and fix it and build a homeowner. They can assess the homeowner after some pre-suit measures, file a lien and foreclose. They can suspend use rights on down the line. And so the way the dance has sort of been going is my client's doing their normal enforcement. If one of these, I'll call them D.R. Horton cases, pops up, we get a letter from plaintiff's counsel saying, hey, don't do enforcement because there's litigation. And in this particular case, Ms. Rodriguez received a 14-day notice, an opportunity for hearing back in January saying, hey, the exterior of your home is in violation if you want to be heard, and they got a letter back. So my client's kind of between a rock and a hard place where they either have to choose to selectively enforce the covenants, or because there's litigation, there's evidentiary issues at play that they don't want to run afoul of, or they run afoul of those evidentiary issues and get hauled in front of Your Honor kind of on an ad hoc basis. And then do that and just proceed, and eventually someone's going to have to file a motion anyways, we would come and intervene. I reviewed the response and opposition. It doesn't appear that there's an argument that the intervention's untimely in any way. One of the bases for the opposition is that, and I'm quoting, this matter does not involve any issues of common interest to all members of the Brighton Landings Homeowners Association. And that's just not the case. The whole point is my client cannot have a group group of cases they're not enforcing, and a group of cases they are. Otherwise, they're subject to affirmative claims for selective enforcement or defenses against enforcement, saying, well, you're not enforcing it the same way with everybody. The response also says that Brighton Hill Landings won't gain or lose by the disposition of this case. Now, ultimately, Your Honor, where I think we get a workable situation is the association is able to proceed with their enforcement, not the self-help, because again, there's evidentiary issues that I don't want my client responsible for removing or exfoliating. They get to the point of a fine and or a lien and attorney's fees, and then they're in a position where they can sort of sit and wait, and that will produce two things. If the plaintiff wins and the defect that's cited in the notice is adjudicated to have been caused by the construction defect, then the plaintiff gets the benefit of getting all of their damages crystallized and paid off. And it also will potentially get my client out or a seat at the table of mediation just to sit and say, look, guys, here's the other claim that she's looking at. If this case doesn't settle or doesn't take this into account, and if they do take it into account, well, then the homeowner gets not only the settlement of their construction defect case, but they get all of the association enforcement wrapped into that, and I don't believe that would be prejudicial. I believe that the opposite would be prejudicial to have Ms. Rodriguez complete her claim one way or the other, settlement or trial, and then get a letter from me. I think it would be more prejudicial to have my client proceed with a lien foreclosure that could root out all of these issues from Ms. Rodriguez if my client takes title and then intervenes. I provided Your Honor with some case law, but long story short is the interest of my client does not have to be the entire interest of the case. I would tend to agree that I'm not going to be going to depositions and adding new issues and claims and defenses. It's more like the Union Central Florida Supreme Court case where an insurer has their claim to these proceeds of settlement or verdict crystallized, and what they're allowed to do is basically sit there, and until it becomes relevant, they sit quietly. In this case, it would be something like this. If 8 months or a year goes by and there's no action on the case, and now my client's statute of limitations is taken away, maybe I can call case management and say, Judge, can we move this along because I don't want my claim to be expired. Also, again, if we can crystallize our damages and claim against Ms. Rodriguez, and then in mediation say, hey, any settlement we think should include these items, not, if D.R. Horton or whoever is going to agree to pay, and that will then remove my client from this catch-22 they're in, where they're either going to run afoul of Your Honor's administration of this case or run afoul of their own allegations, where if someone asks, we can say, we've intervened in the cases, we're protecting the association's rights, and then the other cases are going to proceed as normal. And so, again, I think there's absolutely an interest in the case that's sufficient to warrant intervention, and Your Honor's, unfortunately, Your Honor's job is to kind of tailor these competing interests. But I think that that's what should be done.
So let me ask you this. If you sent the letter to the homeowner and the plaintiff's counsel said, hey,
You're on me, but I couldn't hear you. Okay.
Yeah, I forgot I was. So if you sent the letter to the this is about the selective enforcement issue. If you sent the letter to the homeowner and the plaintiff asked you to hold off, and you had that in your file, how does that allow someone later to claim there was a selective enforcement when you started the process exactly the same, and the only reason you're holding off is because you have this letter based upon a pending court case? I don't see how that allows someone to claim a selective enforcement when you're starting the process exactly the same, and the only reason you held off is you had a letter asking to hold off pending a case.
Yeah, I think the reason is that, especially in terms of the fines and the liens and the foreclosure process, more so than the abatement or the self-help, as I call it, there's no legal obligation to hold off on that process. And however, my contention is that if we push forward, we're going to end up in front of Your Honor anyways, because plaintiff's counsel is not going to want the interest in the home to be removed, or the plaintiff's in a position where she's got to defend that case and take this case. I just think it's an easier, less prejudicial situation for everybody to tie it all together and let us kind of sit on the sidelines and just make sure statute of limitations issues aren't going to come up. Everybody's advised of what I'll call them damages we're seeking under the statute and the governing documents, and then it can all be taken care of at the same time versus, so that, I don't know if that answers your question, but it's more so I don't have a good legal basis to say just because someone tells me they have a construction defect case, I have to hold off. But if Your Honor says we can intervene, we can protect our interests in such and such a way, then I think I have great grounds to say to a homeowner, look, we've essentially run it up the flagpole, this is what we're doing, this is what the court requires.
All right, thank you. Now, before I hear from the defense, obviously there was an objection and there was a joinder. Is there any defense that wants to say something that's not included in the written documentation? And if so, I'll let the plaintiff go first, and then you can call out the other parties so that we have an orderly process here.
Yes, Your Honor, Bill O'Brien, on behalf of Ms. Rodriguez, we did join in the objection that was filed by D.R. Horton. Obviously, I would reiterate all that Ms. Davis will ultimately argue as well. But a couple of things I did want to point out, or at least convey to the court. And, you know, we hear from Mr. Grossman wanting to crystallize the HOA damages. I'm not sure what their damages are. My understanding, there's not a lien that hasn't been applied. There's been no action. And I just don't see, you know, they don't have any responsibility for the routine maintenance of the home. I mean, if they want to come in and remove all the stucco and replace it, repaint the house and take an assignment, and then they can pursue DR for it, that's fine. But that's not what I'm getting from Mr. Grossman. And they're stating that they don't want to make it more difficult or more laborious for the parties to resolve their suit. Well, they've already done so by incurring significant legal fees for all parties involved by bringing this motion. And my question would be, you know, they want a seat at the table mediating. Fine, are they going to pay for their share of the mediator's cost? Are they going to pay for a pro rata share of all the depositions in the case? I don't see that they've shown good cause to be joined into this matter. And I would ask the court to deny the motion and we'll turn it over to Ms. Davis for D.R. Horton.
Yes, Your Honor. Basically, our objection comes down to 2 points, but in direct response to Mr. Grossman, I would basically say that this case has nothing to do with any fines, you know, foreclosures or lien rulings. Ms. Rodriguez, whatever actions that the association may want to take against Ms. Rodriguez directly, they have the right to do that. And as Mr. Grossman said, they can still do that at this time, regardless of their participation in this matter. But going to the 2 points, Your Honor, D.R. Horton believes that the association has no sufficient interest in this case. There's no allegations or facts that any alleged covenant violations, if they exist, have anything to do with the alleged issues in this case, which is construction defects in the original construction of the house. The association will not gain or lose anything regarding the disposition of this case, because there's no issues or facts relevant that will be resolved in behalf of the association in the event that this case comes to ultimate resolution at a mediation. Your Honor, Mr. Grossman has stated that he wants to make sure all the association's restrictions and covenants are complied with. Basically, he is admitting that he wants to decide how mediation is conducted. He wants to decide how the settlement is compiled, crafted, or resolved. And, Your Honor, that is directly prejudicial to the parties in this case who actually have to deal with the real issues, which is the original construction and any alleged defects regarding this house. And so, Your Honor, we would object to the association's motion to intervene. We believe that whatever issues that the association may have with Ms. Rodriguez has nothing to do with the complaint that was filed against D.R. Horton regarding any alleged construction defects in this matter.
All right. I don't believe I saw any other joinders. Anything else from any other defense before I hear back from the moving party here? All right, not hearing anything. We're back to you, Mr. Grossman.
Thank you, Judge. Yeah, I think a lot of this is being way overblown. I how mediation is going to be conducted any more than an insurer with a subrogation right can come in and say, this is how mediation is going to be conducted. It's just a matter of protecting my client's interests. My client's interests are proceed in a way that is uniform throughout the community and that doesn't run afoul of any evidentiary or litigation guidelines. And my client's interest is in protecting the lien that they have, the encumbrance that they have, the elements of intervening in a case. One of them is if you have a lien on the property that's subject at issue. The governing documents themselves are a lien and an encumbrance on the property that relate back to the purchase of the property. Again, I'm not arguing that I have the basis or my client has the basis to bring claims, cross-examine engineers. They do have the right to protect their interests in this matter, which are that if Ms. Rodriguez gets a check for her damages in this case, and some of those damages are $1,000 lien and some attorney's fees, they should be able to protect that if it's adjudicated that these defects caused this violation. If I was sitting here and saying she refused to mow her lawn, I'd like to intervene in the construction defect case, I totally agree. That's way out in left field. This is the exterior of the home showing damages from water intrusion, and that's what's alleged in the complaint. In the complaint, it alleges that there are state and local code violations. I provided Your Honor with some governing documents just to show, for the sake of the record, that that would fall under violating the governing documents as well. And so I'm not sure why the big pushback. I know it's a little bit inconvenient, but I'm not. I think a mountain's being made out of a molehill. I just kind of want this to be in a uniform way, and when and if it gets resolved, it gets resolved. And if at trial, Ms. Davis convinces a jury or whoever convinces a jury that this didn't cause this damage, guess what? I'm out of luck. But in the event she does, we should be able to say, yeah, and there's a fine associated that clouds her title as well. I don't know why we wouldn't want to wrap all that up in the case.
All right, thank you. I understand your position, Mr. Grossman, and maybe after you get a lien on the property, you'll be back. But I'm going to deny your motion to intervene at this time.
And Your Honor, if I could, the basis for the denial would it be the party's representation that the lien foreclosure process doesn't impact anything in this case?
I agree with what was raised by the defense in their objection to you intervening, so I'll just rely upon that. All right, thank you all.
Thank you, Your Honor.
Okay. Yes, good, thank you. It's all over again. Hi there, are you William McCarthy?
Yes, sir.
All right, the allegation is, we're here for initial appearances. The purpose of the initial appearance is for me to advise you what the allegations are, and then to announce whether or not I've made a probable cause determination, and then for me to set conditions of release in the case. Up until this point in time, you've been held no bond, but you're entitled to conditions of release to allow you to get out of jail. You are not to tell me about any prior criminal history, but I'm going to hear from a representative from pretrial services about whether they believe that you have any prior criminal history, but we don't get to hear from you on that topic. Defendants are not to provide that information. There's a representative from the Public Defender's Office. I'm going to ask, did you say PD? Okay, so you do have the Public Defender's Office. Their team of lawyers have now been appointed to represent you, not just today, but also on your case. Do you understand that so far?
Yes, sir.
All right. Because the victim's not present, I am required to order some things. No contact with the victim, maintain a separate residence from the victim, don't possess any weapons or firearms, don't return to the victim's residence except for one time with law enforcement to collect your belongings. You'd contact law enforcement first, and the law enforcement would meet you away from the property and then go with you to the property. Do you understand all of that?
Yes, sir.
Okay. So now my question here is for pretrial services. Any prior criminal history, of any?
Yes, Your Honor, he has 62 priors dating back to 1984, multiple burglaries, drug charges, assault charges. He's had 7 prison terms, 1985, with the most recent being released in November 2019.
When he was released from prison, he wasn't put on probation or anything like that, correct? Or at least there is no probation right now.
Correct. He is currently out on bond out of an Indian River County case for possession of paraphernalia.
And there's no way that this case, as far as at least the charge, looks like it would make him a prison releasee reoffender or anything like that. Right, am I read that correctly?
Because it's a misdemeanor, that's correct, Your Honor.
Okay, yeah. So, all right, so your bond in this case is gonna be $2,500 plus pretrial release with those conditions that I mentioned. Do you understand?
Yes, sir.
But if you've,
Could I ask it, just, could I be sentenced the day before, sir?
well, if you can get a little bit closer to the microphone, and they just told me I can't add pretrial release based upon the, some things.
Okay, I was wondering, could you just sentence me on it today?
Sentence you on it today. Well, it is a misdemeanor case, and the only way that I could possibly sentence you to a misdemeanor without the victim present is to actually give you the maximum penalty. So why would anyone take the maximum penalty when they could set it for a future date and potentially have something much less? See, victims have the right to be present and heard before someone is sentenced. And although they might be advised that they have initial appearances here and that you have the right to enter a plea to a misdemeanor at initial appearances, no one's thinking anyone's pleading to potentially up to a year in jail. Do you understand all of that?
Yes, sir.
You don't really want a year in jail today, do you?
No.
Okay, good. I'm just making sure.
Okay.
All right, so you have conditions of release. You don't have to post bond. You can stay in jail. The clerk's going to tell you your next court date. Actually, let's find out.
Next court date, if still in jail, August 13th. If out, September 11th, in courtroom 4E at 8:30 a.m.
All right, so next week is your next court date, right? And so we'll just put on the paperwork that you're interested in, you might be interested in entering a plea, so the state knows to talk to the victim and let the victim know that you might want to enter a plea and be sentenced on that day, so there'll be no surprise. Got it?
Yes, sir.
That doesn't mean you have to. You don't have to take any plea. But it just at least so that it doesn't potentially get it delayed again, okay?
Yes, sir. Thank you.
All right, thank you. Next case is Ted, last name spelled Luetticke.
Your Honor, he refused at the last minute, but John Doe decided to come up.
Okay, so this gentleman, okay, let me just address the person whose name I mentioned first, and then we'll come to the gentleman next to you. All right, so on the DUI, I previously set the bond at $2,000. That'll remain set. And then I'll put reset for initial appearance if the public defender's office asks. We pointed you all yesterday. So I don't know if there's an issue that you won't want to talk to, but if he says he wants to have an IA, we'll bring him to IA. But unless you tell the clerk otherwise, we're not going to reset him.
Your Honor, just information, his excuse is he will not come to court until he talks to a public defender.
Well, there you go. That's the same, it ends up being the same thing.
Yes, sir.
All right. Yeah, exactly. Okay. Sir, your name, please.
Isaac?
Okay. How about, let's try it this way. And deputy, is that inmate number 1239930?
That's correct, sir.
Okay. So, well, welcome back to initial appearances. The deputy has gone back, the rest of you has gone back and added the charge of providing false identification to a law enforcement officer after being lawfully detained or arrested. You're entitled to a bond in that amount. Case, what was I'm gonna ask the clerk a question. What was the bond amount that I set the other day?
You actually ROR'd him because he was going to be Baker Act.
Baker acted, okay. Is the jail still trying to Baker Act him?
Being that we don't know his actual identity, we really need to wait until something comes back from the sheriff's office to confirm who he actually is.
But didn't we have that the other day? Right, okay. Well, the jail's never gonna release him until they know who he is, right? Isn't that how the law works?
Right.
Okay. So I could say, once his identification is determined, ROR to be Baker Act, and that would work? Okay. All right, do you understand all of that?
Not really, sir, but,
Now, ultimately, it looks like once they figure out who you are, you're going to be released without having to post any money.
okay,
But they'll likely take you over to the hospital to have an evaluation to make sure you're not a danger to yourself or others.
they told me at the hospital I was supposed to go to another hospital instead of coming to jail.
I don't have any control over that.
And, I don't know how you guys don't have my actual identity, but they did a finger scan on me when they, detained me.
Sometimes what happens is people have to get fingerprinted, and then they've given names in different locations, and so then it's about trying to sort that out. But the jail will sort that out. Believe me, they don't want to keep you there. They prefer you be somewhere else. In fact, they're the ones who said they want to have you Baker acted. So, all right, good luck.
All right, thank you.
Thank you, Your Honor.
All right, so it looks like we got a couple more people there. So let's see.
No, sir, this is for afternoon court.
Oh, got it.
Finish
Okay.
up with our docket.
All right, so I have two more cases that apparently may have refused to come. Michael Martin.
Judge, he's in quarantine.
Michael Martin is the COVID lockdown.
All right, so no contact with the victim, maintain a separate residence, don't possess any weapons or firearms, don't return to the scene of the offense except for one time with law enforcement to collect his belongings, don't possess or consume any alcohol, and any prior criminal history. This is just going to be in the event he bonds out before coming back, but we're going to reset him when available.
He has no Florida priors. He does have history out of Maryland, and he currently is on probation for a prior domestic battery case over there. I have been in touch with his probation officer there, and as soon as he gets back, she will be issuing a warrant.
Okay, so I'll set the bond at $1,000 plus am I not allowed to have pretrial release?
Right, he does not qualify.
All right, $1,000 bond plus that, okay. Yes. Just because I had the police report the other day, so that otherwise if it had been like a different judge, I wouldn't have been able to do it. Okay, so the next case is Tyler McStutz.
He's in the hospital, Your Honor.
And he is PDA approved as well.
Okay, we'll reset when he's out of the hospital. There is probable cause to believe the offense occurred. No contact with the victim. Prior criminal history, if any?
He has no prior convictions. He had a marijuana arrest in 2015, which was a notice to appear, not an arrest. And then an arrest again in 2015 for paraphernalia, cocaine, controlled substance. That was no info.
And he qualifies for pretrial release? It's because it says doesn't qualify, and then it looks like it was crossed out.
Yeah, it appears that he does qualify. I'm not sure why that was written there.
Okay, so the bond will be $5,000 plus $1,000 plus pretrial release, no contact, and then no return. And, all right, reset once he's out of the hospital. Is there anyone else that we missed?
Not that I know of, sir.
All right, thank you. See you all tomorrow.
Thank you.
Right, good afternoon, Osceola County. We have a couple cases on our docket this afternoon. First is Dante Wells. I'm going to include.
Your Honor?
Yes?
We had two different judges scheduled at the same time.
Right.
So we're just now finishing up with the first appearance.
Okay.
So give us a few minutes and we'll have your people brought up.
Yeah, not a problem. I have Dante Wells, Austin Spencer, and Jerry Fulton as the inmates I need to see. Then it's going to switch over to Judge Whitehead.
Yes, sir. That's two different sides. So you want the Dante Wells first?
Yes, please.
Yes, sir.
Thank you. All right, good afternoon, officer. Thank you.
Yes, sir.
We have Mr. Wells. All right, Mr. Wells, give me just a moment. I'm going to include your attorney. He's been patiently waiting. Ms. Perez, can you hear me?
Yes, sir.
All right. We have Mr. Wells at the podium. He's at the Osceola County Jail. We have Mr. Tagdiri present. This is a request to quash the capias and set aside the bond forfeiture. Mr. Wells was before the court, as I recall, in person, was provided with a copy of his VOP status hearing on July 29th. He indicated to the court that he'd be hiring you, Ms. Perez. We didn't see a notice of appearance until after he failed to appear on the 29th. Court is in receipt of a number of medical documents that were apparently obtained by the defendant. And Mr. Tagdiri, have you received a copy of the medical documentation? All right, thank you. Ms. Perez, do you wish to be heard as to your request to set aside the capias and bond forfeiture?
Yes, Your Honor. Thank you. First and foremost, Judge, Deontay Wells, I represented him on the underlying matter, and so I have been his attorney throughout this his probation period. I did attempted to file a motion to terminate probation early back in I want to say it was July of 2019. I emailed his probation officer because he had met that halfway requirement and had not violated. But I never got a response from Mr. Parsons, and we sort of let that go. Nonetheless, we ended up here in this situation. Mr. Wells did advise me he was going to retain me, but I had not been retained at the time he was arrested on this warrant. But I did speak to him, and apparently you do have the correct information. He did receive notice that he had to be in court. It looks like he was in an accident on July 26th, and based on my conversations with Mr. Wells, I mean, this was unintentional. They put him on 3 days arrest, medication, and just overlooked it. And I believe that once he realized he had missed it, he came out to the courthouse. So he wasn't picked up on the warrant. He actually came in, attempting to reschedule the status hearing, and he was arrested as the court had already issued the warrant. So that's that. Number two, as far as the motion to quash capias, now going back, because it's been a while since I did one of these, I did go back to Rule 3.131C, and I don't believe that the court could quash the capias and set aside the bond forfeiture, only because you issued the warrant and now it's been days later. So at this point, I did in the title of my motion say, or in the alternative. So I think at this point, Your Honor, you do have discretion. It won't be the same bond. You would have to set new bonds. And so just based on the information I did receive from Mr. Wells, the medical records supporting the fact that he was in an accident, was given medication and 3 days arrest, the fact that he was not picked up and turned himself into the court once he realized he had missed court, I think the court can still set a new bond. I did speak to the state, and the state had no objection. Now, if you'd like me to take testimony from Mr. Wells, I'm more than happy to do that. But in a nutshell, that's what happened in this particular case. And I think that based on the case law, we have case law out of the 50 CA Hodgin versus State 263, 730, 132. In this case, we're just entitled to a hearing, and the judge could exercise this discretion. I think that based on the fact that it wasn't really a willful or intentional failure, and I think the fact that he's never missed court even prior to being on probation, and the fact that he turned himself in, I think the case law suggests that would be grounds for the court to issue a bond if you so will to. But would you like me to put on testimony? It's a little difficult because I don't see him, but I'm willing to do that as well, Judge.
Let me get the state's position. State?
There's no objection to setting.
Oh, and I believe the state had no objection to setting a new bond.
All right. I was a little unclear from the motion as to whether it was being alleged that Mr. Wells was medically unable to come to court, or whether he's just indicating that with everything going on, he lost track of a court date. I didn't see anything in the in the medical records that indicated he was medically unable. It looked like it was a back spasm. It's indicated with no trauma. Mr. Wells, if you're telling me you just had a bunch going on and
Yes, sir. But in the crash, when I got hit from behind, it broke my phone. So I was like, I was like still like, I was thinking my court date was on the 31st, but I really didn't know. That's why I went to the courthouse as soon as I can get, because I don't have a car, so I had to get a ride. So I went to the courthouse as soon as I could, and just to see, I haven't like, I think I was supposed to go to court one of these days. I'm pretty sure it's the 31st, and then she told me it was the 29th. So I'm like, okay, can I stay here and get it fixed? Like, I'm trying to get everything fixed, because I would never miss court, ever. Like,
All right, Mr. Wells. I'm inclined to grant you a bond on 2015 CF 3142 and 2015 CF 3139. Were there multiple counts, or are they both?
No, I believe there's one count on each case.
Right. Court's going to set bond the amount of $500 as to each count, each case. That's going to be $1,000 total for both of the cases. Mr. Wells, I appreciate your candor, and if you just blew a court date, I don't see any history of blowing court dates. I also don't have any objection from the state, so I'm inclined to grant you a bond, but I did need to.
Can I please say one thing, sir?
Yes, sir.
Sir, I really appreciate you, sir, and like, I promise you I will never miss no court date, no meeting or nothing, sir.
Well, I'm taking you at face value, so I'm going to give you a new court date again here in person, so we don't have any misunderstanding as to when you need to be back.
Has court set for 9/1 for VIP status.
All right.
I'm gonna change it.
We have a status date at courthouse on September 1st at 9 o'clock.
Yes, sir.
I'm going to provide that to Ms. Perez. I've told you here in open court, should be on your paperwork. And she has confirmed that she's got the date, so we'll see you on September 1st at 9 o'clock. Hopefully you can bond out and be out of custody by that point. Good luck to you.
I appreciate it, Judge.
All right. Is he still on probation? Does he need to report?
Yes,
Yes, he's still on probation.
All right. Check in with your probation officer within 24 hours of your release.
Yes, sir. Thank you, sir.
All right.
Thank you.
Thanks, Mr. President.
The other 1015 to be up here shortly, Your Honor.
Thank you very much, officer.
Judge, there's another ASA covering the 245 bond hearings. Do you want me to call her up now? Or?
Yeah, sure.
Okay.
I think that the PDs had agreed to try and take it early so we can get the handoff over to Judge Whitehead. Thanks. I'm going to disconnect.
And that's all I have, Judge. Can I be excused?
Of course. Thanks for joining us, Mr. Teggear. Thanks for your patience. I do not know. I'm covering this for Judge Wooten, so I anticipate that the PDs might be here in person. I haven't got any alternate indication. I'm going to join the afternoon docket though, and maybe I'll join that way. He's coming down outside. They weren't kidding about that severe storm. Yeah, man. Holy cow. Airport's over there somewhere, huh? Good afternoon, officer. Thank you.
Yes, sir.
All right, sir, your name, please?
Austin Spencer.
Thanks, Mr. Spencer. Mr. Spencer, we're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Good afternoon, counsel.
Good afternoon, Your Honor. Donald Carbone on behalf of Mr. Austin Spencer in 20 CF 1114.
Thank you, Mr. Carbone. And state?
Anna Olvera on behalf of the state.
Thanks, Mr. Jones. All right, we are here, Mr. Spencer, on your request for the court to set a bond in your case. I understand that it is alleged that you picked up a new charge in 20 CF 1757. They granted you bond on that case, but revoked your bond in Judge Wooten's case. I'm covering for Judge Wooten this afternoon. Care to present evidence or testimony, Mr. Carbone?
Yes, Your Honor. I'd like to start with testimony.
All right, thanks. Mr. Spencer, you've been sworn.
Mr. Spencer, how long have you lived in Osceola County?
All my life.
And how old are you?
26.
Yeah. You have family that lives in Osceola County?
Yes, sir.
And who are they?
Sarah Green, my wife, and my kids, and my dad and my mom.
And they all reside in Osceola County?
Yes.
How many kids do you have?
4.
And what are their ages?
7, 5, 4, and a newborn.
And how many children do you have with Sarah Green?
Huh?
How many children do you have with Sarah Green?
I have 1.
One, okay. Are you the sole?
Yes. Sole provider? Yes.
Okay. And would you have a job if you were released?
Yes.
Okay. What would you be doing?
Running heavy equipment.
Okay. And how many hours per week?
Probably 60. Depending on the rain.
And you promised to show up with all court dates, correct?
Yes.
Okay. And you're not going to pick up another charge?
No.
I have no further questions, Your Honor.
Thank you. State?
No questions from the state, Your Honor.
Thank you. Any additional witnesses or evidence, Mr. Carbone?
Your Honor, I was planning on proffering, but it was basically just where he would live, but it's okay.
I'll take that at face value. State, any witnesses or evidence?
No, Your Honor.
Argument?
Yes, Your Honor. I understand that the client did pick up new charges.
He's out on bond on 2 cases, right? Is there a misdemeanor case too? Maybe that's...
20 MM 40.
I did not know that.
4-0?
40, yes, Your Honor.
That was a misdemeanor allegation of possessing drug paraphernalia. The date of arrest was on January 1, 2020. Let's see what was going on. Information was filed in February. He'd been bouncing along, waiting for his trial date. I believe he's got a no bond also in 2020 MM40, but I'm not sure that that's filed in that court file. Any additional information other than the family information?
No, Your Honor. They are nonviolent crimes. I understand, that he's not entitled to a bond now that he has committed a new law offense. But Your Honor, these are nonviolent drug offenses. He would have a job. He has, 4 children under 10. I don't think jail is the best place for him. It's not like he would just be out on the street. He does have a solid residence to return back to. He just wants to get back to work. School's starting now with his kids. And he just wishes to, litigate this on the outside. I think he is interested in fleeing. But at this time, we'd ask for a bond to be set. I know the motion was only filed in 20 CF 1114, but I'd also ask for it to be set on 20 MM 40.
Yes, Your Honor. Anna Olvera on behalf of the state. At this time, the state would just like to point out that although the defendant is entitled to a bond, we do have a great concern that because he does keep picking up possession charges, the state would just argue that he be held with no bond pending these cases.
You have a score sheet on Mr. Spencer?
On my naval today scored, I had 10-15.
You can get one, Your Honor.
Not two. Fulton, only have one. Jerry Fulton, out of 102.
I apologize, Your Honor. I don't have an updated one. The last one was from 2019.
All right, thanks. What was on the score sheet in 2019?
For case number 2019 CF 1601, the score sheet shows he scored 16.4 points. And yeah, he didn't score DOC or
Prior history?
prior history. Just a petty theft in case number 2012 MM 281.
That was it. What was the felony allegation?
On the case on 2019 CF 1601, we have a possession of drug paraphernalia and again a possession of methamphetamine.
Okay. Spencer, court is faced with the unfortunate situation of you being out on bond on a felony case. I do have probable cause to believe that you have again violated the law with a new felony allegation. You are also out on bond on a misdemeanor case. While those are certainly non-violent, it appears that you have a unmitigated substance abuse issue, which is causing the court some concern. I don't believe that any lesser conditions of bond are going to have you live within the bounds of the law. So the court is not going to revisit the decision that's already been made to revoke your bond, in this case 2020 CF 1114. If you can work out a resolution that's acceptable to all parties, and I would suspect that'll have some substance abuse treatment included in it, you can go back before Judge Wooten. Do we have new dates or?
He has a pre-trial date already set for September 2nd and a trial date of September 14th.
You're going to be in front of Judge Wooten on September 2nd at the latest, and your attorney, Mr. Carbone, will know how to get you in front of him before then if there's an offer that's acceptable to you. Thank you. That's going to conclude our hearing.
Thank you.
Jerry Fulton. Good afternoon, Mr. Fulton. Mr. Fulton, we're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Mr. Fulton, you are here based on the request to have the court consider a reduction of your bail bond. I'll note for the record, looked like a 3-count information you already had, or a 3-count arrest. Has an information been filed, State? Looks like you already had bonds. Just a quick look of the case file looked like bonds in the total amount of $2,650. So I assume that would be $2,000 on one count, $500 on another, and $150 on the third. Mr. Carbone, do you care to present any witness or testimony?
Just brief testimony, Your Honor. It was outlined in the motion.
Thanks. Mr. Fulton, you're under oath.
Mr. Fulton, how long have you lived in Osceola County?
I've lived here 30 years.
And what do you do for a living as a job?
Construction.
Okay.
I'm a carpenter in Melbourne.
Okay. And where do you live?
6805 Chad Jason Road, St. Cloud, Florida.
And you own that property, correct?
Since 2015, my mom left it to me. I've lived there, was raised there.
Okay. And you have property like a vehicle and a camper that you'd be able to post to a bondsman, correct?
Yes, sir. I have a 38-foot RV and I have a pickup truck.
How much bond can you afford total?
I'm not sure. Yeah, I've been in here since May 14th, so I really don't know if I have my job. I have a lady that will do my bond, but I have a failure to appear while I was incarcerated, so no bondsman will touch me right now. And that was on a driving on suspended, and I've already went to court over that and got time served. But the failure to appear, I was incarcerated.
So other than that failure to appear, have you ever failed to appear in any other court case?
No, sir.
Have you ever been arrested before this case?
Yes, 10 years ago.
And you have no intent on leaving the county, correct?
No, sir. I just want to get home to my son. I'm a single father.
Okay. And you're the sole provider and caretaker of that child, correct?
Yes, sir.
And you're worried about school starting?
Yeah, school starts Monday.
Okay.
On the 10th.
And so could you afford a total of $1,500? The 150?
Maybe, yes, sir.
Okay. And you promised to have, you certify that you'll have constant communication with me, correct?
Yes, sir.
I have no further questions.
State, any questions?
No questions from the state, Your Honor.
Thank you. Additional witnesses or evidence?
No, Your Honor, just argument.
Ready?
Your Honor, it's kind of simple. He does have a bond. We just asked for it to be reduced to a total of $1,500. He says he has money in a safe. Based on our previous conversations, he just has to, be able to convince a bonds person. And I guess the person on the outside, the woman, only has, only around $200 total to bond him out. Mr. Fulton lives here. He has property here that was left to him. He lives on the way east side of the county, and he often travels to Melbourne. He is self-employed, and so he has every reason to be on the outside, work his job, care for his child, and litigate this case. Mr. Fulton does wish to litigate his case and doesn't wish to take a plea just because he's incarcerated.
Thanks, Mr. Carbone. State, argument?
Yes, Your Honor. The state has no objection to the bond being reduced to the $1,500.
Court's going to set bond on count one, the amount of $850 will remain $500 as to count two. Count three will remain $150.
Thank you, Your Honor.
All right, Mr. Fulton, reduce your bonds down to $1,500, so hopefully that'll assist you. Please comply with all the conditions of bond and stay in contact with your attorney. Good luck.
All right, thank you, sir.
Thank you. All right, officer, that will conclude our docket. I think we're going to switch the feed over to Judge Whitehead in courtroom 5F, so you can get his guys ready to go.
Yes, sir. Thank you.
Thank you for your help today.
You betcha.
All right, this courtroom will be in recess.